Okay, so today I wanted to touch upon a important question on the prelims paper. Class, I'm taking a look at all your suggestions and I'm working accordingly. जो जो मुझे लग रहा है कि हम क्लास में कवर कर सकते हैं आपके जो पॉइंट्स हैं, I'm taking a look at them. Right? Be mindful of the fact that I'm reading whatever you're writing in terms of your suggestions to what should be taken up by us. I will, let's say, take a look at a few things that I feel are important from the prelims perspective. Let me see, for example, if I can take a look at the concept of constitutionalism. Now, see, if you take a look at the prelims paper, what I'm going to deal with right now, मतलब जो अभी आपके सामने हम concept रख, the concept that we're keeping in front of you, the concept of constitutionalism. This is possibly a very what you can say. This is possibly an increasingly relevant subject in the prelims. हर बार आप देखते हैं in the prelims examination, at least since 2017, 18 till 2023, every year you get one question from this particular part. Every year you get one question. ठीक है, तो आप ये मान के चलिए कि अभी हम जो अगले 10 मिनट में the topic that we're going to cover in the next 10 minutes is certainly going to be addressed in such a way that there is at least one question coming in the prelims examination from it this year. हर बार एक प्रश्न आता है इससे prelims के examination में. So we're going to take a look at a very simple understanding of the topic of constitutionalism, and also associated with it is a concept called constitutional morality, which has been a part of the examination, but the main examination GS paper number 2 mein, in GS paper number 2 in the year 2021, this was the first question that was asked by the UPSC on constitutional morality. Since it is becoming a reference framework for the questions in the GS paper number 2 main examination, we might as well take a little bit of an understanding of these things in a kind of a prelims based idea. ठीक है, तो आज हम थोड़ा सा I'm going to focus a little bit on this part which is going to be under the static part. जो static part में मुझे लगता है कि questions आ सकते हैं आपके, उस पर मैं थोड़ा सा ध्यान देके इस बार बताऊंगा कि कौन से questions आ सकते हैं, and generally questions which have a conceptual underground. Right? We're taking a look at what are questions which are generally based upon certain conceptual ideas. जो घुमाने फिराने वाले प्रश्न कॉन्सेप्ट से आते हैं यूपीएस कॉन्स्टिट्यूशन ऑफ इंडिया में जो चीजें लिखी हुई हैं वहां से थोड़ा सा हम देखना शुरू करेंगे. राइट, सो द फर्स्ट थिंग दैट वी आर गोइंग टू डील विद इज अ कॉन्सेप्ट ऑफ कॉन्स्टिट्यूशनलिज्म. राइट, so when we for example take a look at constitutionalism as an idea, okay, matlab basically if we take a look at this understanding, what is the, let's say, essence of the constitution? Now this is exactly the kind of question that came in the prelims examination last year. Every year you find one question from this part. ये तो बिल्कुल सेट ट्रेंड है, आपका एक क्वेश्चन तो यहीं से हो जाएगा जो हम अभी करेंगे, इसको ध्यान से करिएगा. What is the essence of a constitution? The essential feature of a constitution, a main objective of a constitution. What is the reason for the constitution's existence? Okay, what is the way in which constitution works? Now, the way that, for example, you have to understand the concept of constitutionalism, or the way that the constitution works, is basically you have to understand, for example, that if you take a look at, for example, the term state, and the people. And this in a way can be the what you can call equation within the constitution. A constitution is an agreement between the people and the state. Right, state is the governing and the ruling authority of a society, and people are the members of the society. And when the people of a society and the state, they come into a kind of an agreement with each other about how the rules and laws and everything has to happen, that is basically what is called a constitution. Okay, now for example, let's say if I take a look at the what you can call British model of constitutionalism, which is what you can call the common law model of constitution, the constitution that we are most heavily influenced by, which is the British Constitution. Then the fact is that the state in the British context was always represented by the monarch, right? The King of England represented the state. And in a way, what I basically mean to say is that the King of England represented the executive branch of the government, right? The monarchy, the executive agency, the king was the one who was representing the state. Okay. And then when the evolution happens in the British common law tradition and the British political history, it is the people of the country which come together and form a parliament. Okay, so always you have, for example, the executive organs of a state which were represented by the monarchies, the kings, etc., etc., were the initial organs of the state. There was no democracy. There was only monarchy, a kind of a ancestral monarchy in which the hierarchy of people coming from a particular family or a generation were given the power of the state, the monarchies, right? The evolution of the political theory in Britain was supposed to be the fact that you had, for example, the creation of the people as a group who were represented and who came from the people democratically elected, and that created the composition of the parliament. Okay, and therefore it was always the equation in England was always monarchy versus the parliament, right? And monarchy had a kind of a executive power, and the parliament had the what you can call legislative power. This is how the development happened. And then later on, when the monarchy was kind of reduced down even more significantly, when the monarchs had lost their power, instead of the monarchy, you had the executive organ of the state versus the parliament of the state. So, for example, in this particular case, you will have the government, which would have all the ministries, and then on the top of this would be the prime minister. Okay, so you would have a prime minister at the top, right? He would be the, let's say, a successor of the monarch as a government, and on the other hand you would have the parliament, right? And the idea basically was that the biggest threat to people comes from the monarch. Right? The idea is that the biggest threat to the people comes from the monarch. The biggest threat to the people comes to the monarch, comes to the people from the monarch, and the protection of the people is to be done by the parliament, right? This was the basic idea that kind of developed. So if I, for example, take the executive organs of the state, which includes, for example, in our context, the prime minister and the, what you can say, the council of ministers, etc., etc. These are the executive organs of the state. And then you have the legislative organ of the state. Now, the way that you take a look at the British parliamentary system, the executive organ of the state, by the nature and the virtue of its powers, always imposes a threat upon the people, is the assumption. The assumption is that the executive, being powerful, will always have a kind of a, what you can say, uh, which will always impose a kind of a threat upon the people in terms of their power. Just the fact that you are given power, no matter how you get it, just the fact that you have power, it would necessarily mean that you would threaten the people. You will threaten the independence of the people, the liberties of the people, the rights of the people, the society as a whole. And therefore, what you understand, for example, as a parliament in the British context, is always a body which is kept against the executive, right? And the body, let's say the literature that creates this kind of a institution of how the parliament and the executive are arranged together is the constitution of the Great Britain. So it's the English constitution which has put the relationship between the executive and the legislature as one particular one. Okay, and the nature of that relationship always has this kind of a criteria, that the fact is that you have, for example, the executive power, which is a kind of an active power, right, which wants to do things, which wants to create actions, right? So this is the executive power. The nature of the executive power is to move things, to do things, to make policies, to act on the, societal things and all of that. But also what you basically see in this particular aspect very clearly is that the executive power is always, what you can say, limited by the parliament. Okay, the executive power is limited by the parliament. That's the term that you have to understand, that what the parliament does, what the parliament really does, parliament performs the functions of limiting the executive power. It is a limitation factor which is imposed upon the powers of the executive, which is the parliament, right? So basically this is what is overall wound up in a constitutional system. So when we take a look at the overall understanding of what a constitution is, if we take an overall understanding of what a constitution is or what constitutionalism means, what we get is that in a constitutional system, or constitutionalism as a point, means that the ability of the executive to act is given in the constitution, but also the actions of the executive are limited by the parliament, right? So the executive cannot act without a kind of a precursory law made by the parliament. You see the point? That's basically what we are taking a look at. So for example, let's say if I have to again think about it in a particular manner, let's say we were discussing on the other day the concept of electoral bonds, right? And we saw that, let's say for example, the union executive, the prime minister and the council of ministers, okay, this is the union executive, right? The prime minister and the council of ministers, they are the ones who wanted to create the electoral bond scheme, okay, but they could not directly create it. It is necessary for them to go to the parliament and get the parliament to make a law. Okay, I will repeat this again. It is the Prime Minister and the Council of Ministers who wanted to create the electoral bond scheme, but they could not directly do it. They had to first go to the Parliament and then create a law. And under the law, you will have certain provisions by which the executive can do it. So, for example, one law would say the State Bank of India can issue electoral bonds. So, unless the law has been authorized to issue electoral bonds for the State Bank of India, right? So, under this executive or the State Bank of India has been authorized by law to issue electoral bonds, this kind of an activity cannot happen without the permission of the law. Now, this is an example of what we call a limiting factor, that the Prime Minister and the Council of Ministers may want to do a lot of things, but for that they have to necessarily take a look at the Parliament and cannot do it without the permission of the Parliament, one way or the other, right? Similarly, for example, you have taken a look at previously, for example, if you take a look at the way that the Consolidated Fund of India has been arranged. The Consolidated Fund of India has been kept at the custody of the Parliament. Now, government wants to impose taxes upon the people of India, or government wants to withdraw the money from the Consolidated Fund of India, right? Whether it wants to send the money to the Consolidated Fund of India by taxes, or it wants to withdraw the money from the Consolidated Fund of India as a means of expenditure. All these activities the government can do, but it is the Parliament, the powers which are given to the Parliament can perform limiting functions on the government activities, right? So when we take a look at the term limit, the term limit in this context means that the Parliament's power can check the powers of the government, can in a way restrain the powers of the government, can even restrain the activities of the government, right? So for example, if a budget has to be made which is slightly preposterous and it is not, let's say, good for the nation, and if the government is hell-bent on making that kind of a budget, the Parliament can actually, under Article 113, fail the budget and not let the money come out of the Consolidated Fund of India for the government of India, right? So if I, for example, have in two very simple terms describe the concept of constitutionalism, in very, very simple terms, if I have to describe the concept of constitutionalism, अगर मैं ये बहुत आसान प्रश्न में अगर इसका उत्तर दूं कि कॉन्स्टिट्यूशनलिज्म का मतलब क्या होता है और अगर ये कॉन्स्टिट्यूशन का एसेंस क्या होता है, तो द एसेंस ऑफ द कॉन्स्टिट्यूशन इज ऑलवेज दैट द गवर्नमेंट which is known as the executive is given the power to act. Government, which is the executive, is given the power to act, right? But at the same point of time, this power for the government that is the executive has the power to act, but at the same time the power to act of the government / the executive is limited by the what you can call legislature, or you can call it the parliament. तो इसी क्वेश्चन, इसी जो हमने जो यहाँ पे डायग्राम बनाया है, इसी को अलग अलग प्रकार से पूछा जा सकता है क्वेश्चन में. इनफैक्ट यही क्वेश्चन बार बार रिपीट होकर अलग अलग शब्दावली में पूछा जाता है. आपको एक गारंटीड एक क्वेश्चन यहाँ प्रीलिम्स का भी हम करा रहे हैं यहाँ पर. In this part, as we are discussing it, it is a guarantee that one question in the prelims examination is being already taken care of right here. What we are taking and understanding over here is very clearly that what we understand by constitutionalism, or what we understand by the general concept of constitution, is that the government is limited by the parliament. ये वाला जो स्टेटमेंट है इसी को हम एसेंस बोलते हैं कॉन्स्टिट्यूशनलिज्म का. सो व्हेनेवर अ क्वेश्चन कम्स ऑन concept of constitutionalism, this is the answer that we arrive at. Okay, class, do I make sense? Whenever I ask a question about constitutionalism, the answer that I arrive at is that the government is limited by the parliament, which means that it is the parliament which exercises a limitation on the government. So generally this constitutionalism can also be talked about as the scope and limits of the government. The scope of the government and the limits of the government. And when I talk about government, I am talking about the executive organ of the state. Okay, when I talk about government, I'm talking about the executive organ of the state. Okay, do we understand this point? The fact is that the government is limited by the parliament. Okay, ठीक है. अब एक बार आपने ये समझ लिया तो let's take a look at a few previous year questions on this matter. Every year one question comes out of this. Every year, if you are paying attention to this part, I'm going to demonstrate to you how this simple understanding will always be asked as a question. ठीक है, हर साल एक question पूछा जाता है, as if the UPSC has a set formula that it asks a questions about this particular part every time. तो इससे एक क्वेश्चन तो आपका होगा ही होगा जो हमने अभी डिस्कस किया उस चीज के आसपास. Please take a look at this question number 33 in the 2023 prelims paper. Take a look at this question number 33 in the 2023 prelims paper. Please see if you can get a sense of what we are doing over here. Question number 33 in the 2033 prelims paper. With respect to Britain also, constitutionalism is the same thing. What do you think is the correct answer over this? 23 prelims paper. What is the correct answer to this question? Class, what is the correct answer here? 2023 prelims paper. Question number 33. Option number C. Exactly. It defines the limits and powers of government. ठीक है, जहां पे भी limited शब्द आएगा वही आंसर ठीक होगा. Limits and powers of the government. Right? This is what we have written right here. Scope and limits of the government, meaning the limits and the powers of the government. Okay, you see this question? This is a question which keeps repeating itself every year in one way or the other. Okay, if I take a look at question in 2022, also this question came. Just in the meantime, class, can you also take a look at this question? If you can answer this question. Question number 16. I just saw this question. See if you can just take a look at this question and answer it. Question number 16. See if you can take a look at this question and answer this. Question number 16. Which of the statements given above are correct? Can you give me a sense of what is the correct answer here? Yes, option number 1 is incorrect. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the House. No. Cannot join any political party after 6 months. We have discussed this. We discussed the whole issue of Swapan Das Gupta, and it says after 6 months of being appointed to the House. This is incorrect. The law does not provide any time frame within which the presiding officer has to decide the defection case. This is correct. So only 2 is the correct answer over here. ठीक है ना? Just a second, I'll find out the question that I was referring to here. One second. Take a look at this question number 94 in the prelims paper 2021. Take a look at this question. Question number 94 in the prelims paper 2021. 2021 paper. Question number 94 in the prelims paper 2021. Please take a look at this, class, if you can answer this. What is the correct answer to this? Constitutional government, A, B, C or D? What is the correct answer here, class, please? A government limited by the terms of the constitution. You see? So again, I am already anticipating for you one question which is going to come for your prelims examination this time. This is a question every time almost. The question that I'm asking is basically this. that when we talk about the concept of constitutionalism, this is 100% going to be on your prelims paper. You once you take the paper, when you have this question, you'll think about this class. Constitutionalism as an idea means that the actions of the government, which is also known as the union executive or the state executive, the actions of the government, which means that of the executive, are limited. The actions of the executive are limited. Okay. Now, the limitations are prescribed by the Constitution, and the limiting factor is the Parliament. That is what we want to take a look at. The limitations are prescribed by the Constitution, and the limiting factor is the Parliament. Right? If you can take a look at this sentence here, I am guaranteeing you a prelims question in 2024 from this one. The day that the question paper comes, you will find a question, guaranteed, because it is probably the most frequently repeated concept in the papers of the polity, where you have questions about the concept of constitutionalism and the actions of the government, which is the executive, that are limited. Limitations are prescribed by the Constitution, right? So you have a government limited by the terms of the Constitution, and the factor of limitation which is given is the Parliament, meaning the what you can say, the body which prescribes limitation upon the executive activities is the Parliament. Do we understand this point? That's basically what we have to take a look at in this perspective clearly, right? So this is one part that I wanted to be very clear of, that you will get a question out of, that is called constitutionalism. Okay, now let's say I will make a kind of a big chapter on one thing. I will take up, for example, the chapter of important amendments to the Constitution, and related to this chapter, which is giving the chapter of important amendments to the Constitution, I will take up the chapter of the basic structure doctrine. Okay, I'm going to give a list of amendments of the Constitution which I feel are going to be right for you to read in terms of the prelims examination historically, and also I'm going to apply the concept of the basic structure doctrine with regard to these amendments. Okay, so for example, the kind of questions that we're trying to cover in this part is a question like this. Take a look at question number 34. These are the kind of, what you can say, questions that we would like to cover up, right? You will find in every 2 years this one question in the prelims paper from the amendments to the Constitution, right? So if you take a look at question number 34, which came in the prelims paper last year, we're going to in a way model our ideas of understanding from this basic question. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of the fundamental rights? This is the question that we're going to take a look at, question number 32-4, with regard to the amendments. Okay. Okay, so this is the point that I'm going to in a way underline in terms of understanding. And also with the background of this, we're going to take a look at the basic structure doctrine, and the uh, idea of the basic structure doctrine will also help us cover another aspect of the static portion, which are the landmark judgments. The other aspect of the static portion that we can cover from this entire thing is a landmark judgment. Okay, so first of all, let's basically take a look at this categorically. If I talk about the concept of class, now please pay attention to this. We're going to go through a quick set of revision on certain things. When we talk about the chapter on amendments of the Constitution, when we talk about the chapter of amendments of the Constitution, this is given. Please take a clear note of this. Pen and paper ready. This is given under part 20 of the Constitution. That is the title, and the article which covers amendment of the Constitution is Article 368. Okay, if I write in the middle, it is Article 368 of the Constitution. All of these informations are going to be relevant in terms of being able to take a look at the prelims paper this time. We are taking a look at Article 368 of the Constitution. Okay, and under Article 368 of the Constitution, we are going to take an understanding of what are the basic amendments which are made to the Constitution. What are the ways in which amendments happen, right? So Article 368 Clause 1 talks about constituent power. Okay, Article 368 Clause 1 talks about constituent power. Article 368 Clause 2 talks about procedure for amendment. This I have, I think, completed with you previously. Article 368 Clause 3 says that, the point that I'm trying to make over here is, Article 368 Clause 3 states that an amendment made under Article 368 is not subject to judicial review under Article 13 Clause 2. This is what the part over here says. Okay, so please take a look at this. We are in a way drawing the anatomy of Article 368 of the Constitution. Class, I now invite you to focus upon this intently, because all of this is going to be a part of the prelims paper. Okay, class, are we ready with this? We are targeting questions like these. Take a look at the question number 34 on your screen and see, these are the kind of questions that we're trying to understand in terms of being able to take a look at. So we have to take a look at the list of amendments, important amendments made to the Constitution. This is very specifically given as a part of the prelims paper syllabus also. So if we take a look at the list of amendments which are given, first we'll have to take a understanding of the procedure of what you can say, the power of and the procedure of the Parliament to amend the Constitution, right? And that is given under part 20 of the Constitution, which is under the title Amendments of the Constitution. It is part 20 of the Constitution which is given the title Amendments of the Constitution, which talks about the power and the procedure of the Parliament to amend the Constitution. Okay, so first thing that I'm going to define in this one, class, let's go. First thing I'm going to define in this one is Article 368 Clause 1. Article 368 Clause 1 uses one specific term which is known as constituent power. A question can come regarding the very concept of the constituent power. So please take note of this clearly. If we take a look at, for example, the concept of a constituent power, Article 368 Clause 1 says that Parliament may, by the use of its constituent power, amend amend by way of addition, variation or repeal any provision of the Constitution. This is what you can call very simply an anatomy of Article 368 of the Constitution. Class, we're dealing with the subjects of the amendments to the Constitution. We'll take a list of the amendments to the Constitution, and in that sense, to understand the list of the amendments to the Constitution, we are going to take an understanding of Article 368 of the Constitution, which deals with the chapter of amendments. Part 20 deals with the chapter of amendments, and within part 20 you have Article 368 clause 1, clause 2 and clause 3. We're going to take a quick revision of these clauses. Article 368 clause 1, Parliament may by the use of constituent powers, right? The special powers which are vested in the Parliament to amend the Constitution are known as constituent powers, right? So you have a very clear understanding of what the term constituent power means. It means the special powers which are vested in the Parliament to amend the Constitution. These powers are known as the constituent powers. Class, I will repeat it again. The special powers which are vested in the Parliament to amend the Constitution are known as constituent powers, right? And this is what Article 368 clause 1 says. Article 368 clause 2 talks about the procedure for amending the Constitution, and this one we have taken a look at already while we were dealing with the cooperative societies, etc. So we have the procedure for amending the Constitution is given under Article 368 clause 2. Here we have taken a look at how the makers of the Constitution wanted to, in a way, create a balance between the rigid and the flexible portions of the Constitution, right? So we have already taken a look at the idea of the procedure associated with the amendment of the Constitution, so that now we will not go into. Okay, now to be able to understand the, what you can say, the chronology by which we are going to take a look at Article 368 clause 3 and the related aspects, I am going to create a kind of a list of amendments to the Constitution, list of important amendments. Class, please take a look at this very simply and categorically. I am going to create a list of important amendments of the Constitution. In the first phase, I will deal with the time period of 1950 1951 to 1980. Okay, please take a look at this. I'm going to draw the list of amendments to the Constitution, lists of amendment that can be made to the Constitution from the period of 1951 to 1980, right? And I'm going to lay out the basic features of these Constitution Amendment Acts and how these Constitution Amendment Acts have been relevant in terms of what they are offering into the Constitution. So from 1951 to 1980, we are going to take a list of the amendments made to the Constitution and what are the important features of these amendments. Okay, so please take a look at this very simply. A list of amendments made to the Constitution from 1950 to 1980. This is the first 30 years in which the Constitution has been amended the most significantly, and we are going to take a list of that, right? We are talking about first Constitution Amendment Act. Class, please take a look at this. First Constitution Amendment Act 1951. This is what we are going to take a look at. And now I'm going to describe some basic features of this. First Constitution Amendment Act was passed by the Provisional Parliament. First Constitution Amendment Act was passed by the Provisional Parliament before the first Lok Sabha elections. Okay? First Constitution Amendment Act was passed by the Provisional Parliament before the first Lok Sabha elections. Point number B. First Constitution Amendment Act added Article 31A and Article 31B into the Constitution. Added Article 31A and 31B into the Constitution. Okay, see, these articles gave the possibility for the Parliament to make laws for undertaking land reforms. Without these laws, being subjected to judicial review. On the ground that they violated fundamental rights. Please take a look at this statement very clearly. Dealing with the list of important amendments to the Constitution from 1951 to 1980, we're talking about the first Constitution Amendment Act in 1951. The first Constitution Amendment Act in 1951 talks about, point number A, it was made by the Provisional Parliament before the first Lok Sabha elections. So what basically we are taking a look at is that immediately after the commencement of the Constitution, and the Constituent Assembly, which had made the Constitution itself, had been in a way repurposed as the first Provisional Parliament. And while the first Provisional Parliament was in power, what was in action, they were preparing for the first general elections, out of which the first elected Parliament would be instituted. And during this time, when the first Provisional Parliament was there under the leadership of Jawaharlal Nehru, the Parliament passed Article 31A and Article 31B in the first Constitution Amendment Act. These were the first Constitution Amendment Acts which were made to give effect to land reforms. Land reforms, for instance, allowed the Parliament to make laws to take the land and the properties of the zamindars and the inamdars and the nayabdars, and this kind of a land reform law would not be subjected to any judicial review if it violated Article 14, Article 19 of the Constitution, or any other fundamental right for that matter. Right? So, the first Amendment Act, which created Article 31A and 31B in the Constitution, were directly indicated and instituted to target the ability of the judiciary to enforce fundamental rights and to strike down these laws on the ground that they violate fundamental rights. Article 31A and 31B are given in what is known as a savings clause under Article 31 of the Constitution. And the most important objective of these articles was to ensure that the fundamental rights, which are what you can say given by the part 3 of the Constitution, shall not come in the way of laws which are made under Article 31A and 31B of the Constitution. Right? So it was done to overcome judicial interpretations of fundamental rights, or overcome judicial applications of the fundamental rights. That was the first Constitution Amendment made in 1951. Okay, let me elaborate this further. If I take a look at, for example, point number 4 on this, Article 31A, in fact, let me take a look at this again. Article 31B Article 31B also introduced what is known as the ninth schedule to the Constitution. Okay, it was Article 31B which also introduced a ninth schedule to the Constitution. So if a question comes, which of the following amendments introduce a ninth schedule to the Constitution, the answer is First Constitution Amendment Act 1951. It is this Amendment Act which introduced the ninth schedule to the Constitution. If you have a question, for example, which Constitution Amendment Act introduces the 10th schedule, which is the anti-defection law, you know, it is the 52nd Constitution Amendment Act 1985. Class, I hope that you are taking notes of these things properly. These are going to be relevant in terms of making an understanding on these questions. Ninth schedule was added to the Constitution by the first Constitution Amendment Act, and 10th schedule was added for what is known as the 52nd Constitutional Amendment Act 1985, right? And what we are basically taking a look at is that all laws which are specified in the ninth schedule are immune from judicial review on the question of them violating any fundamental right. Do we get a sense of this, class, please? Are you taking notes of these? Ninth schedule to the Constitution was instituted in the Constitution by the first Constitution Amendment Act. It is connected with Article 31B of the Constitution. And the essence of the ninth schedule of the Constitution is that all laws which are specified in the ninth schedule are immune from judicial review on the question of them violating any fundamental right. So if any law is placed in the ninth schedule by the Parliament, then that law, once it has been placed inside the ninth schedule, shall not be called into question into any court on the ground that it is violating any fundamental right. Okay, so again let me repeat it. If the Parliament makes a law today and puts that law inside the ninth schedule by amending the Constitution, please remember that to introduce a law inside the ninth schedule, you have to amend the Constitution. Right. So if the Parliament makes any law to introduce a law into the ninth schedule of the Constitution, such a law which has been placed inside the ninth schedule shall not be questioned for judicial review if it is violating any fundamental right. So for example, let's say if the Reserve Bank of India Act, if the RPA, if the Companies Act, and if the Income Tax Act, which are creating for electoral bonds, if they are kept under the ninth schedule, then the judicial review which has been applied by the Supreme Court of India in these matters recently would not be possible, because Article 31B says that any law which is made by the Parliament and placed inside the ninth schedule shall not be subjected to any judicial review on the question whether it violates a fundamental right. That's basically the position that one takes with regard to Article 31B. So this is the first Constitution Amendment Act. Article 31A and Article 31B were instituted, and this led to the institution of the possibility that laws can be made by the Parliament which are not going to be subjected to fundamental rights. Laws can be made by the Parliament on the ground that they are not going to be subjected to fundamental rights. 31A and 31B, both of them talk about this particular aspect. Am I clear, class? Okay? Right. Now let's take a look at a quick follow-up of this. The first Constitution Amendment Act 1951 was subjected to a judicial review itself. The first Constitution Amendment Act 1951 was subjected to a judicial review itself on the basis that it violated or took away the fundamental rights, and it is subjected to judicial review under Article 13 Clause 2. In the landmark judgment of the Supreme Court, known as Shankari Prasad versus Union of India. It was a 5-judge bench judgment known as Shankari Prasad versus Union of India, in which the first Constitution Amendment Act was challenged. So the argument made was that the first Constitution Amendment Act is a law under Article 368 of the Constitution, and a law made under Article 368 of the Constitution is included under Article 13 Clause 2 of the Constitution. Okay, so Article 13 Clause 2 of the Constitution states that if any law made by the Parliament violates or takes away any fundamental rights, that law is going to be subjected to judicial review. Now, what the petitioners argued in the Shankari Prasad case was the fact that a law made by the Parliament, which is a Constitution Amendment Act under Article 368, by the insertion of Article 31A and 31B, are taking away a fundamental right. Okay, a law made by the Parliament with the insertion of Article 31A and 31B are taking away a fundamental right. They're taking away Article 14, Article 19, etc., etc. They are creating abrogations of fundamental rights, and therefore this law made by the Parliament under Article 368 of the Constitution is liable to be struck down under the application of judicial review. Again, I'll repeat, this law made by the Parliament under Article 368 is liable to be struck down under Article 13 Clause 2 because it violates fundamental rights. It takes away fundamental rights, and any law which takes away fundamental rights is subjected to judicial review under Article 13 Clause 2. A law made by the Parliament under Article 368 is a law, and therefore if this law takes away any fundamental rights or violates a fundamental rights, this law shall be subjected to judicial review and be struck down. This is what the petitioners argued before the Supreme Court in the Shankari Prasad case. Okay, the name of the case is Shankari Prasad versus Union of India. Are we clear? The judgment which was given by the court, okay, the judgment which was given by the court made the following observations. Please take a look at it very clearly. In the judgment given by the court, class, I want you to please pay attention to these terminologies very, very specifically. These are going to be part of your prelims literature. In the Shankari Prasad case, the government of India created a distinction between law and made law into two categories. The first kind of a law, the government of India called ordinary legislations. Or what are known as the ordinary legislative powers of the Parliament. Laws as they are defined under article in the Constitution are ordinary legislations and ordinary legislative powers of the Parliament. This kind of an activity emerges from Article 245 of the Constitution. It is Article 245 of the Constitution which gives the power to make laws upon subjects which are specific to the, what you can say, union list. Article 245 of the Constitution. So the Parliament of India gets its law making powers, its legislative powers from Article 245 of the Constitution. Right? That's the first part. And the second part is what is the court called constituent powers. Now we can come back to the question of constituent powers. Now let's say what we can write is constitutional law making powers. Okay, so court in these matters stated what are known as constitutional lawmaking powers. Constitutional lawmaking powers. These constitutional lawmaking powers are also what are known as constituent powers. So where the Parliament is exercising its powers which are known as the constituent powers under Article 368, It is channeling its abilities as the constituent assemblies itself. Okay. So while we are talking about ordinary powers, it is the parliament which is acting in the capacity of the parliament itself. Parliament is acting in the capacity of the parliament. Okay. But when the parliament is channeling its powers under Article 368, it is not a mere parliament, it is channeling the activities of the constituent assembly. And therefore, this is the kind of distinction that was made by the Shankari Prasad judgment on the concept of law. Law as it is defined as an ordinary legislation in which the parliament has a law making power, and constituent powers under Article 368 in which the parliament has the ability to amend the constitution. So in these cases, a parliament is not an ordinary parliament. A parliament is performing the functions of the constituent assembly of writing and rewriting or unwriting, remaking, amending the constitution. Do you see the point? And therefore the powers which are given to the parliament under Article 368 are different. Okay. And so here the Shankari Prasad case stated that the concept of law, the term law as mentioned under Article 13 clause 2 of the Constitution shall not include laws made by the parliament in application of Article 368 that are constituent constitutional amendment laws. This was the judgment which was given by the Supreme Court in the landmark case of the Shankari Prasad Deo versus Union of India. Okay, are we able to get a sense of this, class? The term law as mentioned under Article 13 clause 2 of the Constitution shall not include laws made by the parliament in application of Article 368, that is constitution amendment laws. Okay, so what kind of emerged from this as a position, was that laws made under Article 368 are not subject to judicial review under Article 13 clause 2 on the ground that they take away a fundamental right. Okay, please get a sense of what we are writing over here. Laws made under Article 368 are not subject to judicial review under Article 13 clause 2, comma, on the ground that they are take away a fundamental rights, right? So basically what the Shankari Prasad judgment said was that any kind of a constitution amendment act which has been made under Article 368 of the Constitution, for example Article 31A and 31B, you have two articles 31A and 31B alongside each other. Both these articles are enabling the parliament to make laws, and these laws made by the parliament are going to effectuate land reforms, and these laws made by the parliament which are effectuating land reforms shall not be subjected to judicial review on the ground that these laws are taking away any fundamental rights. So Article 31A and 31B, which say that fundamental rights shall not apply to activities done by the government of India and the Parliament of India in pursuit of land reforms. 31A and 31B are taking away fundamental rights. That is correct. But the question is, can 31A, 31B, which are constitution amendment acts, be subjected to a judicial review on the ground that they are taking away a fundamental right? To this question, the answer that was given by the Shankari Prasad case was the distinction that the Shankari Prasad case made in the definition of law. In the definition of law, the Shankari Prasad case stated that law can be divided into ordinary legislations and constitutional lawmaking powers. And ordinary legislations under Article 245, if they violate a fundamental right, if they take away a fundamental right, they can be subjected to judicial review. But a Constitution Amendment Act under Article 368, if it violates a fundamental right, or if it takes away a fundamental right, if Article 31A and 31B takes away a fundamental right, then that is a Constitution Amendment Act. And it is, since a Constitution Amendment Act, this kind of an act shall not be subjected to judicial review on the ground that it has broken or violated or taken away any of the fundamental rights. This was a judgment of the Supreme Court in the Shankari Prasad case. The effect of this judgment of the Supreme Court was that the Parliament was told by the Supreme Court that your powers to amend the Constitution are sacrosanct, are supreme, are non-compromisable, are non-negotiable, and any amendment made to the Constitution by the Parliament in pursuit of its power of Article 368 of the Constitution shall not be subjected to judicial review. The judiciary cannot interfere in the activities of the Parliament in amending the Constitution, stating that these are not covered under the judicial review powers of the judiciary under Article 13 Clause 2. This was a judgment, the landmark judgment, which came immediately after the first Constitution Amendment Act was passed in 1951 to challenge that Constitution Amendment Act. And the petition of that challenge was that these laws, which are Constitution Amendment Acts, should be struck down because they take away a fundamental right. Article 31A say fundamental rights are going to be switched off. Article 31B creates a 9th schedule in which all the fundamental rights are not going to apply. And these taking away of fundamental rights were challenged before the Supreme Court, stating that the definition of the term law applies to this particular article also, Article 368. Supreme Court in response gave the opposite opinion. The Supreme Court stated that the term law does not include ordinary legislation, does not include Constitution Amendment Acts. It only includes ordinary legislations made by the Parliament. So if an ordinary law which is not a Constitution Amendment Act is violating a fundamental right, then such a law can be subjected to judicial review, as we saw yesterday in the what you can call electoral bond scheme, that a law which is violating let's say certain fundamental rights can be subjected to judicial review. But if a constituent power applied Constitutional Amendment Act is violating a fundamental right, then this law cannot be subjected to that kind of an activity, is what we are taking a look at. Okay, so this was the judgment given by the Supreme Court in the Shankari Prasad case. So class, am I clear about it? We've discussed, we're taking on a list of amendments, and we're taking the concept of the first Constitution Amendment Act 1951, and in correlation to the first Constitution Amendment Act 1961, we are dealing with the landmark judgment of the Supreme Court in what is known as the Shankari Prasad case. We are taking a look at the landmark judgment of the Supreme Court into what is known as the Shankari Prasad case, Supreme Court 5-judge bench, in which the distinction was made between law which is made by the Parliament in its ordinary capacity and law which is made by the Parliament in the capacity of Constituent Assembly. So that's basically what we are going to, in a way, take a look at. Article 13 Clause 4 and Article 368 Clause 3, which were later introduced in the Constitution, in a way elaborate the same concept. Okay, so just to be a little bit sure about this, I'm going to read out a passage from the judgment given by the Supreme Court in the Shankari Prasad case. Please take a look at this part. Please take a look at this, class. This is a passage which has been given as a, as a judgment of the Shankari Prasad case, in which the distinction between law was made. Now, it is important to understand this distinction because this is still a part of the Constitution, and it is also still a part of the Constitution that judicial review under Article 13 Clause 2. does not apply to Constitution Amendment Acts because of the reasoning which is given by the Supreme Court herein. If you can understand this reasoning, then you will be able to attempt a question which is dealing with this part. Okay, this is what we mean to say over here. Chaliye. Okay, now moving forward, from first Constitution Amendment Act, we can move directly. If I take first Constitution Amendment Act, which was declared to be constitutionally valid by the Shankari Prasad case. The first Constitution Amendment Act was declared to be constitutionally valid by the Shankari Prasad case. Okay. Now the question that comes before us later on is the Shankari Prasad case, which was a 5-judge bench judgment, was challenged before another bench judgment which is known as the Golaknath case. Before an 11-judge bench. The Shankari Prasad case was challenged by the Supreme Court, or before the Supreme Court, by the petitioners to reverse the Shankari Prasad case in what is known as the Golaknath case 1967, which was known as the 11-judge bench judgment. Okay, and this 11-judge bench judgment in a way creates the context. Okay, in the Golaknath case, number 1, Shankari Prasad was reversed. The judgment that was given by the Supreme Court in Shankari Prasad was reversed. What you can say, overturned. In the Golaknath case, the judgment of the Supreme Court in Shankari Prasad was overturned. ठीक है, Shankari Prasad को हटा दिया था और यहाँ पे Supreme Court ने बात पलट दी थी. Supreme Court ने क्या कहा? Take a look at this. Article 13 Clause 2, which gives powers to the judicial review. Class, I hope that you're taking notes of these exact same terms you'll find in the prelims examination. Article 13 Clause 2, which gives powers to judicial review. देखिए, in the Golaknath case, which was an 11-judge bench judgment of the Supreme Court in the year 1967, the Shankari Prasad case, which was given under in a 5-judge bench, was challenged, and Shankari Prasad was overturned, which gives the in which the Supreme Court stated that Article 13 Clause 2 gives which gives the power to the judiciary to review any laws that take away fundamental rights also includes laws made under Article 368, right? So the conclusion of this judgment was completely opposite to the Shankari Prasad judgment, and this was sealed in its fate by 11 judges of the Supreme Court. 11 judges of the Supreme Court had come to give this conclusion, which was placed in the Golaknath case. In the Golaknath case, the conclusion that was given by the 11 judges was that any law made under Article 368, which is amending the Constitution, any law made under Article 368, which is amending the Constitution, may or can be struck down by the Supreme Court. Can be struck down by the Supreme Court if such a law takes away a fundamental right. Class, am I clear about this? This is the conclusion of the Golaknath case. So I want you to think about it in a chronology, please. You have the first Constitution Amendment Act 1951, which introduces Article 31A and 31B to the Constitution. Now, the intention of the first Constitution Amendment Act 1951, which introduces Article 31A and 31B in the Constitution, is to allow laws to be made which, if they violate fundamental rights, they cannot be subjected to a judicial challenge, to allow a kind of a free-flowing arm to the government of India to construct land reforms, and certain policies of land reforms would come in confrontation with fundamental rights of citizens. For example, at Article 14, Article 19, in 19(1)(f), at the time you also had the right to property. Okay, so these cases and situations in which you are taking a look at the laws which are made by the parliament to do land reforms, they will not be subjected to judicial challenge because they are violating fundamental rights. And this was instituted in the Constitution by Article 31A and 31B. So the challenge that was made before Shankari Prasad case is whether Article 31A and 31B, which are Constitution Amendment Acts, which are taking away fundamental rights, are they subjected to judicial review under Article 13 Clause 2? That was the question which was made by the Supreme Court before the Supreme Court in the Shankari Prasad case. And the answer to the Shankari Prasad case was negative. It said that laws which are made under Article 368 shall not be subjected to judicial review under Article 13 Clause 2 of the Constitution. That is what the Shankari Prasad case had settled out, creating a distinction between the ordinary lawmaking powers of the Parliament and the constituent powers, which are given as extraordinary special powers given to the Parliament to amend the Constitution. And when it comes to constituent powers, the Parliament has the power to make amendments to the Constitution, and when these amendments are made using the constituent powers, such amendments are not subjected to judicial review or judicial challenge on the ground that they violate fundamental right or they take away a fundamental right. This judgment of the Supreme Court in the Golaknath case was overturned, and Supreme Court in an 11-judge bench in a way reaffirmed judicial review. So अगर ऐसा कोई question आता है, which of the following judgments reaffirmed? Class, please take a look at this. If a question comes like this, what if a judgment is given by the Supreme Court, which of the following judgment is given by the Supreme Court, which has reaffirmed the judicial review powers? Which of the following judgments has been given by the Supreme Court, which has reaffirmed the judicial review powers under Article 13 Clause 2 over Constitution Amendment Acts made under Article 368? If this is a kind of a question that is coming to you, then the answer to that question is the Golaknath judgment. That is basically what we are going to take a look at from the perspective of the prelims examination. Class, am I correct? Are you guys here? Are we getting the sense of this question? If a question comes, which of the following judgments reaffirm the judicial review powers of Article 13 Clause 2, in which the judiciary said that nothing doing, no extraordinary powers are given to the parliament. The parliament is not the constituent assembly, and if the parliament is making any constitution amendment acts, it is going to be subjected to judicial review on the ground it is violating fundamental rights, which means that the power of the parliament to amend the constitution is not infinite. And if constitution amendments are going to take away fundamental rights, those constitution amendments shall be subjected to judicial review under Article 13 Clause 2. Golaknath case, 11 judges bench of the Supreme Court had established this perspective very, very clearly. Okay, so I hope that you can follow the chronology over here. We're dealing with the first Constitution Amendment Act, Shankari Prasad case, 5-judge bench, and then the decision of the first constitution, the Shankari Prasad case, was overturned in the Golaknath case, and Golaknath case within its 7 judges came to this particular finding. Am I clear, class? Class, are we here? आप लोग हैं यहाँ पर? Are you getting all of these things together, point wise point? We are going to see exactly these things in the question papers. Class, are we clear? Are we here? Do we understand this point? Golaknath judgment of the Supreme Court. In the Golaknath judgment, Supreme Court made the historical verdict saying that if a parliament is amending the constitution under Article 368, and if those amendments of the constitution are taking away a fundamental right, then those amendments can be struck down by the judiciary on the ground that they are taking away fundamental rights, because such power is given to the judiciary under Article 13 Clause 2 of the Constitution. If you want, we can take a look at Article 13 Clause 2 of the Constitution once again, which is basically talking about the concept of judicial review for laws which are violating fundamental rights. Okay, let's take a look at this once. Please take a look at this. The state shall not make any law which takes away or abridges the rights conferred by this part, rights conferred by the fundamental rights. And any law made in contravention of this clause shall, to the extent of that contravention, be void. Okay, again, are we open about it? A law which is made by the state, meaning parliament, is subject to judicial challenge if it breaks away a fundamental right. अगर किसी भी व्यक्ति का कोई मौलिक अधिकार उड़ाया जाता है किसी लॉ के द्वारा, तो उस लॉ को आप जुडिशियल रिव्यू की पावर्स के अंदर तोड़ सकते हो. प्रश्न ये है कि अगर वो लॉ कॉन्स्टिट्यूशन अमेंडमेंट एक्ट की तरह बनाया जाता है ना, अगर मतलब जो लॉ बनाने का जो माध्यम है, जो प्रक्रिया है, वो कॉन्स्टिट्यूशन अमेंडमेंट एक्ट की है. इफ द law has been made by a constitution amendment act given under Article 368, can Article 13 Clause 2 still apply? Right? In the 5 judges bench of the Supreme Court, the Supreme Court said in Shankari Prasad, no. उन्होंने कहा था कि Article 13 Clause 2 Article 368 के ऊपर बनाए हुए लॉस पे नहीं लगेगा. शंकरी प्रसाद को ओवर रूल कर दिया गोलकनाथ ने. Okay, the judgment of the Shankari Prasad was overruled by Golaknath, and in the 11 judge bench, Golaknath said yes, a law over here includes Article 368, Constitution Amendment Act include karega. A law which is made by the parliament to amend the constitution if it is taking away a fundamental right shall also be subject to judicial review. तो इसका मतलब ये है कि सुप्रीम कोर्ट के हाथ में पावर है कि अगर कोई लॉ, अगर पार्लियामेंट कोई लॉ बनाता है, पार्लियामेंट कोई संविधान में संशोधन करता है, जैसे मान के चलिए कि पार्लियामेंट ने अगर आर्टिकल 14 डिलीट कर दिया, ठीक है, अब आर्टिकल 14 को डिलीट करने की प्रक्रिया क्या है? कॉन्स्टिट्यूशन में अमेंडमेंट करना। और अगर पार्लियामेंट में आर्टिकल 368 की पावर के बाद आर्टिकल 14 को डिलीट कर दिया तो इस डिलीशन को अमेंडमेंट कहेंगे, है ना। और अब गोलकनाथ का कहना यह था कि सुप्रीम कोर्ट अगर चाहे तो इस अमेंडमेंट एक्ट को, ये जो लॉ है जिसने आर्टिकल 14 को टेक अवे कर दिया है, उसको स्ट्राइक डाउन कर सकता है और आर्टिकल 14 को रिस्टोर कर सकता है। You get the point I'm trying to make? The Parliament, if it makes a law under Article 368 stating that Article 14 of the Constitution shall be deleted, then such a law made by the Parliament under Article 368 of the Constitution shall be included in the definition of law in Article 13 Clause 2. Such a law made by the Parliament under Article 368 shall be included in the definition of law under Article 13 Clause 2, which means such a law which is deleting Article 14 of the Constitution, a law which is deleting Article 14 of the Constitution, shall be subjected to judicial challenge. And if the judiciary wants, it can strike down this law and restore Article 14, which means that the judiciary can protect the fundamental rights from being amended out of the Constitution by the laws made by the Parliament. Parliament cannot amend the Constitution to the extent that it violates or takes away fundamental rights. Am I clear about this, class? Do I make sense? Yes or no? Tell me. Class, are we here? This is the spinal cord of the Constitution of India. 2023, the year that we are preparing for the examination. The basic structure doctrine was born in the year 1973, and the basic structure doctrine in the year 2023 has completed 50 years. You know what that means for your purposes? What it means is that this kind of a 50-year anniversary makes the basic structure doctrine one of the most important points to be asked upon this time in the prelims examination. Okay? So इसीलिए I'm trying to in a way create the entire structuring of this entire part. As to the question, as you can see over here, the real question over here, if I just when I very simply derive it down, क्या पार्लियामेंट के पास पूरी तरह से संविधान को संशोधन करने की पावर है? क्या पार्लियामेंट के पास वही पावर है जो कि कॉन्स्टिट्यूएंट असेंबली के पास थी? कॉन्स्टिट्यूएंट असेंबली ने जिस प्रकार से एक ब्लैंक पेज से कॉन्स्टिट्यूशन को बनाना शुरू किया था, the way that the constituent assembly had started creating the constitution from a blank page, can the parliament, which is a successor of the constituent assembly, which is the principal body elected by the people of India, the body which is carrying the will of the people of India, can that parliament also bring down the entire constitution to a blank paper and start writing or rewriting the constitution from a blank paper onwards? These unlimited powers of the parliament to amend the constitution, this question is what is the most haunting question for the first 3 decades of post-independent Indian constitutional history. Does the parliament under Article 368 have the powers to completely write off the constitution and write a new constitution altogether? Right? Or are there any limitations to the powers of the parliament to amend the constitution? Are there certain parts of the constitution which cannot be amended by the parliament? Do we get the point? This is the basic question that we are in a way dealing with at the central point. And in this sense, what we are taking a look at is the idea that the parliament, according to the Golaknath judgment, can make an amendment under Article 368 of the Constitution, can make an amendment to take away a fundamental right, but such an amendment is going to be subjected to challenge, and the judiciary can strike down such an amendment under the powers which are given to the judiciary under Article 13 Clause 2 of the Constitution, which are the powers of judicial review on any laws which are violating or taking away a fundamental right. The Constitution Amendment Act is a law, and this kind of act is not a special kind of a law. This kind of a power of making law is not a special kind of a power. It is an ordinary legislative power. There is no special legislative power given to the parliament, and therefore, just as it is an ordinary law, Like any other ordinary law which violates or takes away a fundamental right, if a Constitution Amendment Act violates or takes away a fundamental right, then such a law is subjected to being struck down by the judiciary for the protection of fundamental rights. This is a judgment given by the Supreme Court in the Golaknath case. Am I clear, class? Okay. Now, take a look at this. As we are going from 1951 to 1965, 1967, we have a lot of things changing in the Indian society. Okay, I'm just creating a kind of a contextual background for this entire activity. As we move from 1951 to 1967, you have the Shankari Prasad case in 1951 and you have the Golaknath case in 1967. In Shankari Prasad, the Supreme Court had seen that the Constituent Assembly and the stalwarts of the Indian constitutional thinking who were part of the Constituent Assembly, they were still active. They were still elected as members of parliament and they were the one who were occupying the parliament for most past. So at this point of time, the Supreme Court did not feel it is a right to interfere in the powers of the Constituent Assembly itself, because it is exactly the same people who were sitting in the Constituent Assembly who created the Constitution. We were now sitting in the parliament. But by 1967, all these people had started retiring or dying, and a kind of a new generation of parliamentarians had started coming in. And these new generations of parliamentarians were not looked at by the Supreme Court with the same kind of a confidence as the Supreme Court looked at the Constituent Assembly, right? So, for example, 1964, Indira Gandhi becomes the member of Rajya Sabha, indicating the flush of new generations of politicians in the parliament who were representing the will of the people. So a generational change was coming in Indian politics and Indian demography. And here the Supreme Court in a way tightened its position and it made sure that these new politicians sitting inside the parliament cannot amend the constitution according to their own will, vetoing the will of the Constituent Assembly over here. So Supreme Court gave the Golaknath judgment that if any constitution amendment is made which takes away a fundamental right of the which takes away a fundamental right which is given under part 3 of the constitution, then that can be struck down. Okay. Now, in 1971, India went through general elections. And in 1971, you had a great year for Mrs. Indira Gandhi. She had won the general elections with a thumping majority. And there was the great battle between India and Pakistan, which was the creation of the state of Bangladesh, right? India, Pakistan. Indira Gandhi was at the helm of affairs in this particular matter. She was the one who was deciding upon all the foreign policy decisions which had to be taken in the consequence and the subsequence of this kind of a foreign policy affair, right? And in 1971, Indira Gandhi was at the peak of her power. That was her year in terms of her superiority and her height and her, charisma. And the entire country had posed their faith in the figure of Indira Gandhi. She emerged as the great prime ministerial candidate and the leader of the people of India. And the entire parliament was mostly the Indian National Congress being voted inside the parliament because of the stature and the figure and the poise of Mrs. Indira Gandhi. Mrs. Indira Gandhi wanted to create very clear policies for India. She wanted a very clear understanding of nationalization, right? She wanted to do nationalization. She wanted to abolish privy purses. She had a very radical understanding of land reforms. She had no faith in private enterprises or private capitalistic greed, and she was inclining towards socialism, which is that all the production in the state shall be undertaken by the state entities. All production in the state shall be undertaken by state entities. Production shall not be left for private enterprises at all, right? All manufacturing, all services, everything is going to be done by state entities, right? These are the values which she propounded, and she wanted to make laws for the execution of these values. For example, she had to make a lot of laws for nationalization. Now the point is this: if you're going to make laws for nationalization or if you're going to make laws for creating, let's say, acquisition of properties and nationalizing of, let's say, for example, if you're a private business, the government of India can pass a law which can nationalize your private business, make it a part of the government of India, make it a part of the resources of the government of India, right? This kind of a nationalization or a private or a what you can call deprivatization can be done by the government by making a law. But this law also can be subjected to judicial review under Article 13, Clause 2 of the Constitution. So, for example, if I take away your property, if I take away your business, you can take a case against me, the state, under Article 19(1)(f), which had right to property, and 19(1)(g), which had right to freedom of trade, occupation, commerce, and business. So, for example, let's say you're running a bank. I want to nationalize all banks in India. I come to you and I say I'm going to take away a bank from you and I'm going to give you some menial compensation for that, right? Give me the bank, I will take control of the bank entirely myself. If I am doing this via a law, you know that this law is violating two of your fundamental rights openly. 19(1)(f), right to have your property. 19(1)(g), right to have a trade, occupation, business, or commerce, which is given under Article 19(1)(g) as a fundamental right. Yes, and therefore, if this law is ending up violating a fundamental right, then you can take this law before the Supreme Court of India, and the Supreme Court of India can subject this law to a strike down on the powers which are given to the Supreme Court under Article 13, Clause 2. And let's say, for example, I, Indira Gandhi, if I want to change the constitution itself, saying that laws made for bank nationalization, please listen to me carefully. If I want to change the constitution and say that laws made for bank nationalization will not be subjected to judicial review if they are violating any fundamental rights, I want to put this clause in the constitution itself. Then, according to the Golaknath judgment, this article which is being inserted in the constitution itself, stating that laws which are going to be made for bank nationalization shall not be subjected to judicial review for violating fundamental rights. This constitution amendment itself can be struck down by the Supreme Court with the application of the Golaknath case, judgment given by the Supreme Court in the year 1967. This is the position that Indira Gandhi as a Prime Minister was facing in the first year of her election in 1971. And she wanted to amend the constitution to ensure that this kind of a problem is solved in the favor of Mrs. Indira Gandhi. And thus Indira Gandhi brought about two amendments to the constitution. Please take a look at this. The two amendments brought to the constitution were 24th Constitution Amendment Act 1971. Class, a list of amendments here. 24th Constitution Amendment Act 1971 and 25th Constitution Amendment Act 1971. These two amendments were made in the constitution very quickly and categorically. Okay, the first 24th Constitution Amendment Act 1971, it inserted article these things. If you take a look at Article 13, Clause 4 over here, 13, Clause 4, nothing in this article shall apply to any amendment of this constitution made under Article 368. You may understand that this is the judgment which was given by the Supreme Court in the Shankari Prasad case, which was opposite to the Golaknath case. Since the Golaknath case was in contradistinction to what Indira Gandhi wanted to do, Indira Gandhi took the position of Shankari Prasad and encoded it. And it said that the constitution itself suggests, class please pay attention to this, the constitution itself suggests, and it should be read as it is. The constitution should be read as it is by everyone, regardless of the fact who has made this provision in the constitution. The constitution itself suggests that nothing in this article shall apply to any amendment of this constitution made under Article 368. What does it mean? It means that if the parliament is making an amendment to the constitution which is saying Article 14 and Article 15 will not apply in cases of bank nationalizations, Article 19 and Article 19, 20 and 21 will not apply in cases of bank nationalizations. If I am putting this clause in the constitution itself by amending the constitution, then the constitution itself suggests that this activity is given in the constitution by the parliament, right? And if I add something like this, it says any constitution amendment act made by the parliament under article 368 of the constitution shall not be called into question before any court of law, saying that this constitution amendment act is taking away a fundamental right. Do you see the point? What Indira Gandhi did was she took the position of Shankari Prasad and she placed it in the constitution itself. Right? Now she told the Supreme Court to say that the constitution itself reads that the power cannot be given to the Supreme Court to review a law made by the parliament under Article 368. If a law made by the parliament under Article 368 is violating a fundamental right, that law which is made under Article 368, if it is taking away a fundamental rights, if it is deleting a fundamental right, omitting a fundamental right, shall not be subjected to judicial review under Article 13 clause 2, because I have added Article 13 clause 4 in the constitution itself directly. And you should read the constitution by me as you were reading the constitution made by the Constituent Assembly. You see, I am representing the will of the people of India exactly in the same equivalence as the Constituent Assembly represented the will of the people of India. And therefore, I am not going to have any limitations in terms of how I will write the constitution. And what I write in the constitution is that you are not allowed to question any amendment made to the constitution by me. Right? This is what Indira Gandhi told very clearly to the Supreme Court. You can take a look at Article 13 clause 4. "24th Constitution Amendment Act 1971. So after the first Constitution Amendment Act 1951, the most important Constitution Amendment Act that we read in the time period that we have delineated for ourselves, 1950 to 1980, is the 24th Constitution Amendment Act 1971. Okay, so these two amendment acts were passed almost simultaneously. 24th Constitution Amendment Act added Article 13 clause 4. The 24th Constitution Amendment Act, 24th Constitution Amendment Act added Article 13 clause 4. It also added Article 368 clause 3. It also added the title of Article 368 . In this title of Article 368, the term these were mentioned. Okay, and in the 25th Constitution Amendment Act 1971, Indira Gandhi added a very dangerous article to the constitution, which is Article 31C. Right, now you remember very clearly, if a question comes, Article 31A and 31B were added into the constitution by the first Constitution Amendment Act. Class, am I clear? 31A, 31B. If I tell you a very simple story about Article 31, take a look at Article 31, all of you. Class, Article 31. Article 31 has A, it has B. Both of them are added by the first Constitution Amendment Act 1951. Right? Article 31C was added by 25th Constitution Amendment Act 1971. This was done by Jawaharlal Nehru, this was done by Indira Gandhi. And again Article 31D, which was the most dangerous of them all, was added to the Constitution by 42nd Constitution Amendment Act 1976, but it was later omitted by the Parliament. So this does not currently form the part of the Parliament. These are all parts of the Constitution. Okay. This is what I am going to give you as a little bit of a history of Article 31 of the Constitution. 31A, 31B, 31C and 31D. As they have been inserted in the Constitution, these are the most important provisions which have been changed in the Constitution, and the entire objective and the mindset of Article 31 of the Constitution is to ensure that there can be laws which can be made by the Parliament, which are going to be totally immune from the application of fundamental rights. The Parliament can make these laws and enforce these laws, and if these laws end up violating any fundamental right, these laws shall not be subjected to a judicial challenge, because they have been kept as a special chamber within part 3 of the Constitution, known as the savings clause. Savings clause meaning laws which will not attract fundamental rights. This is what is known as the savings clause of the fundamental rights part 3 of the Constitution. Alright class, Article 31A, 31B, 31C, 31D. So just take a look at Article 368 Clause 3 on the other side also of this. Okay. Article 368 Clause 3 में भी Parliament ने वही चीज लिख दी जो यहाँ पर लिख रहा था Parliament. ये देखिए आर्टिकल 368 क्लॉज 3. Nothing in Article 13 shall apply to any amendment made under this article. Class, I hope you're getting a sense of what I'm saying over here. 24th Constitution Amendment Act. Yes, this is a part of the current Constitution. Yes, this is a part of the current Constitution. Today, the Constitution contains this part very, very specifically. Nothing in Article 13 shall apply to any amendment made under this article. Okay, this was inserted in the Constitution by the amendment made to the Constitution in the 24th Constitution Amendment Act. You can see this over here, inserted by the Constitution, 24th Constitution Amendment Act 1971. Okay, are we clear class? Okay, so the Constitution was amended by Indira Gandhi under Article 31 under the Constitution Amendment Act which was passed in the 24th and the 25th CAA, right? If you want to take a look at, for example, Article 31C, maybe we can get there also. 31A, 31B, and 31C, you can take a look at them. You go to the simple draft of the Constitution for yourself and try to read Article 31C. But let's take a look at this together. See, this says inserted by the Constitution 25th Amendment Act. Again, if a question comes, which of the following amendments inserted Article 31C, the answer is 25th Constitution Amendment Act 1971. That is the correct answer for 31C. Okay. And what does 31C read? Please take a look at this yourself. 31C, saving of laws. So what does it mean? Saving of laws. These laws are not going to be subjected to fundamental rights. ओके अगर ये लॉ किसी व्यक्ति की फंडामेंटल राइट वायलेट कर दे तो इनको लॉ को नहीं रोका जा सकता है. लॉ चलते रहेंगे, फंडामेंटल राइट वायलेट हो या ना हो उससे कोई फर्क नहीं पड़ेगा. जिस भी व्यक्ति की फंडामेंटल राइट वायलेट हो रही है वो व्यक्ति इस लॉ को चैलेंज नहीं कर सकता है जुडिशरी के सामने, उसकी सारी पावर्स खत्म हो जाएंगी. ठीक, पढ़िए एक बार आर्टिकल 31C, ट्राई टू रीड इट फॉर योरसेल्फ. Notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19. ठीक है? And no law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. तो अगर संक्षेप में बताया जाए आपको इसके बारे में तो आर्टिकल 31C में ये दे रखा है कि अगर मान के चलिए हम कोई लॉ बनाते हैं, अगर पार्लियामेंट कोई लॉ बनाता है, देखिए सुनिए आर्टिकल 31C में दे रखा है, अगर पार्लियामेंट कोई लॉ बनाता है जिसको डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी का टाइटल दिया जाता है, तो इस लॉ की कोई भी जो प्रोविजंस है जब ये इन्फोर्स होंगी और अगर इन्फोर्स होते होते इन्होंने मान के चलिए किसी व्यक्ति की फंडामेंटल राइट आर्टिकल 14 और आर्टिकल 19 में अगर तोड़ दी, if it ends up violating the fundamental right of any person under article 14 and under article 19, then such a law shall not be सब्जेक्ट टू चैलेंज. तो मतलब अगर मान के चलिए इस व्यक्ति की फंडामेंटल राइट आर्टिकल 14 और आर्टिकल 19 इस लॉ के आधार पे टूट गई तो ये व्यक्ति सुप्रीम कोर्ट नहीं जा सकता है, ना ही तो रिट पिटीशन फाइल करने, ना ही आर्टिकल 13 क्लॉज 2 में लॉ को स्ट्राइक डाउन कराने. This person cannot go to the Supreme Court either to file a writ petition under Article 32 or to subject the law to a violation under Article, what you can say, 13 clause 2 of the Constitution. अगर इसके ऊपर DPSP का चिट लगा हुआ है, इस पे DPSP का लेबल लगा हुआ है. Any law given made to enforce the directive principles of state policy. Again, I'll repeat it, class. Any law given to enforce the directive principles of state policy shall not be subjected to judicial review if that law which is giving force to directive principle of state policy is made like that. अगर वो लॉ मान के चलिए यूनिफॉर्म सिविल कोड है, ठीक है, अगर यूनिफॉर्म सिविल कोड डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी में आता है, जो कि आता है, इफ इट एंड्स अप वायलेटिंग आर्टिकल 14 और आर्टिकल 19 ऑफ एनी पर्सन, तो ये व्यक्ति जाके कोर्ट के सामने फहरिस्त उसके याचिका नहीं लगा सकता है. आर्टिकल 31C में ऐसा लिखा हुआ था. So this was made in the amendment to the Constitution in 25th Constitution Amendment Act. ठीक है, अब देखिए यहां पर आपने देखा कि शंकरी प्रसाद का केस हो गया, राइट. द फर्स्ट केस दैट वी हैव अंडरस्टूड इज शंकरी प्रसाद. द सेकंड थिंग दैट वी हैव अंडरस्टूड इन रिलेशन टू शंकरी प्रसाद इज द गोलकनाथ केस, राइट. और गोलकनाथ को काउंटर किसने किया? 24th और 25th कॉन्स्टिट्यूशन अमेंडमेंट एक्ट. तो क्या हुआ 1971 में? द 24th and 25th Constitution Amendment Act. Now these were challenged before the Supreme Court. 24th and the 25th Constitution Amendment Act 1970 were. These were challenged by before the Supreme Court for violating गोलकनाथ, क्योंकि सही है ना कि गोलकनाथ की 11 जज की बेंच जो कह रही थी उसको 24th और 25th ने वायलेट कर लिया. तो जो गोलकनाथ का प्रश्न ठीक है या फिर पार्लियामेंट ठीक है, इसका प्रश्न उठाया गया 13 जजेस बेंच के सामने. The question that was raised at this point of time before a 13 judge bench of the Supreme Court was the question asking the validity of the 24th ठीक है. तो अगर प्रीलिम्स में क्वेश्चन आते हैं केशवानंद भारती में, मुख्य प्रश्न क्या था? मुख्य प्रश्न ये था, क्या 24th and 25th Constitution Amendment Acts 1973 are constitutionally valid in the light of the Golaknath judgment. This was a central question. And then if you want to take a look at the most important question that was asked overall with this central question, this became the central question which eventually led to the birth of the basic structure doctrine in the Keshwananda Bharati case. That is what basically I'm trying to in a way arrive at this point. Okay class, first constitution amendment Shankari Prasad case, Golaknath case, 24th and 25th Constitution Amendment Act. And then after that you have the Keshwananda Bharati versus State of Kerala case, right? And once you complete the state Keshwananda Bharati versus State of Kerala case, then you will come to the question which is put over the board over here. So these are the two central questions which were asked and answered. Okay, so the answer to this question at least was yes, there are limitations to the parliament's power to amend the constitution, and the limitations were described as the basic structure doctrine. ठीक है, तो ये क्वेश्चन आपके सामने प्रीलिम्स में आ सकता है प्रिलिमिनरी लेवल पे. Okay, this was the answer to the question which was given by the Keshwananda Bharati case. ठीक है, so we'll break at the point and we'll come back and deal with the judgment of the Keshwananda Bharati case. Then we'll take a look at the 42nd Constitution Amendment Act 1976. Then we'll take a look at 43rd, and then we'll take a look at 44th. ये तो आपके 1980 तक सारे कॉन्स्टिट्यूशन अमेंडमेंट एक्ट्स हो जाएंगे, और उसके बाद हम 1980 के बाद इंपॉर्टेंट कॉन्स्टिट्यूशन अमेंडमेंट एक्ट्स को देखेंगे. We'll take a look at anti-defection law, etc. 73rd and 74th Amendment Act, 102 Amendment Act, 103 Amendment Act, all of these things. I want to be very clear in terms of covering the important list of amendments made to the Constitution so that you can answer a question on the nature of amendments, XYZ, whatever question comes out of that particular thing, you should be able to answer this. Okay, now take a look at this. We have arrived at the 24th CAA 1971 and the 25th CAA 1971, right? And if you can say, let's say the combined effect The combined effect of these amendments has these distinctions. Okay, so if a question comes, what are the features of these amendments? Class, please be sure to note this out properly. The combined effects of these amendments are, point number A, this was the first effect of what you can say Article 13, Clause 4, Article 368, Clause 3, which were both inserted in the Constitution by the 24th Constitution Amendment Act 1971. Right? And the next question, the next point which is arrived over here is this, in point number B, that Article 31A plus B plus C combined allow the Parliament to make laws that are this was basically the combined effect of the 24th Constitution Amendment Act 1971 and the 25th Constitution Act 1971. Do I make my point clear? 25th Constitution Amendment Act 1971 places Article 31C. So this is what basically we can understand as the combined effect of the amendments made to the Constitution, 24th CA 1971, 25th Constitution Amendment Act 1971. Okay. Now, as we are taking a understanding of this in a kind of a chronology, it is that I have mentioned that the 24th Constitution Amendment Act and 25th Constitution Amendment Act, these acts have been challenged by the before the Supreme Court in the Keshwananda Bharati case on the ground that they are running contrary to the judgment given by the Supreme Court in the Golaknath case. Okay, the 24th Constitution Amendment Act and 25th Constitution Amendment Act, they are challenged in the Supreme Court, saying that they are running contrary to the judgment given by the Supreme Court. And you have a 13-judge bench of the Supreme Court, the highest ever. Okay, please be sure about this fact. You have the highest number of judges in a bench. It's a record. It has never been repeated ever since and never happened before that. Highest number of judges in a bench, 13 judges with a 7:6 majority. They gave judgments with regard to two things. Okay, this is what you can say the basic idea of the Keshwananda Bharati case. Okay, so I'm going to divide this into two parts. The judgment of the Supreme Court in the Keshwananda Bharati case. The Keshwananda Bharati case, Supreme Court agreed that the power of Parliament Supreme Court agreed that the power of Parliament to amend the Constitution under Article 368 is not subject to judicial review under the basic structure doctrine. Under the okay, so this was a agreement, this was a kind of a judgment in which the Supreme Court's decision has been made in favor of Shankari Prasad. Okay, so by this kind of a understanding, the Supreme Court was able to overrule the judgment of the Golaknath. So here you have the Supreme Court in the Keshwananda Bharati case overturning the judgment of Golaknath. The Supreme Court had overturned the judgment of Golaknath. Okay, here that was one part of this, and it agreed with the Shankari Prasad case. And therefore, the constitutional validity of Article 13, Clause 4 was reinstated. बोला कि Article 13, Clause 4 भी constitutionally valid है और Article 368, Clause 3 भी constitutionally valid है. Okay, so these things the Supreme Court agreed in totality in terms of giving a sense of the case on the Bharati judgment in the first part of it. Okay. The second part of this judgment, the Supreme Court said Okay, just take a look at this kind of the presentation that we can take a look at about the judgment of the case in the Bharti case in the matter of this entirety. Just very simply take a look at the judgment as it is given in this particular matter. Just take a little bit of a read and notation of it if you can, and then I will explain to you the logic of the Keshav the Bharti case. Again, 50 years the Keshav the Bharti case is completing this year, and therefore the judgment of the Supreme Court, which is the most historic judgment ever by the Supreme Court, could become a relevant perspective in the prelims paper this time. So we are going to take a look at it with some detail as we are arriving at it. Okay, the 24th and the 25th Constitution Amendment Acts were challenged before the Supreme Court in the case of the Bharti versus State of Kerala, where 13 judges were instituted to look at the validity of the 24th and 25th CA 1971. So if a question comes, which of the following amendments acts were challenged before the case of the Bharti, it was 24th and 25th CA. What are the conditions, or what are the provisions of the constitution that were challenged under this? You have article, what you can call 13 clause 4, 368 clause 3 and 31C, and this was the, what you can say, a premise of a judgment which was created by the Supreme Court. Okay, so we'll take a look at this a little bit. Please just read this and notice down, and then we'll explain this part. Please focus upon this part. You're talking about the application of the basic structure doctrine, and you know for a fact that the Keshav the Bharti case was the one which created the basic structure doctrine, right? Now, if I take a look at, for example, a little bit of an elaboration of the Keshav the Bharti case, what we are understanding is this, that the question was, can judicial review exist? Can judicial review exist for You see, this was a basic question which was coming in the center of Keshav the Bharti. Now, class, please focus upon this part. Okay, we are developing the basic structure doctrine here. Can judicial review exist for amendments to the Constitution under Article 13, Clause 2? Right. So, for example, if amendments are made to the Constitution under Article 368, can these amendments be subjected to judicial review under Article 13, Clause 2 of the Constitution? What is the answer? The court gives the answer no. The parliament is correct to state. The parliament is correct to state that the amending powers under Article 368, which are the constituent powers, are not covered under Article 13 Clause 2 as laws. Therefore, amendments that take away fundamental right are not subject to challenge under 13 clause 2. This is what the court held in the first instance. Therefore, Article 13 clause 4 and Article 368 clause 3 are correct. ठीक है, तो यहां पर the court upheld the constitutional validity. जो 24th CAA 1971 था, उसमें सुप्रीम कोर्ट ने केशवानंद भारती केस में कॉन्स्टिट्यूशनल वैलिडिटी को अपहोल्ड कर दिया था. डू यू अंडरस्टैंड द पॉइंट ओवर हियर? दैट वाज द फर्स्ट क्वेश्चन दैट वाज टेकन अप. ठीक है, सो जस्ट टेक अ लुक एट दिस इन अ कैटेगोरिकल टर्म. देन द नेक्स्ट क्वेश्चन दैट केम अप बिफोर द सुप्रीम कोर्ट वाज, इज देयर एनी अदर format of judicial review upon constitution amendment acts. Sure, there is no judicial review as per the Supreme Court upon constitution amendment acts under Article 13 clause 2. Okay, there is no judicial review upon Constitution Amendment Act under Article 13 clause 2. That is even today the relevant position. Class, I am going to be very emphatic about this. Even today there is no relevant position in which a Constitution Amendment Act can be subjected to judicial review under Article 13 clause 2. Today the Constitution Amendment Acts cannot be subjected to judicial review under Article 13 clause 2. So if a constitution, let's say if a parliament makes an amendment and takes away Article 14, 15, 16, 17, 18, 19 and deletes them from the constitution today, parliament by an amendment, these amendments are not going to be subject to judicial review under Article 13 clause 2. That is even today the position, because there is Article 13 clause 4 and there is Article 368 clause 3, both inserted by the 24th Constitution Amendment Act, and both of them are part of the parliament. Both of them are a part of the constitution today, right? So there is no what you can say power which is existing with the Supreme Court of India or the High Courts of India to subject a Constitution Amendment Act to judicial review if it is taking away a fundamental right under Article 13 clause 2. Please notice the fact, under Article 13 clause 2 there is no power of judicial review, right? The question therefore is there any other power of judicial review? Now this is the real revelation, if you think about it clearly. This is the real revelation. When we talk about the powers of judicial review under Article 13 clause 2, they are not there. Okay, but now the Supreme Court had invented new powers of judicial review, right? There are hidden powers of judicial review, as the Supreme Court stated. There are hidden powers of judicial review under Article 368 itself. Okay, so now the Supreme Court, on one hand, it gave away its powers of judicial review under Article 13 Clause 2. Okay, the Supreme Court of India on one hand gave away its powers of judicial review under Article 13 Clause 2. It gave away the powers of judicial review under Article 13 Clause 2. But on the other hand, it assumed the powers of judicial review completely newly founded under Article 368. And this was the argument made by the Supreme Court. Supreme Court said that the Part 20 of the Constitution, just take a look at this argument which was made by the Supreme Court, to develop a new set of powers for judicial review. Now class, please pay attention over here, right? Part 20 of the Constitution talks, or the title of the Part 20 of the Constitution is the Amendment of the Constitution. This is what the title of the part says, Amendment of the Constitution. Amendment of the Constitution, Amendment of the Constitution, right? And now he was, let's say for example, judges of the Supreme Court took a look at the term Amendment of the Constitution and they did a bit of a mathematical derivation out of it. Amendment of the Constitution would mean A of C, right? You have, for example, the equation that comes out by deriving amendment of the Constitution is A of C. Amendment of the Constitution, the equation that is derived out of it is A of C, right? A of C. And the Supreme Court argued that if I, for example, say x of y in mathematical terms, then y cannot be greater than y. Which means y must be greater than x. The function of mathematically presupposes that x is smaller than y. X cannot be greater than y. Y must be greater than x, from which x can be derived out of, right? Now, this is basically what the term amendment of the Constitution was read by the Supreme Court as. It says that amendment of the Constitution implies that after the amendment has been made, amendment of the Constitution implies that after the amendment has been made. So, for example, let's say if this is the Constitution, right? And let's say this is the circumference of the Constitution. Okay, and now let's say, for example, this is the amendment. Now, let's imagine this is the circumference of the amendment. Okay, now when it says x of y, something like this, it is needful to say that an amendment of the Constitution, cannot be greater than the Constitution itself, right? So you can't have an amendment of the Constitution which in a way is greater than the Constitution itself. Okay, amendment of the Constitution has to be done in such a manner that it remains within the framework of the Constitution, which means that the idea of the Constitution or the concept of the Constitution must survive the amendment. After the amendment has been made to a Constitution, it should not be the case that the Constitution itself does not remain at all, because it talks about amendment of the Constitution. The term which is used over here is amendment of the Constitution. So x of y, meaning x must be done in such a way that it does not annihilate y entirely. There must be something that remains after y, after x is done. You see, x cannot annihilate y entirely. X can reform y, but it also cannot completely annihilate the point where the equation collapses, where the equation is self-destruct, right? And therefore the amendment to the Constitution cannot be made to such an extent that the amendment itself is bigger than the Constitution, right? An amendment to the Constitution cannot be made to such an extent that it is bigger than the constitution. In fact, after an amendment has been made to the constitution, it must be the case that the amendment must survive. The constitution must survive. Okay, so what the Supreme Court basically came with the argument over here is that the term amendment of the constitution means that amendments must be such that the constitution as a concept must survive the amendments, right? This is the, what you can say, deduction they had made from the term amendment of the constitution, right? Amendment must be such that the constitution must survive the amendment, right? Which means that amendments cannot destroy the constitution. Which means that there must be an essence of the constitution that cannot be destroyed. Okay, this essence of the constitution is known as the basic structure of the constitution. This essence of the constitution is known as the basic structure of the constitution. Okay, and after this the Supreme Court said that amendments this is the real logicality of the Keshwananda Bharati case. Okay, try to read these statements properly, class. Get a sense of this, what I have written over here, please. Try to understand the logic that I am creating. We come from the question which is asked in the Shankari Prasad case, and the Golaknath case, and finally in the Keshwananda Bharati case. The question is, are there any powers, are there any limitations upon the powers of the parliament to amend the constitution, right? Can the parliament amend the constitution without any restrictions whatsoever? Can the parliament amend any part of the constitution, including the fundamental rights? These are the questions which have come up as a major constitutional debate from 1951, which is the Shankari Prasad case. Shankari Prasad said yes, the parliament's power to amend the constitution are infinite, because the only thing that can stop the activities of the parliament from amending the constitution is the judiciary, and the judiciary has been given the powers to judicial review under Article 13 clause 2 of the constitution. But the powers of judicial review under Article 13 clause 2 of the constitution do not extend on constitution amendment acts made under Article 368, and we have to make a distinction between ordinary laws made by the Parliament and Constitution Amendment Acts made by the constituent powers, and Article 13 Clause 2 will only cover ordinary laws made by the Parliament with regard to their judicial review on the basis of violating fundamental rights, but it will not cover Constitution Amendment Acts. This is what Shankari Prasad said. This is what Golaknath overturned. Golaknath said that it is not correct to say that the Parliament can amend the entire Constitution, or at least not the part 3 of the Constitution. Golaknath said part 3 is the soul of the Indian Constitution, and the Parliament does not have the power to amend the provisions of part 3 of the Constitution. And if a Parliament passes a law to amend the provisions of part 3 of the Constitution, which are fundamental rights, then such a law shall be struck down by the Supreme Court under Article 13 Clause 2. This is what Keshwananda Golaknath said. To oppose the Golaknath case, the Indira Gandhi government brought about the 24th and 25th Constitution Amendment Acts, in which it, in a way, amended the Constitution itself to say that Supreme Court or other courts shall not entertain matters which are made under Article 368 of the Constitution to amend a fundamental right. So it countered the Golaknath judgment, and the 24th and 25th Constitution Amendment Act were before the Keshwananda Bharati Supreme Court judgment. And the Keshwananda Bharati first of all said that the judicial powers of the Supreme Court under Article 13 Clause 2 to challenge Constitution Amendment Acts is not there. The Parliament is correct. Okay. So it took the power of judicial review under Article 13 Clause 2 and threw it away. But now it did not rely upon the powers of judicial review under Article 13 Clause 2 of the Constitution. It invented, discovered, deduced new powers within Article 368 of the Constitution itself for judicial reviews. New powers were deduced, were read by the, what you can say, the Supreme Court of judicial review within Article 368 itself. And the logic of that was this particular point. They said the title of Article 368, which talks about amendment of the Constitution, which means A of C or X of Y, which means A cannot be such an extent that it annihilates Y, right? The amendment of the Constitution cannot be in such a manner that it annihilates the Constitution itself, and therefore the Constitution must be larger than the amendment. Therefore, there must be some part of the Constitution which cannot be amended, and this the Supreme Court declared was the basic structure of the Constitution. So if you take a look at this point-wise point argument, this is how Supreme Court evolves what is known as the basic structure doctrine, and this is how the Supreme Court evolves new judicial review powers under Article 368 itself. Under the basic structure doctrine, which the Supreme Court found hidden within Article 368 itself, it gave to itself the judicial review powers on Constitution Amendment Acts which are violating a basic feature of the Constitution. So, after the Keshwananda Bharati case, class, please take a very attentive listening to this. It is a concept building exercise. After the Keshwananda Bharati case, the Supreme Court of India agreed with the Parliament that it does not have judicial review powers on laws which are amending the Constitution to take away fundamental rights under Article 13 Clause 2. Under the Article 13 Clause 2, the Supreme Court agreed that it does not have judicial review powers. Okay. And then it said that I don't need the judicial review powers to strike down laws made under Article 368. I have discovered a new set of judicial review powers, and these judicial review powers are under Article 368 of the Constitution, the basic structure of the Constitution. So it says amendment of the Constitution means Constitution must be slightly higher than the amendment, right? And therefore, an amendment, if it is made in such a way that it takes or annihilates the Constitution itself so that the equation itself doesn't remain, is something that cannot be constitutional, because the term says amendment of the Constitution. Okay, X of Y. And thus they said that there is going to be some kind of a basic structure of the Constitution which can never be amended. There must be some kind of a basic, underlying essence of the Constitution which can never be amended. And this basic underlying essence of the Constitution they call the basic structure doctrine, which is not subjected to any amendment, which cannot be amended. If that amends, the essence of the Constitution itself is destroyed. Okay. And then they said, take a look at this, that let's say for example, just try to understand this logic here clearly now. Class, take a look at this logic please clearly. Let's say if the Constitution Amendment Act, please class, I want you to attend upon this fully. If a Constitution Amendment Act, let's say 150th Constitution Amendment Act, in the year 2035, let's imagine a hypothetical science fiction scenario, is passed by the parliament. Let's say 2035, we have really gone to hell as a country, and let's say the parliament is occupied by all goons. Okay, all the majorities are occupied by gundas. Let's say, imagine. Okay, now if let's say for example the parliament in 2035 is taken up by a kind of a Naxalite force or a Maoist force or something like that, and the parliament passes an amendment to the constitution saying article 14, article 19, article 21 and article 25, these are all suspended for the next 10 years. ठीक है, उन्होंने कहा कि बहुत हो गया फंडामेंटल राइट और ये डेमोक्रेसी और ये सारी चीजें, अब हम लोगों पे शासन करेंगे कड़क तरीके से. ठीक है, तो आर्टिकल 14, 19, 21 एंड 25 आर सस्पेंडेड फॉर 10 years. लिख दिया इन आर्टिकल्स के सामने कि आर्टिकल 14, 19, 20, 21 is suspended for 10 years. Okay, and they have followed the procedure under article 368 clause 2. आर्टिकल 368 clause 2 का प्रोसीजर इन लोगों ने फॉलो कर लिया है. ठीक है, अब मान के चलिए कि ये वाली पोजीशन, इफ दिस काइंड ऑफ अ केस goes to the Supreme Court of India, if this kind of a position goes to the Supreme Court of India, can the Supreme Court, question to you class, can the Supreme Court declare the Constitution Amendment Act 2035, let's say 150 Constitution Amendment Act 2035, void under article 13 clause 2 as it takes away a fundamental right? That is the question that we are trying to ask here. Do we get a sense here, class? ठीक है, बताइए. How do I answer this question? I put up a hypothetical scenario before you. We're talking about the 150th Constitution Amendment Act 2035, which is passed by the Parliament, which says Article 14, 19, 21 and 25 are suspended for 10 years. Which means that this law, which is made by the Parliament under Article 368 of the Constitution, has been made to take away the fundamental rights. The question that I'm asking is, can the Supreme Court of India declare this 150th Constitution Amendment Act as void under Article 13 clause 2 as it takes away a fundamental right? This is my question to you, class. Answer the question please, yes or no. Meaning yes, the Supreme Court can strike down. No, the Supreme Court cannot strike down. Please give the answer. Please give the answer, class. The Supreme Court cannot strike down. What is the answer? I am putting a statement before you. Can the Supreme Court declare the 150th Constitution Amendment Act 2035 void under Article 13 clause 2 as it takes away fundamental rights? Can this kind of an activity exist in the format of a judicial review? Yes or no is the question. What is the answer? Class, what is the answer to the question? Please, all of you tell me. Excellent. The answer is no. No, this cannot happen. So what happens in the pursuit of this entire activity? What happens if this is not possible? Do we live in a society in which fundamental rights can be taken away by any person who gets a majority in the parliament? What if elections are rigged? What if all the election machineries have been compromised? How do you know that the people sitting in the parliament are the real will of the people? We don't know that. Okay, so what do you see as a point? What we see as a point is, let's say the question is, if the judicial review cannot happen under Article 13 Clause 2, what are the two possible scenarios out of this? The two possible scenarios out of this is, there are no other judicial review powers, okay, this is one scenario, and this is another scenario is that judicial review powers under the basic structure doctrine they still exist. ये कारतूस है आपके पास. Judicial review powers under the basic structure doctrine. Okay, now take a look at this. Though the Supreme, I'm going to write it out properly, class. Please pay attention to this. Again, a concept building point we are at. Very, very crucial. Though the judicial review powers of the Supreme Court on Constitution Amendment Acts are not given under Article 13 Clause 2, that does not mean that there are no judicial review powers at all on Constitution Amendment Acts. Do we understand, class? Okay. Now take a look at this. According to the Keshwanand Bharati case, in which a 13-judge bench of the Supreme Court, according to the Keshwanand Bharati case, in which you have a 13-judge bench of the Supreme Court, which discovered the basic structure doctrine, which stated that the essence of the Constitution cannot be destroyed by amendments, and such amendments that destroy the essence can be struck down. Now look at this argument here. Fundamental rights are a basic feature these are the essence of the Constitution. and if they are taken away by amending the constitution, it will destroy the essence of constitution. Try to gather this argument, class. The Supreme Court, therefore, can declare the 150th CAA 1935 as unconstitutional, as it violates the basic structure doctrine by destroying the fundamental rights which are a basic feature. Try to get a sense of this argument, class. Please try to get a sense of this argument that I have made entirely in addition to what we have studied till now. Please, class, get to the bottom of it. We are at the real crucial juncture, the nerve center of understanding the most complicated and the most enlightened concept within our constitutional history, the basic structure doctrine. And I want you to understand the concept absolutely spot on, so that you don't have to memorize anything and you can answer any question only on the basis of your understanding of the concept. Okay, I think the voice is back. Right, class, I'm going to repeat it again. Yes. Take a look at this. 150th Constitution Amendment Act, which takes away Article 14, 19, 20, 21, 25 of the Constitution, is not subject to judicial review under Article 13, Clause 2 of the Constitution. Again, I'll repeat. Take a look at this, please. Here, I hope the voice is clear now. The 150th Constitution Amendment Act, if I take the Constitution, this is the Constitution, okay? If I take the Constitution, I am the Parliament, okay? Let's say some person has rigged the elections and they have come to the Parliament, Gundas, okay? And they say that this Constitution will not have 14, 19, 21 and 25 for the next 10 years. This Constitution will not have 14, 19, 21 and 25 for the next 10 years. Give us a free reign for 10 years. In 10 years, we will fix all the problems of this country. That's exactly what everyone says, right? And in that sense, give me 14, 19, 21 and 25 and I will put it out of the Constitution for 10 years. I have made this Constitution Amendment Act, passed it through the Parliament, enacted, given the assent by the President. This Constitution Amendment Act, which is taking away Article 14, 19, 21 and 25 from the Constitution, can it be subjected to striking down by the Supreme Court under Article 13, Clause 2 of the Constitution? The answer is no. Because under Article 13, Clause 2 of the Constitution, the opinion of Shankari Prasad remains intact, which says that a law which is made under the Constitution, Article 368, that law shall not be subjected to any provision of Article 13 of the Constitution. And this was also made a part of the 24th Constitution Amendment Act 1971, right? And this 1971 Constitution Amendment Act, this was declared as constitutionally valid by the Supreme Court in the Keshwananda Bharati case, stating that the argument made by Shankari Prasad and the Parliament is correct. There is a very clear distinction between the constituent powers and the ordinary legislative powers. While the Parliament is performing its ordinary legislative powers, it is a Parliament of everyday accord and its powers cannot be, extraordinary. But when the powers are being exercised under the constituent power of Article 368 of the Constitution, then the Parliament is channeling the Constituent Assembly. It is as if were a reincarnation of the Constituent Assembly. And therefore, since it is a reincarnation of the Constituent Assembly, it has a power to amend the Constitution entirely without being subjected to judicial review under Article 13, Clause 2 of the Constitution. That is what was agreed by Keshwananda Bharati. But this 150th Constitution Amendment Act, if it is not subjected to judicial review under Article 13, Clause 2, does not mean that it cannot be subjected to any form of judicial review. That's the point, ladies and gentlemen. The point is that you are not subjected to judicial review under Article 13, Clause 2, agreed, but you are not subjected to any kind of a judicial review, is not agreed. Does the Supreme Court itself have the powers to have judicial review from somewhere else apart from Article 13, Clause 2 of the Constitution? And the answer is yes, of course, correct. It is amendment of the Constitution which says amendments should be smaller than the Constitution, which means Constitution cannot entirely be eaten up by amendments. An amendment cannot be made in such a way that the Constitution itself collapses, right? And this activity in which amendments have to be made in such a way that the Constitution survives, the essence of the Constitution survives, created the possibility of having a doctrine in which there are parts of the constitution or concepts or ideas or values within the constitution that are beyond amendment. They cannot be amended. These are known as the basic features of the constitution. And now, while looking at the 150th Constitution Amendment Act 2035, the Supreme Court says, I cannot strike it down under Article 13 Clause 2. You are right. But I can say fundamental rights are a basic feature of the Constitution. Fundamental rights are the essence of the Constitution. And therefore, any kind of a Constitution amendment which is taking away the fundamental rights is taking away the essence of the Constitution. And therefore, this taking away of the fundamental rights can be subjected to judicial review under Article 368 through the basic structure doctrine, and bam, this amendment can be struck down. Now tell me, do you understand the nature of the basic structure doctrine or not? Do we have an idea of what we are talking over here, class? Can you hear me out there? Can the 150th Constitution Amendment Act 2035 be struck down by the Supreme Court if it is taking away a fundamental right? Yes, but not under Article 13 Clause 2, but under Article 368, because Article 368 has given the birth to the basic structure doctrine, and fundamental rights is one of the basic features. Okay? You see the point? Class, are we there? Do we understand? Class, do we understand? Now take a look at this. If you have a very simple idea, any Constitution Amendment Act made under Article 368 that hurts, destroys, takes away, violates a basic feature of the Constitution can be subjected to a strike down by the judiciary under the basic structure doctrine. Okay, right, so this is point number 1. Point number 2, Constitution Amendment Act 2035 takes away FRs, that is the basic feature of the constitution. Judicial review cannot Do we understand this argument entirely, class? What I have written on the board over here? So, previously the fundamental rights were being protected by the judicial review which was given to amending the fundamental rights out of the constitution under Article 13 Clause 2 itself. Now the fundamental rights are being protected from being amended out of the constitution, not from Article 13 Clause 2, but from Article 368, which is under the basic structure doctrine. Do we understand this part? Class, are we clear? Do we have a clarity upon this entirely? Yes or no, class? Tell me. Okay. Now, let's come to the final part of understanding this properly. We have something called the basic structure of the constitution, right? The basic structure of the constitution. Okay, so if you take a look at this, for example, very simply, basic structure is a doctrine, it is a theory, okay, it is an idea, it is a concept. Basic features of the constitution are a list of those items which are essential to the constitution. Okay, so for example, let's say fundamental rights are essential to the constitution. Federalism is essential to the constitution. Judicial review is essential to the constitution. Independence of judiciary is essential to the constitution. Parliamentary form of government is essential to the constitution. Secularism is essential to the constitution. And the list can go on and on to include free and fair elections as being essential to the constitution. Do we get a sense of this? Now, let me come to the final part of this in a more provocative sense of getting it into clarity. When you take a look at, for example, 1973, let's say pre-1973 and post-1973. If you take a look at these parts, you have, let's say, judiciary could strike down any constitution amendment act which took away fundamental rights, according to what is the Golaknath judgment. Now, this judgment was overturned. The position that has come after 1973, post 1973, which is from the Keshwaranda Bharati case, the position which has come from the post 1973, which is the Keshwaranda Bharati case, is that the judiciary can strike down any constitution amendment act that takes away any of the basic features of the constitution. Which includes fundamental rights, which includes free and fair elections, which includes secularism, which includes federalism, etc., etc. You see? Now, just to focus upon this point, you will get a clarity upon a certain idea here. With the Golaknath judgment, 11-judge bench of the Supreme Court, the power of the Supreme Court to have judicial review over amendments to the Constitution was ascertained. With the Golaknath judgment, the power of the Supreme Court to have judicial review over the amendments to the Constitution was ascertained. Agreed. Okay. But only limited to the parts which are governed by Part 3 of the Constitution. तो गोलकनाथ जजमेंट में ये कहा गया था कि अगर संविधान में पार्ट 3 में कोई अमेंडमेंट होता है तो उसको सुप्रीम कोर्ट स्ट्राइक डाउन कर सकता है ना. पार्ट 3 में है फंडामेंटल राइट्स, आर्टिकल 13 बात करता है जुडिशियल रिव्यू फंडामेंटल राइट्स के ऊपर. तो गोलकनाथ में ये कहा गया था कि अगर संविधान के पार्ट 3 ऑफ द कॉन्स्टिट्यूशन में किसी भी प्रकार का कोई संशोधन किया जाता है जिससे कि फंडामेंटल राइट्स को हटा दिया जाता है तो आप उस पार्ट को, मतलब उस अमेंडमेंट को स्ट्राइक डाउन कर सकते हो. लेकिन मान के चलिए प्रश्न आपसे ये पूछा जाता है, फॉर एग्जांपल लेट्स से द क्वेश्चन दैट वी आर गोइंग टू आस्क इज, इफ आई ओपन अप लेट्स से if I, let's say for example, open up article 324 of the Constitution. Let's say I open up article 324 of the Constitution. Now let's say this is the article 324 of the Constitution. Okay, let's say I'm giving a case example, hypothetical. Let's say 140th Constitution Amendment Act 2030 is passed by the Parliament, and under this it is written 140th Constitution Amendment Act 2030 is passed by the Parliament, and under that act an amendment is made to this part of the Constitution. What does the amendment say? It says the superintendent's direction and control. यहाँ पर टाइटल चेंज कर देता है, लेट्स से इसको हटा देता है अमेंडमेंट और यहाँ पे लिख देता है होम मिनिस्ट्री. ठीक है, और इसको भी हटा देता है यहां से. यहां भी लिख देता है मिनिस्ट्री ऑफ होम अफेयर्स. Okay, please take a look at this. I'm giving you a kind of a thought experiment to elaborate the concept of the basic structure doctrine and its application. 140th Constitution Amendment Act passed in 2030. 140th Constitution Amendment Act passed in 2030 amends Article 324 of the Constitution, and it is these amendments that it makes that the superintendent's direction control of elections to be vested in the Home Ministry, and instead of the Election Commission of India you will have the Home Ministry. ठीक है, और बाकी जो सारे आर्टिकल्स होते हैं वो डिलीट कर देता है. इसका मतलब है कि भारत में चुनाव की पूरी प्रक्रिया कराना, उसका ऑर्गेनाइजेशन कराना, उसका कोड ऑफ कॉन्डक्ट लगाना, ये सारी चीजें कराना होम मिनिस्ट्री का काम है. ठीक, all the activities which are to be done with regard to elections in India are now to be conducted and operationalized by the Home Ministry. Now the question is 140th Constitution Amendment Act के ऊपर हम आपसे दो प्रश्न पूछेंगे. सुनिएगा ध्यान से. Two questions I will ask you. If it was made, let's say, before 1973, how could it be subject to judicial review? If it is made after 1973, how could it be subject to judicial review? Class, any thoughts over this? Any thoughts over this, class, please? A, this is the question. A में कैसा होता judicial review? या हो पाता कि नहीं? So let's say if I ask the question, A में judicial review हो पाता कि नहीं, और B में judicial review कैसे होता, ये बताइए. Or even let's say for example, to make it a slightly more interesting and simple also, अगर हम गोलकनाथ केस के हिसाब से जाते तो सुप्रीम कोर्ट अगर गोलकनाथ की वर्डिक्ट से रिव्यू करता तो कैसे कर पाता, और अगर हम केशवानंद भारती के केस से जाएंगे तो कैसे कर पाएगा? That is the question that I'm trying to ask you over here, class. Please try to understand the point I'm trying to make here and give a sense of the answer to us. 1973 के पहले अगर ये अमेंडमेंट होता तो जुडिशियल रिव्यू हो पाता कि नहीं हो पाता, और 1973 के बाद अगर ये अमेंडमेंट है तो जुडिशियल रिव्यू हो सकता है कि नहीं हो सकता है? Give me an answer, class. I'm looking to an answer here. Class, I want an answer over here. Come on, class, give me an answer. Is judicial review possible under A and B both? And if it is possible under A, how? And if it is possible under B, how? मतलब क्या सुप्रीम कोर्ट ये कह सकती है कि होम मिनिस्ट्री को चुनाव का अधिकार देना गलत होगा, संवैधानिक होगा, गैर संवैधानिक होगा? तो क्या सुप्रीम कोर्ट इस अमेंडमेंट को स्ट्राइक डाउन करके इलेक्शन कमीशन ऑफ इंडिया को बचा सकती है कि नहीं, ये प्रश्न है. What about A and what about B is the question that I'm trying to ask. Class, please tell me now. Very good. Most of you have answered it correctly. Absolutely fine. You see, if Article 324 is amended, class, please pay attention to this. If Article 324 is amended by the Constitution Amendment Act, and if you are going to subject this as a judicial review under the Golaknath case, okay? If I am going to subject Golaknath case to a judicial review under Article 324, as you can see, Golaknath assumes the power of judicial review under Article 13, Clause 2. So Golaknath says that the Supreme Court can strike down any Constitution Amendment Act which take away any provision under Part 3, class. You have to be very sure that Part 3 is what is being specified in judicial review under Article 13, Clause 2. So if it go with the Golaknath verdict में 13 Clause 2 में judicial review आ सकता है? Yes. Constitution Amendment Act के अंदर आ सकता है? Yes. लेकिन वो कॉन्स्टिट्यूशन अमेंडमेंट एक्ट के अंदर नहीं आ सकता जो पार्ट 3 के बाहर है, और क्योंकि आर्टिकल 324 इज नॉट, एज यू आर वेरी करेक्टली पॉइंटिंग आउट, पार्ट 324 is not within part 3 of the constitution. You see, that is why it is not going to be applied to article 324. तो मतलब गोलकनाथ वर्डिक्ट के अंदर अगर चाहें तो इलेक्शन कमीशन ऑफ इंडिया को हटा के उसकी जगह आप गृह मंत्रालय को सारा काम दे दीजिए चुनाव संभालने का. गृह मंत्रालय जो सरकार के हाथ पे चलता है, और सरकार वो जो इलेक्ट होना दोबारा चाहती है, द मेंबर ऑफ पार्लियामेंट्स हु आर फॉर्मिंग द गवर्नमेंट, दीज पीपल वांट टू बिकम और बी री-इलेक्टेड एज द मेंबर्स ऑफ पार्लियामेंट. ये लोग अगर खुद ही अपना चुनाव कराएंगे तो जाहिर है कि इलेक्शन कमीशन ऑफ इंडिया के ना होने से और गृह मंत्रालय चुनाव को ऑर्गेनाइज कराने से अपनी तरफ टिल्ट करा लेगा. लेकिन गोलकनाथ जजमेंट के अनुसार, अकॉर्डिंग टू द, if the Golaknath judgment would have been present today, then under the Golaknath judgment सुप्रीम कोर्ट देखता रह जाता है इस अमेंडमेंट को, लेकिन टच नहीं कर पाता, क्योंकि सुप्रीम कोर्ट के पास जुडिशियल रिव्यू की पावर्स गोलकनाथ जजमेंट के अंदर सिर्फ आर्टिकल 13 क्लॉज 2 में दे रखी हैं. ये बात सही है कि सुप्रीम कोर्ट फंडामेंटल राइट्स के टेक अवे होने पे जुडिशियल रिव्यू कर सकता है. द सुप्रीम कोर्ट कैन strike down a law which is amending the constitution, which is violating or taking away a fundamental right. Okay, but at the same time the Supreme Court does not have the power to subject a Constitution Amendment Act to judicial review where fundamental rights are not concerned. Part 3 of the Constitution are not there, and therefore यहाँ पर Supreme Court किसी भी प्रकार का review नहीं लगा सकता था गोलकनाथ केस में. Your reading is absolutely correct. Most of you have got the correct answer. But if I take a look at Article 324 with regard to the basic structure doctrine 1973 में, आप लोगों ने बिल्कुल सही बोला है. बेसिक स्ट्रक्चर डॉक्ट्रिन में जो जुडिशियल रिव्यू आएगा, विद इन द बेसिक स्ट्रक्चर डॉक्ट्रिन द जुडिशियल रिव्यू विल बी अप्लाइंग अ स्ट्राइक डाउन. Judicial review will be applying a strike down on the ground that the amendment to Article 324 shall violate the basic feature of free and fair elections. This is what we can call the impact of the Keshwananda Bharati case, class. This is exactly what I'm trying to, in a way, impress upon you, which is the impact of the Keshwananda Bharati case. Do we have a sense of this, class? This is the real impact of the Keshwananda Bharati case. That it has, in a way, exploded the powers of judicial review. And for example, let's say if this is the entire Constitution of India, which is having part 1, part 2, part 3, any of these parts of the Constitution, right? Okay, so let's say 1, 2, 3, 4, 5, 6. These are the parts of the Constitution. Previously, under the Golaknath, any amendment made only to part 3 of the Constitution, अगर आपने पार्ट 3 में कुछ चेंज किया तभी जाके आप उस पार्ट के अमेंडमेंट को रोक सकते थे. सो द पावर्स ऑफ स्ट्राइकिंग डाउन लॉज, ठीक है. ये वाला था जो आपका गोलकनाथ का जजमेंट था, जिसमें सुप्रीम कोर्ट ने 11 जज बेंच में खुद अपने आप को जो पावर्स दी थी, वो बहुत ही लिमिटेड पावर्स थी, जहां पर कि इट कुड ओनली स्ट्राइक डाउन अ जजमेंट अमेंडमेंट्स with regard to the part 3. But today, if you take a look at any part of the Constitution, if you take a look at any part of the Constitution, any part of the Constitution can be protected by the Supreme Court under judicial review. If it says that any of these parts of the Constitution have the basic structure of the Constitution, ठीक है. अगर किसी भी पार्ट में आपने बेसिक फीचर आइडेंटिफाई कर लिया, सो फॉर एग्जांपल पार्ट 1 में आप यूनिटी और इंटेग्रिटी ऑफ इंडिया आइडेंटिफाई कर सकते हो, पार्ट 2 में आप सिटीजनशिप कर सकते हो, पार्ट 3 में फंडामेंटल राइट्स है, पार्ट 4 में डायरेक्टिव प्रिंसिपल्स कर सकते हो, प्रेसिडेंशियल फॉर्म ऑफ प्रेसिडेंशियल एग्जीक्यूटिव कर सकते हो, पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट कर सकते हो, फ्री एंड फेयर इलेक्शंस कर सकते हो, सेक्युलरिज्म कर सकते हो. ऑल द पार्ट्स ऑफ द कॉन्स्टिट्यूशन आर नाउ प्रोटेक्टेड. सो अगर मान के चलिए पार्लियामेंट अगर इनमें से किसी भी पार्ट को अगर अमेंड करने आज के समय में आता है, तो उस अमेंडमेंट को रोका जा सकता है. If the parliament comes to amend any of these parts of the constitution, then those amendments can be stopped by the Supreme Court by the virtue of the basic structure doctrine which has been created in the Keshwananda Bharati case. So in a way, the Supreme Court has enveloped its hands around across the constitution entirely, in which it can very simply say that any part of the constitution which is violating a basic feature of the constitution can be subjected to judicial review. And therefore, this is something that is going to be a very clear explosion of the powers of the Supreme Court. That is what basically we take a look at in the form of the basic structure doctrine, Keshwananda Bharati case, in terms of its powers of judicial review. Okay, so let me do a quick revision for you here. If I am doing a concept called judicial review, class, now please pay attention to this. If I am taking a look at a concept called judicial review, the concept of judicial review can be classified into two dimensions. The concept of judicial review can be classified into in actually 4 dimensions. Okay, ordinary law, violating a fundamental right. Judicial review lies under Article 13, Clause 2 of the Constitution. Okay. So for example, let's say if I need to illustrate this, the case of electoral bonds was kept over here. Okay, section 377 of the Indian Penal Code is kept over here. These are the kinds of examples that we're talking about here. And if you take a look at this part, let's say for example, the landmark judgments of the Supreme Court, for example, the Minerva Mills case, okay, and let's say for example the NJAC case of 2016. These are the kind of cases in which the Supreme Court has struck down constitution amendments which have been subjected to questions on judicial review. So this is the entire diagram of the 4 ways in which judicial review can be subjected on what is activities which are relating to the lawmaking powers of the parliament. Okay, so if you want to take a very simple understanding of judicial review as a concept, judicial review as a concept deals with 4 categories, 4 subjects and topics. One, ordinary laws violating a fundamental right, which can be subjected to judicial review. So yesterday we had seen, day before we had seen, with regard to the electoral bonds, that the RBI Act, the RPA, the the Companies Act itself, all of these are amendments made to laws, not constitution amendment acts, but simple laws, ordinary laws made by the parliament, which ended up violating fundamental rights. Okay, so that is going to be subjected to judicial review right here. Electoral bonds case is an example of judicial review right here. And if you take a look at, for example, the NJAC case of 2016, in which Article 124A, you must be aware of this now, Article 124A, which created the NJAC, right? That article, when it was struck down as unconstitutional, that was done under the powers of judicial review given to the Supreme Court through the basic structure doctrine. Constitution amendment acts violating any other basic feature of the constitution, that was subjected in this particular manner. Are we clear? Do we understand the whole idea of what is a judicial review? And especially what happens is that after till the part of, let's say for example, till Keshavananda Bharati case, only these 2 powers of judicial review existed. Okay, they did not exist before the Keshavananda Bharati case. After the Keshavananda Bharati case, these powers of judicial review have also cropped up. These are evolved powers of the Supreme Court and the High Court. These powers did not exist in the original draft of the Constitution. Do we understand this point, class? Okay? Judicial reviews can be divided into subcategories like this, and this. It is over here, for example, we can take a look at landmark judgments like the Minerva Mills. So I'll come to this case a little further in the chronology of how things are happening. Understanding. So we have taken first Constitution Amendment Act 1951, class. First Constitution Amendment Act 1951. 24th and 25th Constitution Amendment Act 1971. This we have taken a look at, right? और इसके बाद हमने आसपास इसके judgments पढ़ लिए थे. ठीक है. Now let me take a very simple understanding. The next Constitution Amendment Act which becomes of any relevance is the act which is done by the Parliament in 1976. Okay, so it is the 42nd Constitution Amendment Act. This is the relevant one that was passed by the Parliament in 1976. that made 59 amendments to the Indian Constitution. Right? 59 new provisions were added to the Indian Constitution. Okay, some of these important 59 amendments to the Indian Constitution included, for example, in preamble, the terms socialist and secular were added. Okay, and also the unity and integrity of India. These were the terms which are added in the preamble in the 1976 Amendment Act. Okay. Then Article 31D was added, which was a draconian article which described what are known as the anti-national activities. And it gave the power to the police administration to punish those people who were involved in anti-national activities. Okay. Then Part 4A, in Part 4, Article 39A and 43A were added. ठीक है, ये वाले पार्ट्स ऐड किए थे 39A और 42A, मतलब आर्टिकल 39 and 42A, which means 2 new directive principles of state policies were added. Okay, and then of course you all understand this very clearly. Part 4A was introduced. Part 4A was introduced, which kept what you can call Article 51A. Out of Article 51A, what you have is the concept of fundamental duties. This was added in the 42nd Constitution Amendment Act 1976. Article 323A and Article 323B, as we have discussed last time when we were taking a look at this Swaran Singh committee report and everything, we had understood at the time, and we had how clearly correlated it, that the tribunal's creation was done directly to slide the judiciary, right? To sideline the judiciary and to take away the cases from the judiciary to the tribunals. Article 323A and Article 323B were added. Yes. And the last and the most important amendment was made to Article 368, Clause 4 and 5. Within Article 368, Clause 4 and 368, Clause 5 were added. Okay, which in a way produced a these are the most important amendments made to the parliament, made to what you can call the constitution, which wanted to amend the constitution. The 59 amendments to the Indian constitution, big and small, were added, and the 7 most important amendments added to the constitution in the 42nd Constitution Amendment Act 1976. By the way, you have to be mindful of the fact that the 42nd Amendment Act 1976 was passed by the Parliament which had received extension of 1 year during proclamation of emergency. Okay, so you just have to be a little mindful of this part slightly. 42nd Constitution Amendment Act 1976, Parliament which had received extension of 1 year during proclamation of emergency, and 59 amendments to the Indian Constitution were made by this categorization. The important ones are mentioned before you. Now, if you take a look at this part, let's say for example, the ones I'm taking with blue, they are still a part of the Constitution. Preamble is exactly the same. This is exactly the same. This is exactly the same. This is exactly the same. Okay. ये वाला जो part है ये omit हो चुका है. This part has been omitted, and this part has been struck down by the Supreme Court. (1980). This part has been struck down by the Supreme Court in the Minerva Mills versus Union of India 1980. The parts which I'm mentioning in blue ticks, this is basically still relevant. You may see some news in the recent times regarding the question on this part, socialist को अगर preamble में रखना चाहिए कि नहीं रखना चाहिए. There are petitions made before the Supreme Court, and there are also private members bill coming in the Parliament to answer the question whether socialist can be kept inside the preamble or not. Right, so that's basically one part that we have to take a little bit of an understanding of with regard to preamble, whether it is considered a part of the Constitution or not considered a part of the Constitution. Okay, this is the 42nd Constitution Amendment Act which we are taking a look at. और ये सारे Constitution Amendment Acts जुडिशरी को ही तोड़ने के लिए किए गए थे. Okay, so if you take a look at this, let's say Article 368 of the Constitution, just take an understanding of this. इसको एक बार पढ़िए. This is where you have Article 368 of the Constitution. These are the amendments which were made. These amendments to the Constitution were challenged before the Supreme Court in what is known as now the legendary judgment of the Supreme Court in Minerva Mills versus Union of India. And in this case, the Supreme Court had declared that Article 368 clause Article 368 clause 4 and 5 This is basically what is known as the Minerva Mills judgment, in which these two provisions of Article 368 clause 4 and 5 are struck down. That is why this judgment is a celebrated judgment in this entire setup and hierarchy. Okay. You see the point? Now, if you've taken an understanding of this class, see, these are the what you can say amendments. 59 amendments were made to the Constitution by the 42nd Constitution Amendment Acts, right? And largely most of them are amendments which have been made directly to hit the power of the High Court and the Supreme Court. So you see Article 226 amended, Article 226A, 227, 228, 228, 257. All these are provisions with relation to the High Courts. And again, there are provisions which are related to the Supreme Court also, which are amended. So this is basically how the amendments were introduced, and these amendments had a lot of negative impact upon how the judiciary's independence had to be functioned out properly, right? So when in 1976, after these things, after this whole kind of saga comes to an end, and the government of Indira Gandhi finally loses power, elections are undertaken, and the power is lost by Indira Gandhi's faction. The power goes to the Morarji Desai government. It is Morarji Desai government which bring about the two most important amendments to the Constitution, which are the 44th Constitution Amendment Act and 43rd Constitution Amendment Act, right? So the 44th Constitution Amendment Act and 43rd Constitution Amendment Act, what they do is they clean up the mess created by the Indira Gandhi Parliament, right? Whatever problematic provisions have been kept inside the Constitution by the Parliament governed by Indira Gandhi, they undo it. So they take a lot of these articles which are giving or taking away powers of the courts, etc., etc., and these articles are removed out of the Constitution. But the amendments which were made to the Constitution by Indira Gandhi, they have been removed out of the Constitution by this particular Amendment Act, 43rd and 44th Constitution Amendment Acts. right? And that's basically the legacy of it. For example, you can see Article 31D has been omitted by the 43rd Constitution Amendment Act, 44th Constitution Amendment Act, 43rd Constitution Amendment Act. So Article 31D, which talks about anti-national activities, has been removed. So all these articles which were inserted by the Constitution Amendment Act 42nd, which are of a problematic nature, they were both removed by the 43rd and 44th Constitution Amendment Act, right? And then again, if you see, for example, the provisions of emergency. So if I'm talking about two important amendments which were made by 43rd and 44th, and this I'll take in detail tomorrow, 1977 and 1978. Two most important things that were added by these amendments was, number A, that Article 19(1)(f), which contained right to property, was omitted. Okay, Article 19(1)(f), which talks about right to property, it was omitted and it was sent to Article 100A. Sorry, Article 300A, where the right to property was converted into a legal right as opposed to a fundamental right. सबसे पहला काम ये वाला हुआ था. And then the second thing that they had done was they had taken Article 352 and in place of armed rebellion as a ground, in place of internal disturbances as a ground for national emergency, in place of internal disturbances as a ground for national emergency, they had instituted what is known as armed rebellion. यहाँ पर आर्म्ड रेबेलियन लिख दिया था आर्टिकल 352 में, ग्राउंड फॉर प्रोक्लेमिंग इमरजेंसी. एंड अगेन सिमिलरली अंडर आर्टिकल 359, if you can call it 359, a condition was imposed by them. Under Article 359, a condition was imposed by them which stated that under 359 a condition was imposed by them which stated that fundamental rights given under Article 20 and 21 cannot be suspended even during the proclamation of an emergency. Okay, so these are the three most important amendments which were made by the 43rd and 44th Constitution Amendment Acts to the Constitution of India. Right to property was shifted to Article 300A and Article 19(1)(f) was omitted. Okay, 352 shifted internal disturbances to armed rebellion, and 359, which talks about the what you can say suspension of fundamental rights during emergencies, gave the point that under Article 20 and 21, even during an emergency, Article 20 and 21 of the Constitution cannot be amended. This was what you can call in a way, reinforcement of the judgment given by Justice H.R. Khanna in the ADM Jabalpur case. In ADM Jabalpur case, Justice H.R. Khanna was the one to give the minority judgment, saying that Article 20 and 21 cannot be suspended during an emergency, but the majority judgment gave the opposite verdict, saying that all fundamental rights can be struck down in an emergency. In this case, the Supreme Court had given a bad verdict but a good minority judgment. This minority judgment was codified by the 44th and 43rd and 44th Constitution Amendment Act 1977 and 1978 in this categorization. Yesterday we were taking a look at the concept of judicial review. Right, so we are trying to take an understanding on the concept of judicial review with the the understanding of the amendments to the constitution, right? So yesterday we had taken a look at few of the amendments made to the constitution, into the constitution. As we were taking a list of those important amendments, we had finished off certain important ones, and these are the ones that we're going to take a look at how prelims questions can be asked out of that. We have the first Constitution Amendment Act 1951, which introduces Article 31A and 31B into the Constitution. Right? First Constitution Amendment Act, which introduces Article 31A and 31B into the Constitution. The effect of this amendment is to what you can call overcome judicial challenges on land reform laws which may violate fundamental rights. Do we understand this? First Constitution Amendment Act 1951, 31A, 31B, overcome judicial challenges on land reforms laws which may violate fundamental rights. So this is the first item that we had covered yesterday. Okay, so I'm just putting it in a summary for your prelims examination to be in focus. Then we took a look at how, for example, you have the second part, which is the Shankari Prasad Deo versus Union of India judgment. In the Shankari Prasad case, we had seen that the Supreme Court had given the verdict that laws under Article 13 Clause 2 do not include law made under Article 368. This was what was said by the Supreme Court in the Shankari Prasad case of 1951. So this is the first landmark judgment that we take a look at, right? Similarly, let's say, for example, we can take an understanding now in relation to this concept, which is, for instance, how the Supreme Court has dealt with the same case in the matter of Golaknath judgment. The Golaknath case, as we had described it yesterday, 1967, overturned Shankari Prasad, right? It overturned Shankari Prasad. Overturned Shankari Prasad and held that laws under Article 368 are covered under Article 13 clause 2, which means judicial review on constitution amendment acts, judicial review on constitution amendment acts that violate fundamental rights is applicable, right? This was what the judgment of the Supreme Court was in the Golaknath case. Okay, then in the next part you have what is known as the 24th Constitution Amendment Act and 25th Constitution Amendment Act, right? This we had taken a look at in 1971, which was done to overturn the Golaknath case, right? So this was done to overturn the Golaknath case. The parliament wanted to overturn the Golaknath judgment, and in which the parliament had written that you have section 13 clause 4, you have section 368 clause 3, and you have section 31C. These were introduced inside the constitution by the 24th and 25th Constitution Amendment Act 1971. After that we see very clearly and particularly how, for instance, we have next part is after the Shankari Prasad Golaknath 24th and 25th Constitution Amendment Acts 1971, we have what is known as the Keshwanand Bharti case. And it was in the Keshwanand Bharti case that we had discussed yesterday the concept of the basic structure of the constitution was for the first time established, and the details of the basic structure doctrine we had seen very clearly and categorically. Okay, and then we see how, for example, you had the 42nd Constitution Amendment Act 1976. This was the most dangerous and the most elaborate of them all, which was supposed to overturn the Keshwanand Bharti case, right? And this 42nd Constitution Amendment Act 1976 eventually leads to a lot of introductions in the constitution. Article 31D was introduced, preamble was amended to introduce socialist and secular, Article 51A was introduced, Article 323A plus B was introduced, etc., etc. So we had taken a list of these amendments, and after that we had taken a look at what are known as the 43rd and 44th Constitution Amendment Acts, right? This was the amendment made to the constitution to fix the constitution against the activities of the Indira Gandhi amendments. And the most important provisions of these amendment was 19(1)(f) was deleted and made to come under Article 300A. Then there was Article 31D was deleted, Article 352 and 359 were amended, amending the provisions of emergency. Okay, you see the point? And then in addition to that, we had taken a look at, in point number 8, what we are taking a look at is how the Minerva Mills case talks about Article 368 clause 3, clause 4 and 5 was declared as unconstitutional under the basic structure doctrine. So this was the first case in which the basic structure doctrine was actually applied by the Supreme Court. That is why it is such a landmark case. that the first time this basic structure doctrine was applied by the Supreme Court was in the Minerva Mills case. So you can take a look at this chart to understand the important amendments and the literature around those amendments, which is supposed to be a part of the context of the amendments to the Constitution. Right. So I hope you get a sense of this and what I'm trying to point out as a particular activity over here. Right. Just take a look at this chart, and this is going to be all your what you can say uh, literature that you need for answering a question from the prelims examination in the context of what the amendments are supposed to be and like in these matters. Okay, just take a look at these, class. ओके, थोड़ा और टेम्परेचर ठीक कर दीजिए इसका. Okay, clear, class? So yesterday when I was showing you, for example, the example that we were taking a look at yesterday was on this front, as we were taking a look at the paper UPSC had made in 2023. This is the kind of question that you can now attend from what we are taking a look at. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of fundamental rights? Okay, this is the kind of question that you should be able to deal with the data that we are supplying in this particular class. Okay, ये वाला जो point है इसको आप समझ सकते हैं. The question number 34 as it goes. Okay, तो अब जैसे for example मान के चलिए, let's say if I kind of alter this question a little bit, if I meaning take a little bit of an alteration to this question, and if I instead of this question say enacted to overcome the judicial interpretations of the basic structure doctrine, if I do this kind of a alteration to this question, then what becomes the correct answer? The correct answer then would be 42nd Constitution Amendment Act. Okay, these are the questions that UPSC has been asking for the last 2-3 years. And what we are doing with the list of amendments that we are understanding over here and taking them into consideration is the 42nd Constitution Amendment Act is going to be a kind of an answer if you are writing the question like this to overcome the judicial interpretations of the fundamental instead of fundamental rights you have the basic structure doctrine that we are going to take a look at. Clear? Take it so you get a sense of this. Now if I move on, for example, in the list of important amendments, if you take a look at the list of important amendments after 1980, amendments which are supposed to be made a list out of, then on the top of it we are taking a look at what is known as the 85th Constitution Amendment Act. 52nd Constitution Amendment Act 1985. 52nd Constitution Amendment Act 1985 we have already covered in some extent. '52nd Constitution Amendment Act 1985 we have seen introduces the 10th schedule to the Constitution. So we have covered this previously. The whole idea of a 10th schedule, etc., etc. We had covered it properly. Okay. So this is the 52nd Constitution Amendment Act. Then in addition to this, we can take a look at what are known as the 73rd and 74th Constitution Amendment Acts. Right? These are the ones which we can get a sense of. 73rd and 74th Constitution Amendment Acts. That's basically what we are going to take a look at, right? Now, what we take a look at, for example, in the 73rd Constitution Amendment Act, if you take a look at the statement of objects and reasons for introducing this part into the Constitution, which is the 73rd Constitution Amendment Act, what you see is basically in the 73rd Constitution Amendment Act, you have the institution of Panchayati Raj institutions, which is making part 9 of the Constitution. Relevant, right? So you have the part 9 of the Constitution was instituted in the Constitution by the 73rd Amendment Act, which introduced what are known as the Panchayati Raj institutions, right? So you can take a look at the respective points. Article 40 of the Constitution, which is a directive principle of state policy, enshrines one of the directive principles of state policy, lays down that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. In the light of the experience in the last 40 years, and in view of the shortcomings which have been observed, it is considered that there is an imperative need to enshrine in the Constitution certain basic and essential features of Panchayati Raj institutions to impart certainty, continuity, and strength to them. Right? So the edifice of creating Panchayati Raj institutions through the Constitution itself was created by the 73rd Amendment Act, and therefore you have the whole idea that certain seats were reserved for the scheduled caste and scheduled tribes in proportion of their population for membership of the panchayats and the office of chairpersons in panchayat at each level. And also you had the first time reservation of women in seats in the panchayat elections. So that is what basically we're going to take a look at in terms of understanding it from a prelims perspective. It is to introduce part 9 to the Constitution, which is dealing with the Panchayati Raj institutions. 73rd and 73rd Constitution Amendment Act, which deals with the Panchayati Raj institution. Right? This is basically what we have to remember. In terms of a prelims question, अगर आपसे क्वेश्चन पूछा जाता है कि यहाँ पर इस अमेंडमेंट के माध्यम से संविधान के अंदर क्या नया पार्ट लगाया गया था, the answer is 73rd Constitution Amendment Act made in 1992 inserted part 9 to the constitution, which talks about the Panchayati Raj institutions. Similarly, if you take a look at the 74th Constitution Amendment Act, we are talking about urban local bodies, or what are known as the municipal corporation, right? So you have in the 74th Constitution Amendment Act introduced article part 9b of the constitution, by the 73rd Constitution Amendment Act you have introduced part 9b to the constitution, and part 9b to the constitution is talking about what is called as the constitution of three types of municipalities. Okay, Nagar Panchayats for areas in transition from rural to urban areas, municipal councils for smaller urban areas, and municipal corporations for larger urban areas. Right, so this is basically what is covered under the chapter of municipalities. Okay, so basically just to give a brief understanding of these important amendments, right? I'm sure that you've covered all of these things in your foundation classes. So from a kind of a very simple prelims perspective, 73rd and 74th Constitution Amendment Acts are dealing with the institution of Part 9 of the Constitution, which deals with the Panchayati Raj institutions. And Part 9A, which deal with what are known as the municipalities. Okay. Right, so I hope you understand this properly. 73rd and 74th Constitution Amendment Acts, which are made in this particular regard. Okay. As you have seen later on, for example, if we take a look at, in this instance, the 97th Constitution Amendment Act 2011, we have already taken a look at. 97th Constitution Amendment Act introduces the Part 9B to this chapter, which is on local governance, and we have the creation of what are known as the cooperative societies. तो cooperative societies तो हमने करा दिया है आप लोगों को अच्छे से. The concept of cooperative societies we have done properly in the classes over here. Okay, so 97th Constitution Amendment Act 2011, you have the cooperative societies, which we have taken a look at. Okay. The other important amendments that we can take a look at, just to get a sense of the ones which are relevant from the perspective of the exam, is of course the 102nd Constitution Amendment Act 2018. 102nd Constitution Amendment Act 2018 is important from the perspective of creating Article 338B plus Article 342A, which talks about what are known as National Commission for Backward Classes, was made into a constitutional body. Right. It establishes a constitutional body by the name of National Commission for Backward Classes. And powers are divided between the state and the center on OBC classification. Okay. 102nd is this. Then you have 103rd Constitution Amendment Act 2019, by which Article 15 Clause 6 and 16 clause 6 were inserted in the constitution to create what is known as the EWS quota. Okay, so these are the ones that I'm identifying important for the prelims examination this year, which is basically what we are trying to get a sense of in terms of understanding this properly as a sense that is going to be relevant for the prelims examination this time. Okay, 52nd Constitution Amendment Act, 73rd and 74th Constitution Amendment Act, 97th Constitution Amendment Act, 102nd Constitution Amendment Act, and 103rd Constitution Amendment Act. Okay, do you get a sense of this, class? ठीक है, एक जो बात है 101st Constitution Amendment Act which talks about the goods and services tax, I'll deal with in a specific manner. So we'll take a little bit of a look at the GST Council and all that, all those things today. तो थोड़ा सा उस पे हम फोकस करेंगे आज, तो उसको मैं अलग से डील करूंगा. The 101st Constitution Amendment Act. ठीक है, चलिए. Now, if I am going to just pay a little bit focus upon the next part that I'm going to cover. I want to touch a few technical parts of the Constitution which are related to fiscal federalism. Okay, these are some tricky parts of the Constitution which are related to the fiscal federalism, and within this tricky part, I want to also cover the institution of the first 101st Constitution Amendment Act 2016. Okay, this is the one that I want to focus a little bit of an attention upon, which is the creation of what is known as a goods and services tax, GST. Okay, so this is going to be one of the most important aspects that we're taking a look at today in terms of understanding how these activities are supposed to happen. Okay, the 101st Constitution Amendment Act 2016, and the chapter that I will give to this one is what we're going to take a look at by the name of fiscal federalism. ठीक है, तो आज जो एक बहुत अच्छा खासा बड़ा चैप्टर जो हम लोग करेंगे क्लास के अंदर, उसका नाम है फिस्कल फेडरलिज्म, और इसको हम एक और नाम से भी जानते हैं. दिस चैप्टर कैन बी नोन बाय अनदर नेम आल्सो, व्हिच इज नोन एज डेवल्यूशन ऑफ फंड्स बिटवीन center and states. The concept of fiscal federalism can also be understood by another term which is known as devolution of funds between center and states, right? Or what is basically known as the financial planning in which this kind of an activity can work out. ठीक है, चलिए अब इसको थोड़ा सा देखेगा फिस्कल फेडरलिज्म में हमको क्या क्या करना है. We are going to again divide the chapter of class. Now let's get ready for some movement here. We're going to divide the chapter of fiscal federalism into again two portions. One is going to be the static portion, and the other is going to be what are known as the current updates on these matters. ठीक है. So we'll take a look at the static portion on fiscal federalism, and also we'll take a look at the current updates which are going to be relevant on these question answers. ठीक है. Now just take a look at how we'll deal with it. In the static portion, we'll deal with Article 265, which are laws on taxation. Okay, Article 266, which is the Consolidated Fund of India. Article 267, which is what is known as the Contingency Fund of India. So we'll pay a little bit of an understanding of what is the Consolidated Fund of India and the Contingency Fund of India. Okay. Then we'll take a look at what is known as the Article 279A, which is the GST Council, and we'll take a look at Article 280 plus 281, which is the constitutional body by the name of Finance Commission. And also, for example, the recent report of the Finance Commission is in somewhat of a controversy because of statements made by certain chief ministers. For example, the chief minister of Karnataka has made statements against the Financial Commission. You have the government of Tamil Nadu also making statement against the report of the Finance Commission. So we'll just take a look at this bit of a part over here, and then we'll take a look at Article 282. Article 282 is what is known as the concept of the origin of the concept of what are known as the centrally sponsored schemes. ठीक है, ये तो पूरा फिस्कल फेडरलिज्म में हम ये कहेंगे. ठीक है, और इससे करंट अपडेट्स में व्हाट वी आर गोइंग टू डू इज, नंबर 1, we'll take a look at on the current update aspect. We'll take a look at what is known as the GST issue. या फिर इसका हम just let me just give this point. GST compensation cess. What has been the issue between the government of India and the government of state upon the GST compensation cess? This has been in news for at least 4 years now, and even this year this has been in news, and this is one of the things that has not come in the paper yet. So we are expecting some kind of a movement or activity is going to be there on this particular aspect with regarding the GST compensation cess properly. Okay. Next thing that we're going to take a look at is a judgment of the Supreme Court on the GST Council. एक सुप्रीम कोर्ट का जजमेंट आया जीएसटी काउंसिल के ऊपर, which is a landmark judgment which has made a lot of waves in the recent times about this thing. ठीक है, and then we'll take a look at slightly the Finance Commission reports. That are in the recent times and the recommendations of the Finance Commission which have made some amount of current affair headlines in the recent times. ठीक है, तो इसको थोड़ा सा देखेंगे with regard to how the Finance Commission has become an important element in terms of deciding how these activities are supposed to be decided. क्योंकि Finance Commission का अभी अगर आप देखें, if I just do a little bit of a simple Google search of this part, These are the kind of current updates that we are going to take a look at. Cabinet clears terms for the reference for the 16th Finance Commission. We've already seen the recommendations of the 15th Finance Commission in action, and that's basically what we are going to take a look at. The Finance Commission's recommendations would cover 5-year period commencing from April 1 to 26. Union Cabinet approves terms of reference of a panel including recommending formula for sharing revenues between center and states, right? So this is the kind of news that has developed with regard to the Finance Commission and the Finance Commission report, which has been in news recently. Right, and this is the kind of newspaper article that we'll take a look at in terms of understanding the role of the Finance Commission, etc., etc. ठीक है, तो इस पर थोड़ा सा ध्यान देंगे हम लोग. We'll just go in some technical detailed matters, and this is a huge repository of questions for the prelims examination. Every year you'll find some of the other question converging on the lines of polity and economy to be able to understand questions about the Finance Commission. Okay, so let's start this part of the subject and get a sense of all the clarities that we are looking at in this aspect. Okay, now let's begin. If I talk about, let's say for instance, the concept of what is known as the Consolidated Fund of India. Now class, please pay attention to all these parts clearly. Okay, if we take a look at this very simple idea of what is known as the Consolidated Fund of India, and I think in some way or the other I have already drawn this diagram before you when I was dealing with the electoral bonds cases. Consolidated Fund of India. Class, you're going to expect a question from the Finance Commission this time, because the Finance Commission has been constituted in the year 2023, and the Finance Commission is constituted once in every 5 years. So this is a kind of a very relevant current update. A commission which is instituted once in every 5 years has been instituted, and that is basically the reason why we are taking a look at the movement of the Finance Commission more properly. Okay, in addition to this, we are also going to ensure that you are able to cover questions like this. We are looking at, let's say for example, the GST Council judgment by the Supreme Court. Supreme Court's GST verdict. Okay, take a look at this. Pronouncing its verdict in a protracted dispute over the levy of goods and services on ocean freight charges paid by importers, the Supreme Court Thursday held that such a tax was untenable. Its 153 judgment has also dwelt length of the nature of the recommendations of the GST Council, the constitutional body set up to oversee the operations of indirect tax regimes. Invoking the spirit of cooperative federalism, the court has held that both the union and the state legislatures have equal and simultaneous and unique powers to make GST laws, etc. etc. तो ये GST काउंसिल के ऊपर बहुत बड़ा जजमेंट सुप्रीम कोर्ट का आ रखा है, जिससे कि आपका पूरा एक क्वेश्चन बन सकता है. और इसके अलावा we have a huge amount of material to cover in what is known as a GST compensation cess. ठीक है, पिछले 4 साल से ये बार बार न्यूज में आ रहा है. Right, so this is basically what is the news with regard to the GST compensation cess. तो इसको थोड़ा सा हम कवर करने की कोशिश करेंगे. इन तीनों चीज़ों में से, फाइनेंस कमीशन में से, सुप्रीम कोर्ट के जजमेंट में से और GST compensation cess में से, you are easily expecting a question or two in the prelims examination this time. ठीक है, चलो let's begin. Let's get a very clear and proper sense of what we are noticing in this regard. Okay, class, take a look at this. this is what you can call the Consolidated Fund of India, as we were discussing. The Consolidated Fund of India is marked under Article 266 of the Constitution. Okay. As you can see, the Consolidated Fund of India is the place from where the money is taken from the people of India in the form of revenue, and it is deposited in the Consolidated Fund of India. Money is taken from the people of India in the form of revenue, and it is deposited in the Consolidated Fund of India. And similarly, money is taken out from the Consolidated Fund of India and given to the Government of India for the expenditure that is basically going to be taken up by the Government of India. This much we have understood as to how the Consolidated Fund of India works from our previous readings of the matter. Okay. Now, in addition to this part, we are taking a look at the fact that the Consolidated Fund of India is guarded by the Parliament on both the ends. Right? The Consolidated Fund of India is guarded by the Parliament on both the ends. Money cannot be taken inside Consolidated Fund of India. Class, now let's focus upon this part. We have to develop this particular aspect in a clarity. Money cannot be taken from the people of India and put inside Consolidated Fund of India, nor can be money taken from the Consolidated Fund of India and given to the Government of India without the permission of the Parliament. Right? So here we have, for example, a few sections that articles you have to understand. You have Article 265 of the Constitution. Article 265 of the Constitution says taxes cannot be imposed except by the authority of law, which means that taxes cannot be imposed except the fact that the state legislature has, or state legislature or the union legislature, the parliament and the state legislative assemblies, they have given a thumbs up to the taxation regime. Right? In that sense, taxation cannot be improved. And then we have seen, for example, over here, Article 266, Clause 3. It says that money cannot move out of the CFI except by authority of law. Okay, please take a look at this, class. Just try to understand the sense of this argument here. Now, once you have understood this diagram, let me take you through a very simple kind of a characterizing feature of this entire activity. When we take a look at, for example, Article 265 of the Constitution. Article 265 of the Constitution says very simply this, that no tax in the country, Article 265 of the Constitution says that no tax in the country can be imposed except by the authority of law. This is what Article 265 says. What does this imply? It implies, number one, that only laws made by the Parliament or state legislatures can impose taxes. This is what Article 265 says in point number 1. Only laws made by the parliament or state legislatures can impose taxes. Taxes can only be imposed upon the people of India by making a law. The government cannot itself, for example, the Ministry of Finance or the Ministry of Commerce and Industry or any other ministry for that matter cannot impose its own taxes. Taxes can only be imposed upon the people of India by the parliament or by the state legislature. So a very natural question that comes to our mind is, what are the subjects upon which parliament can impose taxes and what are the subjects upon which state legislatures can impose taxes? That's the relevant question that can come to our mind now. Okay, so how are the question that we're asking is, how are the powers of the, now class, let's get gearing up. How are the powers of the parliament and the state legislatures? How are the powers of the parliament and the state legislatures divided in terms of taxation? That's the question that you ask. Okay, and the answer to that question is that these powers are divided according to the 7th schedule, right? The answer is, under article, the parliament has the power to impose taxes upon the subjects mentioned in the union list of the 7th schedule. Okay, please take a look at this very clearly and openly. The parliament has the power to impose taxes upon the subjects mentioned in the union list of the 7th schedule. Parliament has the power to impose taxes upon the subjects mentioned in the union list of the 7th schedule. Right, this is the first thing that we come across as a question. And then another set of answer which can be given to this is, the state legislatures have the power to impose taxes on the state subjects of the 7th schedule. This is how the simple basic premise of what Article 265 and the collection of taxes by the parliament and by the state can be understood. You see the point? This is what basically we are taking a look at. If you take a look at Article 265 of the Constitution, Article 265 of the Constitution says no tax in the country can be imposed except by the authority of law, which means that only laws made by the parliament or state legislatures can impose taxes, right? So what does it imply? It implies that it is not in the authority of the government of India to ask for taxes. Government of India, you understand, for example, from a very simple variation of what are known as the concept of separation of powers. When you link it, let's say for example, when you think about it as a concept of separation of powers, you know that there is a division between the Parliament of India and the Government of India, between the state legislature and the state executive. There's a very clear division between two activities, the Parliament of India and the Government of India, the state legislature, state executive. There is a very clear cut division between these two entities, right? Are we sure about this? Now take a look at the point that I'm trying to make. The Article 265 very clearly says that a tax which is to be imposed can only be imposed by the legislative organs of the state, not by the executive organs of the state. Okay, so only legislative organs of the state can actually impose taxes. Executive organs of the state cannot impose taxes. That is what Article 265 very clearly states, in which what it says is that no tax can be imposed except by the authority of law. It is only the legislative organs that can, in a way, impose taxes, and not the executive organs. Executive organs cannot impose taxes at all. That is what Article 265 of the Constitution says. No tax can be imposed except by the authority of law. Right. So that's one thing that you have to very clearly understand and be mindful of. That's the first part. Okay. Second part that we understand is that if, for example, taxation has to be taken from the people of India, right? If people of India are supposed to pay the taxes to the government of India, then the question is, how do you divide this between the union government and the state government? Let's say, for example, the entire tax collected from the territory of India in one financial year is rupees 100. Then the question that we're trying to ask is, how do we decide that out of 100 some amount is going to go to the union government and some amount is going to go to the state government? That's the question basically we want to ask. This is basically the question of what is known as a fiscal distribution between the government of India and the state government. That's the question that we are trying to address over here, right? So what is the nature of the question? The nature of the question is, if, for example, we have a tax pool of rupees 100 coming from the territory of India. Okay, so let's say, for example, the entire tax raised from the territory of India in one financial year, entire tax raised from the territory of India in one financial year, entire tax raised from the territory of India in one financial year is rupees 100. Okay, so this is people of India has paid the tax. Now the question is, the Indian Republic is of course divided into two headers. One is the union government, the other is the state government. So the question that we're basically asking is, how is 100 distributed between the union of government, right? What kind of a formula is applied? 50-50 formula? Ki 50-50 goes to the union government and the state governments. Does everything go to the union government and the union government gives some amount of it to the state government according to its own consideration, or whatever? What is the formula by which fiscal distribution happens? How do the states and the union share their tax incomes? That's basically the question that we're asking. And the answer to that question is given under Article 265, within Article 265 to 279, which says that the Parliament has the power to impose taxes upon subjects which are mentioned in the union list, and the state legislatures have the power to impose taxes on the subjects which are mentioned in the state list. Okay, that's basically the answer to the question. So let's say, for example, I might take a, let's say, just imagine something like this. This is a person, let's say this is the entire territory of India. This is the state of Karnataka. Okay, recently a news had come that the finance minister had thanked the people of Bangalore for keeping a tax buoyancy, right? Say, let's say, for example, within Karnataka, this is Bengaluru. Okay, this is Bangalore, right? Now let's say, for example, imagine a situation that a person works in an insurance company located in Bangalore. Okay, you see the point? Let's say, for example, if this is Mr. Vijay. Mr. Vijay is born in Bangalore. He's born in Karnataka. He's a Kannada, right? He speaks the Kannada language very fluently. He speaks some amount of English and Hindi also. If Mr. Vijay is working in an insurance company in Bangalore, let's say, for example, he's working as a senior executive in Max Life Insurance, which is registered in Bangalore. Okay, so he's working in what is known as the insurance sector, right? Now, let's say, for example, if Mr. Vijay is earning 50 lakh rupees, if the total amount of money which has been earned by Mr. Vijay is 50 lakh rupees, okay, in one financial year, and he's paying, let's say for example, 30% income tax on this money. If Mr. Vijay is earning 50 lakh rupees in one financial year and he's paying 30% income tax upon this money, right? The question that we are asking is, where does this income tax money go? Okay, where does the income tax money go? This amount of money, does it go to the consolidated fund of India or does it go to the consolidated fund of the state of Karnataka? Class, what do you think is the answer? Does this money go to the consolidated fund of India or does this money go to the consolidated fund of Karnataka? What is the answer here? If Mr. Vijay, who's staying in Karnataka, who is residing in Bangalore, who is working for a Max Life Insurance, if Mr. Vijay is living in Karnataka, all his life he's lived in Karnataka and he's a Kannada, what do you think is going to be the answer to the question? That if he pays 30% on 50 lakh rupees income as income tax, does this money go to the finance minister of the union or does this money go to the finance minister of the state? That's the question that I'm trying to ask you. Does this money go to the finance minister of the union or does this money go to the finance minister of the state? What is the correct answer to this question, class, is what I'm asking. The answer is union. And the question is, why union? And the answer is because insurance is in the union list. Of the 7th schedule, because insurance as a subject is in the union list of the 7th schedule. Insurance as a subject is in the union list of the 7th schedule, right? And for that reason, what we are saying is that the government of India will have the claim upon the taxation. Now, please be mindful of the fact that Mr. Vijay is residing in the state of Karnataka. He is, let's say for example, very pro Kannada himself, okay? But nonetheless, the income that he is going to earn is going to go to the Union of India. It is in Delhi that his income would be consolidated into the tax and the money is going to go in the consolidated fund of India. Right, class? Do you get a sense of this? Class, are we getting a sense of this? Right? So, if you take a look at very simply the statement that I'm trying to make over here, how are the powers of the parliament and the state legislatures divided in terms of taxation? मतलब state legislatures की और parliament की powers taxation के basis पे किस तरह से divided है? And the answer is, parliament has the power to impose taxes upon subjects mentioned in the union list 7th schedule, and state legislatures have the power to impose taxes on the state subjects of the 7th schedule. So for example, let's say if I take a look at this newspaper over here, this kind of a article that came. Take a look at this. The Union Minister of Finance hailed Bangaluru's taxpayers for their contribution in the building of the Viksit Bharat and said the tech capital is home to the income tax department's faceless assessment of the entire country. Okay. This is what basically she's saying, that we are able to maintain our tax buoyancy because the kind of income tax which is being paid by the people of Bangalore, right? So you see the point. Now, why is this being said? Because all the industries which are operating in Bangalore, which is in the state of Karnataka, all the industries which are operating in the state of Bangalore, in the state of Karnataka, are mentioned under the union list, right? So for example, let's say I take entry number 47 of the union list. You can see insurance. Now, every person who's working in the insurance sector in Bangalore and earning income out of the insurance sector of Bangalore is going to pay the taxes to the government of India, not to the state government of Bangalore, not to the state legislature or the state executive, but to the union government. The money shall go, right? And that money will be taken by the union government, right? So by this, what we understand is that all the subject matters which are given under the union list, all the citizens of India, be it from any part of the country, any state of the country, they will pay taxes in the coffers of the Union of India. You see, that is basically where the sum comes and consolidates in the consolidated fund of India. And similarly, if you take a look at the next part, which is the taxations which are paid by the states, right? So if you take a look at the state list, for example, you see this is the state list. Okay, if you take an item from the state list, let's say if I take let's say if I take the concept of electricity, if you pay your electricity bill, and if there is certain amount of indirect tax that you have to pay to electricity, let's say for example you get a electricity bill, and on that electricity bill there is a kind of a tax which is attached to it, associated with that kind of a tax shall be paid by the state government, by the consumer of the electricity, to the state consolidated fund. Okay, so for example, even liquor is a part of the state, intoxicants are a part of the state thing, and therefore the let's say for example taxes on lands and buildings is a part of the state, agricultural income is a part of the state, duties in respect to succession to agricultural land, estate duty, treasure trove, all of these things which are basically, let's say, betting and gambling. For example, if you take a look at something like let's say a kind of an online betting thing, right? Dream 11 or something. Any kind of a tax which is paid by these companies or people working in these companies is to be paid directly to the state government, etc., etc. Right? So the question that I'm trying to understand over here is that if you have the final collection of 100 rupees as taxes, if you are collecting 100 rupees as taxes from the entire what you can say territory of India, the question is how are these 100 rupees divided between the union and the states? And the answer to that question is that they are divided according to the 7th schedule. Whatever is given in the 7th schedule in the union list shall be taken up by the union, and what is given in the 7th schedule by the state list shall be taken up by the state. This is how the division of taxes is determined by these activities, is what we are trying to understand in this particular nature. Are we clear, class? Do we have a clear understanding of this? So the first point of fiscal federalism, for example, if I have to write a simple proposition describing the concept of fiscal federalism, now federalism you understand is the relationship between the union and the state. Okay, then I can write this kind of a statement to get a clear vision of what fiscal federalism is. The first statement that I can write in respect of fiscal federalism is that taxes upon their respective subjects as mentioned under the 7th schedule. Okay, taxes upon their respective subjects as mentioned in the 7th schedule in 7th schedule are imposed by the parliament and state legislatures respectively. You see, do I make a sense of this statement, class? Are we clear? Please take a look at the statement if you get a sense of what I'm trying to make over here. Okay, so in this way, we get the first proposition of what is known as the fiscal federalism and the policies which are associated with fiscal federalism. Article 265 of the Constitution comes into action over here. So we get a kind of a statement building upon a simple concept that first of all, if this is the territory of India and taxes are to be imposed upon the territory of India, if this is the territory of India and taxes are to be imposed upon the territory of India, then taxes can be imposed by two levels of government, Union of India and the government of the state. These two taxes can be imposed upon the subjects which have been given to them by the Constitution under the 7th schedule. Class, am I making my point clear? These two taxes are imposed by the state legislatures and the union legislature only. It cannot be imposed by the government because Article 265 of the Constitution says that it is not the government of India nor the state governments which can impose any taxes. The taxes can only be imposed by the union legislature and the state legislature. The imposition of taxes is supposed to be an entirely legislative act. It is to be done only by the authority of law. Law is a point which is created by the legislature. Therefore, we are talking about legislative activities which create taxes. And then again, the question is, if the state legislature can create a tax, it can only create a tax upon the subjects mentioned in the state list of the 7th schedule. On the other hand, if the union legislature is creating a tax, it can only create a tax on the subjects mentioned in the union list. Class, hope I'm getting the point across clearly. And therefore, can you see the cracks or the division which has been made upon the public's money as divided between the union and the state, and how the union, for example, if I am a citizen of India, but I am also a citizen of the state of Madhya Pradesh, then I am paying tax out of my pocket. Some amount of tax is being given to the Union of India. The other amount of tax is going to be given to the state of Madhya Pradesh, right? And the way that this line is constructed is basically the question of fiscal federalism. How is it that the taxes given by the people of India are divided between the two levels of government, the union government and the state government? That is the question, basically, what we understand in terms of what is a fiscal federalism. Class, are we there? Do we understand this point clearly? Okay, this is one simple statement which comes at the heart of fiscal federalism. Taxes upon their subjects, as mentioned under the 7th schedule, are imposed by the parliament and the state legislatures respectively. Please be sure that you note the term state legislatures with some amount of understanding. It is not the state executive but the state legislatures, and it is not the union executive but the union legislature, which is the parliament, which can create those taxes, right? So I'm hoping I'm creating a vision in your mind as to how the taxation activities are supposed to take place, right? Pool of money coming from the people of India divided into two categories, one which goes to India, one which goes to my state. Okay, now here's a point. If you want to have a point of reference to understand this part very clearly, you can take a little bit of a thought experiment around it like this. Let's say I have 100 rupees. Let's say, for example, if I am paying a tax of 500 rupees, okay, entirely, if my monthly or my annual tax is 500 rupees, I pay taxes of 500 rupees in 1 year. Okay, let's say 300 of these 500 rupees I am giving to India, which means 300 rupees are being given by me to India. What do I mean by that? That these 300 rupees can be taken by the government of India from me and they can be given to a person in a very far off state. Okay, so for example, imagine situation like this. I am in the state of Madhya Pradesh. Okay, I give taxes upon the consumption of certain things which are in the union list. Okay, now if I am paying those taxes to the government of India, the government of India can take that money and invest that money in the state of Manipur. You see the point? This is basically what a union tax looks like. It is a tax which can be invested by the government of India anywhere in the territory of India. You see the point? So, one percentage of my tax I am taking out in the name of the entire nation. I may be in Himachal and I am paying tax, and the government of India, having taken my tax money, can pay that money to someone in Kerala. This is the nature of the union taxes. Okay, whereas the other kind of a tax where I'm putting a tax upon the state subjects, then for example, if I'm a person in Uttar Pradesh and I'm paying a tax upon a subject which is in the state list, which is collected by the government of Uttar Pradesh, then this tax is going to remain in the state of Uttar Pradesh. This money will be invested in the state of Uttar Pradesh only. Do you see the point? And if, for example, lower down I go, if a tax is imposed by a municipality or a panchayat, then that tax will remain within that municipality or a panchayat only. This is again the structuring that I'm creating for understanding the concept of fiscal devolution. Class, am I making my point clear somewhat over here? Okay, so the tax that I'm paying as a citizen of India to the Union of India is going to rotate anywhere in the territory of India. The tax which I'm going as a citizen or a resident of a particular state is going to rotate within that state only. And then lower down you have at the local level, right? So in that sense, the taxation structures are divided between the union and the states. Okay, so that's basically what we take a look at. Now the reason, for example, I am going to just elaborate to you the concept of what is known as the Consolidated Fund of India, as it is given under Article 266 of the Constitution. Okay, Consolidated Fund of India. When we take a look at the concept of Consolidated Fund of India, first of all, what do we mean by the term consolidation? How do you understand the concept of consolidation? What is the idea that is behind the concept of consolidation? Consolidation basically means, let's say for example, if I take, imagine a situation like this. If I take, let's say for instance, let's say for example, if I want to develop a clay toy, ठीक है, एक मिट्टी का खिलौना I want to develop, ठीक है, I want to take clay and I want to develop a toy out of it. Okay, अब मान के चलिए मैं अलग अलग जगह पर गया. Okay, I go to one place, I go to another place, I go to another place, I go to another place. ठीक है, ये जो चार प्रकार के, ये आप सोचिए जगह से गया. ठीक है, और यहां से मैंने अलग अलग प्रकार की क्ले लेके आया. Right, so you have clay number 1, you have clay number 2, you have clay number 3, and you have clay number 4. ठीक है, तो we are getting, let's say for example, the 4 kinds of clay, right, from different parts of the country. ठीक है, अब मान के चलिए कि मैंने इन सारी क्ले को एक साथ जोड़कर एक बड़ा पीस बना दिया. लेट्स से फॉर एग्जांपल, आई टेक ऑल दिस क्ले. इस मिट्टी को मैंने अलग अलग जगह से लेकर आया, उस मिट्टी को मैंने थोड़ा सा पानी डाल के प्रॉपरली बांध कर एक बड़ा सा वो बना दिया मैंने, इसका लंप. यू सी द पॉइंट? नाउ दिस इज व्हाट आई कैन कॉल फॉर एग्जांपल सॉलिड. सो व्हेन वंस दिस काइंड ऑफ अ सॉलिड स्ट्रक्चर हैज बीन क्रिएटेड, इसमें से बहुत मुश्किल हो जाएगा ये बताना कि एक कौन सी है, दूसरी कौन सी है, तीसरी कौन सी है, चौथी कौन सी है. Once I have created a solid structure out of this different kind of a clay, when I have taken a solid structure which has been created by different kinds of clays and I have kind of very nicely, wounded them up again, etc, etc. अब ये पूरा एक मिट्टी का एक टुकड़ा मेरे पास खड़ा हो गया है. इसमें से मैं अलग अलग पार्ट करके नहीं निकाल सकता कि 1 कहाँ है, 2 कहाँ है, 3 कहाँ है, 4 कहाँ है. You see, it is impossible for me to identify which is 1, which is 2, which is 3, which is 4. It is not going to happen with this kind of a activity in which we are dividing them. Do you get the point? This is what basically we understand as consolidation. तो consolidation का मतलब ये होता है कि अगर आप 5-6 चीजें लेके उसको इस तरह से अपने आसपास में मिक्स कर दें, that if you take 5 or 6 things and you kind of put them together, you mix them together in such a manner that it becomes impossible for you to find out the constituent parts. वो अपने आप में बीच में खो जाएगा, आपको मिलेगा नहीं कि वो किस चीज का बना हुआ है. It becomes one solid whole. एक वो जिसको कहते हैं बेजोड़ बन जाता है, which is basically meaning that आपको joint नहीं दिखते अलग अलग करके, right? You don't see the joints in a particular thing. So that kind of a consolidation in which you can't see joints about something is what is known as a solidified entity. And that is exactly the reason the name of the Fund of India is given the Consolidated Fund of India, because all the taxes that you're paying to the Union of India, no matter where they are coming from, the taxes may be coming from Haryana, they may be coming from Rajasthan, maybe from Manipur, maybe from Meghalaya, maybe from Gujarat, maybe from Kerala, Tamil Nadu, Karnataka, Andhra, Odisha, anywhere the taxes are coming from. The moment that they enter into the Consolidated Fund of India, they become one single solid whole. They become a complete, undivided, not just disjointed, what you can say, lump of things, right? And that it is impossible to break down. So, for example, if the state of Maharashtra is paying 20% tax of the total income tax, the moment it enters into the Consolidated Fund of India, that 20% activity does not exist. That consolidated tax becomes only one single whole, and it has no charge whatsoever upon the money which has been taken from that particular state. It doesn't come in a jointed kind of a format. This is what we understand by the concept of a Consolidated Fund of India, class. Do you get a sense of what I'm trying to say over here? Concept of a Consolidated Fund of India means that if I'm taking money from a particular state, the moment that money enters into my fund, the charge that it is coming from that state disappears. Okay? किसी Consolidated Fund of India पैसे को इस तरह से बनाता है, इस तरह से रखता है कि वो पैसा किससे आया उससे कोई फर्क नहीं पड़ता है. There is no matter as to who gave the money. Fact is that this money does not belong to the person who gave it in that proportion. For example, let's say if the state of Maharashtra, this is a Consolidated Fund of India. Okay, now let me elaborate the point that I'm trying to make. If the state of Maharashtra is paying, let's say 20% of income tax of the entire country, the state of Maharashtra is paying 20% of income tax of the entire country. Okay, does it matter? Once this money, let's say for example, the entire income tax paid by the country is 100 and out of that 20 comes from state of Maharashtra. The moment this 20 enters into this pile, this 20 disappears. इसका मतलब ये होता है कि there is nothing in the constitution to suggest that state of Maharashtra will get returns of the 20% in proportion. मतलब स्टेट ऑफ महाराष्ट्र ये नहीं कह सकता है कि हमने 20% टैक्स अगर यूनियन को दिया है तो हमको 20% टैक्स की वैल्यू मिलनी चाहिए, है ना. मतलब फॉर एग्जांपल इफ आई एम द हाईएस्ट टैक्स पेयर टू द गवर्नमेंट ऑफ इंडिया, most amount of infrastructure projects must be pushed by the government of India in my state. That kind of an argument cannot be made in the face of what you understand as a Consolidated Fund of India. Do I make my point clear, class? That is the reason it is called Consolidated Fund of India, because things come from different ends, become one, and they can't be separated. They are not joined in a way, they are not disjointed, they are not something which can be in a way put against each other and be divided into the same proportion, right? So we don't have the policy that the states are going to get returns upon their taxes in percentage of the money which is coming from those particular states with regard to the Consolidated Fund of India. So it is possible, for example, for the government of India to charge a tax upon the state of Kerala, earn money through that tax and give that money to the state of Bihar. That's exactly the role of the nature of the union government in a Republic of India, where it can support the poorer parts of the Republic of India, and even for that it may have to charge taxes upon the richer parts of the Republic of India. That's basically the power which has been given to the union in terms of its paramount powers on fiscal control, right? But at the same point of time, fiscal federalism as a concept implies that the union government cannot just take up any money from any part of India and give it to any other part of India. It is not possible for the union government to take any money from any part of India and give it to any part of India. This is basically that some money must stay within the state only, within the state itself, and this is what is entitled under the question and the concept of what we know as fiscal federalism. Class, am I getting clearly a point across to you? We are developing structures of this kind to be able to develop your conceptual intuition on these matters. Class, do we have a sense of this? Yes or no? Do we get an understanding of what I'm trying to say over here as to how do we understand the question of the fiscal federalism? Do we get a sense of what I'm trying to say? Structure बन रहा है आपके दिमाग में अब थोड़ा थोड़ा? भारत के लोगों के द्वारा जो टैक्स पे किया जाता है वो दो भागों में बांटा जाता है. The tax which is paid by the people of India is divided into two categories. One tax goes to the Union of India. This money I give to in the name of India. भारत के नाम का टैक्स अभी भारत सरकार लेके किसी को भी देते हैं. I may be paying tax in Himachal. The money is sent to Andaman and Nicobar Islands. It is on the Union government to decide. I cannot ask for my tax returned in the same proportion in which I have paid it. मैं ये नहीं कह सकता कि मैंने 50 करोड़ रुपए दिए तो 50 करोड़ की लागत का खर्चा आप मेरे राज्य में करिए या मेरे क्षेत्र में करिए या मेरे घर के सामने की सड़क बनवाइए. भारत सरकार उसको लेके कहीं भी दे सकती है. हो सकता है भारत के बाहर लगा दे कहीं पैसा इन्वेस्टमेंट के नाम पे. You see the point? That is what is the money of the Union of India. But उसके साथ ही हम सारा पैसा तो भारत सरकार के पास ये पावर होती है कि वो अमीर राज्यों से टैक्स खींचकर गरीब राज्यों में दे सके. ये सबसे बड़ी पावर है यूनियन ऑफ इंडिया की फिस्कल लेवल पे. दैट इज हाउ फॉर एग्जांपल द होल नॉर्थ साउथ क्वेश्चन कैन बी क्रिएटेड. एंड यू सी फॉर एग्जांपल व्हेन रिसेंटली वी आर टेकिंग अ लुक एट पर्सन लाइक लेट्स से you are looking at this kind of a political issue also raising now. BJP hits back as opposition parties raise issue of the north-south divide. Okay, so for example, take a look at this. Leaders from the Tamil Nadu joined the Saffron Party. BJP MPs from Karnataka met the media in Delhi, and the party released a statement on the protest by the Kerala CM Pinarayi Vijayan. Right, so you have, for example, this is what is the most important question that you are seeing in the current times. Karnataka Chief Minister Siddaramaiah mounted a protest in New Delhi against what they termed unfair devolution of tax money to the southern states. Right, so their argument is that most of these southern states are they have been able to control their populations, develop their infrastructure, and develop employment opportunities for their people, out of which a lot of tax is collected by the government of India. You see, and what they are saying is that the government of India, what it does is all of these tax are given by the government of India, taken from Karnataka, Tamil Nadu, Kerala, Andhra, and given to states like Uttar Pradesh, Bihar, Madhya Pradesh, Rajasthan. right? This is what they're terming as a kind of a fiscal terrorism, that even the northern states, for example, have not been able to control their populations, develop their economies, provide opportunities for employment, etc., etc. The southern states are forced into paying for these states, and the government of India is doing a kind of a political incentivization, because southern states have lesser seats in the Lok Sabha and the Rajya Sabha, and northern states have more seats in the Lok Sabha and the Rajya Sabha. The northern states are being, in a way, subsidized by the southern states, as you can see it. Accusing the union government of discriminating against Karnataka and the other southern states with regard to the devolution of taxes, the state government's entire leadership, led by the Chief Minister Siddaramaiah, staged a protest at New Delhi's Jantar Mantar on Wednesday, terming the protest as a movement to protect the interests of Karnataka and Kannadigas. And against stepmotherly treatment by the centre, Mr. Siddaramaiah dismissed the BJP's allegation that the protest was aimed at creating a north-south divide. The Congress wants the country to be united, but there should be no discrimination against the southern states. On Thursday, Kerala Chief Minister Pinarayi Vijayan of the Communist Party of India, along with his cabinet colleagues, will stage a similar protest in Delhi against what they describe as the union government's negligence towards Kerala. Okay, Mr. Siddaramaiah asserted that they were protesting the gross injustice perpetrated by the union government in the devolution of taxes, grant and aid, non-release of drought relief, and denial of permissions to take up water resources projects for the past few years. We are raising the issue of discrimination meted by the government of India to the state of Karnataka and other southern states. This is why I had written a letter to all the MPs of the BJP and JDs asking them to participate in this agitation. Okay, so you see the point. This is what basically we are taking a look at this. Mr. Siddaramaiah demanded that the union government set the right to states' losses the tune of 1.87 lakh crores since 2017, allegedly incurred under the 15th Finance Commission. He claimed that the formula used to devolve taxes to the states, especially Karnataka, under the 14th Finance Commission was changed by the 15th Finance Commission and called for reverting to the old formula to stop the loss of revenue of state. After we are done with this kind of a chapter, you would be able to understand this language. Overall, if the recommendations of the 14th Finance Commission had been followed, the 15th Karnataka would have received 62,098 crore, Mr. Siddaramaiah said. The 15th Finance Commission did not have a single member from the South Indian states. Okay, and then of course, this whole thing is what is a North-South divide. And then you have the question of cooperative federalism, or what you understand is a kind of a variant of fiscal federalism. Congress General Secretary Jairam Ramesh said that Karnataka's top leaders had protested at the Jantar Mantar to safeguard the interest of the whole state. The Prime Minister talks big about cooperative federalism, but as usual, that is just a jumla. His anti-democratic, anti-people views are evident at the repeated anyaya to Karnataka as well as other opposition rule states. Drought relief funds denied, food grains denied, projects delayed, Mr. Ramesh said in a post on Twitter. Okay, you get the point. This is the kind of current update we are trying to develop the context and the structure for class. Okay, all right, so that's one point that you understand about how this division happens. Okay, Article 265 is the mother of this entire thing. Okay, so I think I have given you an understanding of what the Article 265 looks like. If I go to the Constitution of India, Article 265 class. Taxes not to be imposed save by the authority of law. No tax shall be levied or collected except by the authority of law. You understand the point? Okay. Now we're going to take a look at the related topic of what is the Consolidated Fund of India. Now to some extent I have described to you what the CFI is, But if you want to take a proper definition of the Consolidated Fund of India, we are going to refer to Article 266 of the Constitution. Okay, please take an understanding of what is known as the Consolidated Fund of India. Okay, now just take a look at it. Subject to the provisions of Article 267 and to the other provisions chapter with respect to assignments, etc., etc. Take a look at this. All revenues received by the Government of India. Okay, I'm going to underline this as point number 1. All revenues received by the Government of India. Okay, point number 2. All loans raised by the government by the issue of treasury bills. Loans or ways and means advances and all money received by that government in repayment of loans. Okay. Now just take a look at this very sincerely. Please class, help me out here. Get a sense of this. 1 plus 2 plus 3 plus 4. Okay, this is the formula. This is 1, this is 2. What is given in green is 2. What is given in black is 3. And what is given in red is 4. Okay, so let me just be very specific about it. 1 is purple, 2 is green, 3 is black, and 4 is red. Okay. Now this is basically what composes the Consolidated Fund of India. Class, let's take a very sincere understanding of this from a prelims perspective. If a question comes, what is the Consolidated Fund of India? What is the Consolidated Fund of India? What is the answer that you're going to write? Consolidated Fund of India has 4 entries into it. Okay. First, revenues received by the Government of India, which means taxes. Point number 1. Second, all loan raised by that government by the issue of treasury bills. Second. Third, loans or ways and mean advances. Third, and monies received by the government in repayment of loans. Right. So the 4 kind of things that come into the Consolidated Fund of India are given in point number 1, 2, 3 and 4. This is how the government earns its money, which includes not only taxes but also include loans. So all the revenues received by the Government of India, which forms a tax collection. This is the most important composition of the Consolidated Fund of India, class. Are we clear? Apart from that, all the loans which are issued by the raised by the government in the forms of treasury bills. All the loans which are raised by the government in the form of treasury bills, T-bills. Okay. Then loans generally or ways and means advances. I'm sure from your economic classes you understand the concept of the ways and means advances. And all monies received by the government in repayment of loans. So for example, if the government has given some person a loan and that person has repaid the loan to the Government of India, that money shall be composed in the Consolidated Fund of India. The question that we're asking over here, class, is this: which of the following form a part of the Consolidated Fund of India? Number 1, taxes, revenues received by the Government of India. Number 2, loans which are taken by the Government of India by the issuing of treasury bills, right? 3, loans or ways and means advances, which are general loans. If they are India, Government of India taking a loan from some place, the money is going to be kept inside the Consolidated Fund of India. And 4th, the money which is received by the Government of India when any person that the Government of India has given a loan repays back the loan. This is the four ways in which money can be kept inside the Consolidated Fund of India under Article 265 of the Constitution class. Please get a very clear sense of this part. This is a possible prelims question. Class, am I getting a sense of this here? Please tell me. Question is, which of the following form a part of the Consolidated Fund of India? Revenues, which are taxes, loans by issuing of treasury bills, loans and ways and means advances, and repayment of the money. So Government of India, if it has given a loan to someone and that some person has given interest to the Government of India, that is how it is going to become a part of the Consolidated Fund of India. You see, that is how Consolidated Fund of India is defined under Article 266 of the Constitution. Am I clear, class? That is how the Consolidated Fund of India is defined under the Article 266 of the Constitution. And similarly, on the same lines, each of the state is also supposed to maintain its own Consolidated Fund of the state. Okay, so you have the Consolidated Fund of India over here, and similarly you have the Consolidated Fund of the state. Exactly the similar things which are happening. So think of these as two bank accounts which are maintained by the Government of India and the Government of the state, in which the money is kept in, and the sources from which money is kept inside the Consolidated Fund of India is what we are basically taking a look at. In the definition of Article 266 of the Constitution, Clause 1 defines the Consolidated Fund of India and the Consolidated Fund of State. The money which is earned by the Government of India is kept inside the Consolidated Fund of India, and the money which is earned by the Government of State is kept inside the Consolidated Fund of the State. Are we clear? Article 266. This is a prelims question for you. Okay. What are the ways? I hope you get a sense of this. Okay. So if I am going to prepare a very simple analysis of this, this is the Consolidated Fund of India. Right. Now the question is, what forms a part of the Consolidated Fund of India? First is revenues, of course. The first thing that are poured in the Consolidated Fund of India are revenues. Second, loans by the issue of treasury bills, general loans or ways and means advances. This is known as a WMA. This must have been a part of your economic foundation classes. And fourth, repayment of loan. If the Government of India has given any person a loan, if that person repays the loan, it forms a part of the Consolidated Fund of India. So this is how money moves inside the Consolidated Fund of India. But of course, it goes without saying that the largest chunk of the Consolidated Fund of India is revenues, which are paid by taxes. This is the most amount of money that is put inside the Consolidated Fund of India, that is by revenues / taxes. Okay, do I get my point clear over here? Do we understand this, class? Article 266 clause 1. And similarly, if you want to create a slightly alternative idea, you have the same concept in regard to Consolidated Fund of a state. With regard to the Consolidated Fund of a state, you have the same context and the same concept which has been created over here. Are we clear, class? 1, 2, 3, 4. This is how I am decoding for you a kind of a possible prelims question, which asks the question, what are the kinds of money which are kept under the Consolidated Fund of India? Article 265 clause 1, and also this is the kind of money which is kept under Article 265 under the Consolidated Fund of the state. Right? Now, what I mean to say is that all of this money is entering the Consolidated Fund of India and this is the money that the government of India has for expenditure. जितना भी सरकार को अपना खर्चा पानी चलाना है वो इसी पैसे से चलाना है. So this is basically what we're taking a look at in terms of understanding how the government earns the money it does, and all that money which is earned by the government is imposed into the consolidated fund of India, and the most amount of money which is taken the consolidated fund of India is by the, what you can say, revenues which are introduced in this particular matter. Clear? Okay, now let's take a look at this part. Article 266 clause 3 over here very simply says, as we were discussing a part a little away, by the way, none of these monies cannot be made to enter without the permission of the parliament. Sorry, this is supposed to be 266, not 265. Okay, and then this part says very simply that money which has to exit the consolidated fund of India. Okay, so the money which is going to be moved out by the consolidated fund of India, सरकार इसमें से पैसा निकालेगी, but that also can only be done with the permission of the parliament. Money cannot be moved out of the CFI without the permission of the parliament. This is given under Article 266 clause 3. So in a way, I am adding more richness and depth to this concept that we have discussed on the first page. How is the money controlled by the government of India? And this kind of a same argument and the same logic applies also in the case of the consolidated fund of the state. जो consolidated fund of the state का जो question है उसमें भी यही पूरा logic लगता है. What we basically see in the consolidated fund of state is exactly the same thing. Money which is coming from the consolidated fund of money which is coming into the consolidated fund of India is coming through these sources. Similarly, for the state, money is coming into the consolidated fund of India from these sources, right? For state purposes, for state subjects. Okay, taxes for state subjects according to the second list of the 7th schedule. And similarly, just like consolidated fund of India may say you cannot withdraw the money without the permission of the parliament, in the same sense, from the consolidated fund of India, from the consolidated fund of a state, you cannot withdraw money from the state legislature. I'm just trying to give you a very overall sense of how the, what you can say, just an overall sense of how the composition and the structuring of the consolidated fund of India is made and how the accounting happens with regard to the government of India. Class, am I clear about this now? I'm giving you a reference of Article 266 clause 1 over here, and here you can take a look at Article 265 if you feel. Are we clear, class? ठीक है. If you want to take a look at this part, please, Article 268 clause 266 clause 3 here. Just a sense of this, please. 266 clause 3, and then briefly we'll take a look at the contingency fund. I'm reading all your questions. I'll come back to them. Just let me first explain these parts. Some of your questions may be answered by the explanation itself. But if you take a look at Article 266 clause 3, what does it say? No monies out of the consolidated fund of India or the consolidated fund of a state shall be appropriated except in accordance with the law. and for the purposes and the manner provided in this constitution. Law meaning the withdrawal of the money from the Consolidated Fund of India. The power of withdrawal of the money for the Consolidated Fund of India is given to the Parliament, and power of withdrawal of money from the Consolidated Fund of the state is given to the state legislature. The power of the money to be withdrawn from the Consolidated Fund of India is given to the Parliament, and from the state is given to the state legislature, because it is said very clearly it cannot be done except in accordance with law. So I hope this entire thing gives you a very clear sense of how the accounting of the money of the government of India and the government of India, a government of a state, is kept, right? So revenues are earned by the government of India and the government of states separately on the subjects which are mentioned in the union list and the state list separately, by making laws upon these subjects and imposing taxes upon them separately, and they are taken into different accounts separately. Account for the government of India is Consolidated Fund of India. Account for the government of state is a Consolidated Fund of the state, and that is how the government of India earns its revenues for the entire territory of India, and the government of states earn their revenues for the entire territory of that state. This is what basically is creating the first and the most foundational aspects of what is understood as the fiscal federalism, right? That's basically what we are trying to focus upon. Are we clear till here, class? Class, give me a yes or no. Are we here? समझ में आ रही ना सारी चीजें? इनसे क्वेश्चन आएंगे आपके. Okay. Now let me just, in that sense, in the same kind of a flow, explain to you what is the Contingency Fund of India. Okay, what do we understand by what is known as the Contingency Fund of India? Let me call it, for example, I can call it the CNFI. Okay. Contingency Fund of India is what, let's say, for example, I call it like this. It says the Parliament, please listen to it carefully, class. I'm trying to understand the concept of the Contingency Fund of India. Okay. The Parliament is given the power under Article 267 to make a law. Okay, so for example, the name of the law is the Contingency Fund of India Act. A law has been made by the Parliament under the power it has been given to the Parliament under Article 267, which makes the Contingency Fund of India Act. Okay, and this under this Contingency Fund of India Act, a law has been made by the Parliament which creates the Contingency Fund of India under the Contingency Fund of India Act, and in this law it says that money shall be taken from the Consolidated Fund of India from time to time. Okay, for example, one transaction can be made up to 15 crore and be deposited in the Contingency Fund of India. Please take a look at this. Money shall be taken from time to time from the Consolidated Fund of India and be deposited in the contingency fund of India. Okay, and then it says the contingency fund of India shall be kept at the disposal of the President. President over here works with the aid and advice of the Prime Minister. Please get a sense of what we are saying over here, class. Just try to see what we are, referring to. Contingency Fund of India is created under Article 267. Under Article 267, the Parliament has been given the power to create an act to create the Contingency Fund of India. And under that power, the Parliament has enacted the Contingency Fund of India Act, in which it is said that money shall be taken from the CFI from time to time, for example, 15 crores in one transaction, and be deposited in the consolidated Contingency Fund of India. And such a Contingency Fund of India shall be kept at the disposal of the President, which is to be submitted at the aid and advice of the Prime Minister. Okay, do we have a sense of what we are saying over here? The Contingency Fund of, if you take for example a look at what is known as the Consolidated Fund of India versus the Contingency Fund of India. Consolidated Fund of India is kept at the disposal of the Parliament. That money can be taken out from the Consolidated Fund of India only by the Parliament, but the Contingency Fund of India is kept at the disposal of the President. So, for example, if there is, let's say, 120 CR currently lying in the Contingency Fund of India, that the President, and the President really is only the nominal head, that means that the Prime Minister and Council of Ministers can withdraw this fund at any given time for what is known as an unforeseen circumstances or unforeseen crisis. Any kind of a natural disaster or any kind of a anthropogenic crisis can be dealt with by the Contingency Fund of India, because in Contingency Fund of India, the most important thing to remember is that the money can be withdrawn from the Contingency of India Fund of India directly by the Prime Minister without taking the permission of the Parliament. It is a fund kept directly under the control of the Government of India, where the Parliament's approval is not needed. So, it is the power of the Parliament to create the Contingency Fund of India and to manage the money which goes from the Consolidated Fund of India into the Contingency Fund of India. But the money in the Contingency Fund of India is kept at the disposal of the President, and such money shall not be submitted to a vote of the Parliament before it is disposed of. That is what basically we understand by the context of the Contingency Fund of India. Article 267. You can take a look at, but let me just show you the statute which is creating the Contingency Fund of India Act. It was created by the Provisional Parliament itself in 1950 to be able to deal with certain famine activities, etc., etc. So, we are going to take a look at the Contingency Fund of India Act class. Please take a look at this. Contingency Fund of India. Okay, take a look at this. An act to provide the establishment and maintenance of Contingency Fund of India. Establishment. There shall be established a contingency fund in the nature of an impress titled the Contingency Fund of India, into which shall be paid from time to time Consolidated Fund of India a sum of 15 crore rupees. Custody of the Contingency Fund of India. The Contingency Fund of India shall be held on behalf of the President by a secretary to the Government of India in the Ministry of Finance, and no advances shall be made out of such fund except for the purposes of meeting unforeseen expenditure, which is basically what we are looking at in terms of Contingency Fund of India. It is only supposed to make advances for unforeseen expenditure. So, I hope I am able to establish and in a way explain to you the entire idea of what is known as a Contingency Fund of India class. Right? Just take a look at point number 3 again and get a sense of what we are talking about. Article 267 of the Constitution gives the power to the Parliament to create a Contingency Fund of India. And the Parliament, which has created the Contingency Fund of India, can allow the money from the consolidated fund of India to move into the contingency fund of India. That's important to remember. Money from the CFI, consolidated fund of India, can move to the contingency fund of India, and that contingency fund of India is kept at the disposal of the president through a Ministry of Finance secretary. So the government of India can make any kind of a grant or an aid to any unforeseen circumstances, to any unforeseen expenditure which the government of India feels it is correct to make so. Right? So it is for the government of India to have unforeseen expenditures which are to be dealt by with the consolidated fund of India. Okay, so a natural calamity, a disaster, a health crisis, if you want to make immediate payments to that particular aspect, it is the Prime Minister himself who can make the decision of drawing out of the consolidated fund of India. That is how it is divided under Article 267 of the Constitution. I hope, class, you can get a sense of what I'm trying to say over here. Class, yes or no? Do we get it? Okay, do we have an understanding of this, class? Okay. Now the next title, what you can say, article that we're going to take a look at is Article 270. Okay, so I'm doing a little bit of a run up over here. You have Article 265 of the Constitution, Article 266 of the Constitution, Article 267 of the Constitution. In Article 266, we have discussed a clause 1 and clause 3, which talks about the consolidated fund of India. Okay, and under Article 267, we have talked about the contingency fund of India. Now we are coming to the real bomb of the article, which is basically the core article in which the devolution of grants. In this article, the devolution of funds between the union and the states is further complicated. And from this only article, we will start moving to the concept of what is known as a finance commission. Please be sure that finance commission is in news for this year for more than one instances, and therefore we have to take a very clear and categorical look at what is happening in these aspects about the finance commission. Okay, so devolution of funds between the union and the states, this is basically most prominently covered in this part, which is known as Article 270 of the Constitution. Okay, now this is also what is going to develop our understanding of what is known as the finance commission. And also finance commission के साथ साथ हम जो GST का जो basic portion है, static portion है, GST council etc. और GST क्या होता है, वो that also we are going to take a look at from this particular aspect. Okay, class. Okay, let's take a look at this structuring here, please. Please pay attention upon this slightly. यहाँ से चीजें थोड़ी सी कॉम्प्लिकेट होंगी हमारी, अभी तक तो चीजें आपको समझ में आ रही होंगी धीरे धीरे स्ट्रक्चर के हिसाब से. दिस विल स्लाइटली ऐड टू सम issue in this what we are discussing over here. If we take a for example, let's say if we ask the question, what is the total tax collected from the in the territory of India? If we ask the question, what is the total tax collected in the territory of India? Okay, and let's say the answer to that question is 100. Okay, 100 रुपए का tax हमने collect किया, and then of course we know that the tax is divided between the union and the states according to the union list and the state list. Right? If the tax is divided between the union list and the state list, and if we ask the question if the total tax is collected between the union and the state in the territory of India, right? Then the question is, if you ask this question perhaps can become somewhat relevant, and also a counter question, I think a kind of additional follow-up question can be asked along with this question. The additional follow-up question is, you see if you can get a sense of question number A and question number B. Please take a sense of what we are seeing over here. मैं ये जानना चाहता हूँ कि एक बार टैक्स कलेक्शन एक बार हो जाता है पूरा एक फाइनेंशियल ईयर के लिए, मान लीजिए टैक्सेस का कलेक्शन हो गया, once taxes have been collected for one financial year. Okay, the question that I'm asking is, what is the total tax collected in that territory of India? It is 100. Okay, now the question is कि अगर आप देखें कि मान लीजिए 100 रुपए का टैक्स एक साल में कलेक्ट हुआ है, तो ज्यादा टैक्स यूनियन के पास जाएगा या गवर्नमेंट के पास जाएगा? लेट्स से फॉर एग्जांपल, इवन इफ आई टेक द इंस्टेंस ऑफ अ टैक्स पेयर, आई एम अ टैक्स पेयर, लेट्स से, and I am, let's say, residing in the state of Uttar Pradesh, so I am paying taxes in the state of Uttar Pradesh. Now some of the taxes I am paying go to the union government, okay, some of the taxes I am paying go to the state government according to the respective lists which are prepared in the name of the union government and the state government. Am I correct? The taxes which I am paying to the union government are according to the union list, and the taxes that I am paying to the state government are according to the state list, right? We are clear about that point. The question that I am asking is, at the end of this tax collection, which organ or which level of the government has taken more of my money? मतलब more of my money is given to India or more of my money is given to my state? मतलब मेरे 100 रुपए में से ज्यादा पैसा मैंने भारत के नाम का दिया या अपने राज्य का नाम का दिया, ये प्रश्न है. इसका मतलब इसके छिपा हुआ प्रश्न ये भी है कि दोनों लिस्टों में से यूनियन लिस्ट और स्टेट लिस्ट के बीच में ज्यादा टैक्स हैवी आइटम्स कहां पर आते हैं. यू सी द क्वेश्चन दैट आई एम ट्राइंग टू आस्क ओवर हियर. द क्वेश्चन इज between the union list and the state list, which of the lists has more tax heavy items? That's the point that I want to in a way take a sense of, and the answer to that is very clear. It is indeed the union government. In fact पता ये वाली बात भी है कि जो शेड्यूल 7 है उसमें जो आइटम्स दे रखे हैं वो ज्यादातर मतलब जो यूनियन और स्टेट लिस्ट बनाई गई है, most of this list is created on the basis of taxes. Most of the tax heavy items are with the union. Okay, और ज्यादा टैक्स यूनियन के पास जाता है और कम टैक्स स्टेट्स के पास जाता है. Right, so most of the tax heavy items which are collected from a particular state are given to the union, not to the states. ठीक है, तो अगर मान लीजिए मैंने स्टेट ऑफ उत्तर प्रदेश के रेसिडेंट होते हुए, इफ आई एम अ रेसिडेंट ऑफ द स्टेट ऑफ उत्तर प्रदेश, और मैंने अगर 100 रुपए का टैक्स भरा तो उसमें से करीब 70 से 75 से 80 रुपए तक मैंने केंद्र सरकार को दिया है और 20 रुपए हो सकता है मैंने अपनी राज्य सरकार को दिया. अगर आपको एक आकलन, एक समीक्षा लेनी है कि किस प्रकार से टैक्सेस का डिवोल्यूशन होता है दोनों ऑर्गन्स के बीच में, तो वो इस प्रकार से होता है बिटवीन द यूनियन एंड द स्टेट्स. यू सी, सो इवेंचुअली फॉर एग्जांपल द डायग्राम कम्स लाइक दिस. ये बहुत सारे वो है, यूनियन है, मतलब ये यूनियन है और ये बहुत सारे स्टेट्स हैं. ओके, और ये मान के चलिए कि स्टेट्स में ये जो पीपल ऑफ इंडिया है, जो पीपल ऑफ इंडिया का जो पैसा जाता है टैक्स का, वो यहां तो जा रहा है यूनियन लिस्ट की तरह, है ना, और यहां जा रहा है स्टेट लिस्ट की तरह. क्लियर? सो what we are basically taking a look at, the most amount of money of the people of India is going to the government of India. मतलब कंसोलिडेटेड फंड ऑफ इंडिया में ज्यादा पैसा जा रहा है और थोड़ा कम पैसा स्टेट्स के पास जा रहा है. तो मतलब यहाँ के स्टेट ऑफ मध्य प्रदेश के अपने कंसोलिडेटेड फंड में, उत्तर प्रदेश में, बिहार में, कर्नाटक में, हरियाणा में, the money is going slightly lesser. So generally जो शेड्यूलिंग करी हुई है लिस्ट 1 और लिस्ट 2 की 7 शेड्यूल में, उसके बीच में इसी प्रकार का डिस्टिंक्शन किया गया है जिससे कि इंश्योर किया जाए कि ज्यादा पैसा यूनियन के पास पहुंचे और कम पैसा स्टेट्स के पास रहे. दैट इज व्हाट इज अनदर व्हाट यू कैन से इंडिकेशन ऑफ द इंडियन कॉन्स्टिट्यूशन हैविंग स्ट्रॉन्ग यूनिटरी फीचर्स. It is said about the Indian constitution that it is having strong unitary features. That is another indication why it has strong unitary features, because most of the money which is taken from the people of India comes to the Union of India and not to the states. ठीक है, यही वाली बात हम समझते हैं. और इसी में क्योंकि ये जो एक फॉर एग्जाम्पल इसको कहते हैं, लेट्स से फॉर एग्जाम्पल a kind of a vertical asymmetry exists between the states and the union, and also a kind of a, now both of these are technical terms, by the way, these are keywords, a horizontal asymmetry exists, a vertical asymmetry exists between the union and the states, and a horizontal asymmetry exists among the states, and it is actually to be able to in a way balance these asymmetries. Okay, to be able to balance these asymmetries, you have what is known as the फाइनेंस कमीशन. यहीं पर फाइनेंस कमीशन का काम आता है. द कॉन्स्टिट्यूशन बॉडी नेम्ड द फाइनेंस कमीशन कम्स इनटू पिक्चर एग्जैक्टली हियर. ठीक है, तो इसको थोड़ा सा हम यहाँ पर आर्टिकल 270 में, आर्टिकल 280 में और आर्टिकल 281 में अब कवर करेंगे एक बार. ठीक है, इसको हम कहते हैं फाइनेंस कमीशन के रोल्स और डेवोल्यूशन, और मतलब स्टेट और मतलब जो यूनियन और स्टेट है इसके बीच में जो डेवोल्यूशन का कॉन्सेप्ट है. इफ यू टेकिंग लुक एट द 15th फाइनेंस कमीशन फॉर्मूला अगेंस्ट विच मिस्टर सिद्धारमैया इज प्रोटेस्टिंग, then we'll take a look at what is the major idea which is behind this activity. Okay, so here just take a look at this part as I'm coming to the understanding of it. We are discussing with the class, please now be a little intently on these things. Please take a look at this properly. We are taking a look at what is known as a tax devolution between the center and the state. That's the whole point that I'm trying to make, right? And let's say, for example, if I can create the system of tax devolution in a simple setup, I'm thinking I'm creating the questions for you from the original idea. A tax devolution between the center and the states can be basically divided into these two categories. Tax devolution between the center and the state can basically be divided into these two categories. First is when we talk about tax devolution, we talk about, let's say, I call it the first cycle of tax devolution. And the first cycle of tax devolution, first, let's say, episode of tax devolution, it happens in sense that the union and the state governments, right, the union government and the state governments, meaning state government including the state parliament here, they get taxes from the people of India according to the distinction which is made between the states and the unions through the Schedule 7 of the Constitution. Okay, so I have in a way kind of brought it to your understanding that the way that the taxes are divided between the union and the states are divided in accordance with what is known as the Schedule 7 union and the state list. So all the subjects mentioned in the union list are taxed by the union government, and those monies goes to the Union of India, right? Which means that they can be spent across the territory of India, and this money is kept in the consolidated fund of India. Okay, and all the subjects which are mentioned in the state list of the 7th schedule, the second list of the 7th schedule, all this money is taxed by the state legislatures, and they are taxed from within the state, and they are to be invested back into the territory of that state. It cannot go out of the territory of that state. You see, and if you create a kind of a little bit of a division of these two, you see the taxation values which are accrued by the state and which are accrued by the center, and this is basically a kind of a simple structural formulation of the fiscal division of powers, or what is known as the fiscal federalism as a concept, right? So I am sure that you're aware about what we are looking at this particular perspective, right? So this is how the first set of taxes come to the government of India and to the states of India. Now it has deliberately been the case that all the tax heavy subjects, all the subjects, for example, you have heavy industries. All of the heavy industries are subject to what you can call the union list. So the union government has the ability to tax the heavy industries, to tax the incomes of the people who are working in the heavy industry sector, etc., etc. So generally the larger tax intensive sectors which have a lot of ability to pay taxes are with the union government. And for example, if let's say you have the information technology sector in Bangalore being very active, okay, it's a very what you can say phenomenal sector in the city of Bangalore, which is in the state of Karnataka, and let's say a lot of people from Karnataka are working in the information sector of Bangalore. The government is charging income tax upon this sector. The income tax is going to the union government. So state, let's say we can say the state of Karnataka and the city of Bangalore is paying money for the survival of the great chunk of population of Indians outside Karnataka and Bangalore, because all of this is going to the union government of India. And that's basically how this taxation structure has been divided, that lists of Schedule 1 and Schedule 2. The subjects which are mentioned in Schedule 1 and Schedule 2 have been so mentioned so that more taxes come to the union as compared to the state. Okay, so what we get is a situation, for example, like this, that the people of India are paying more taxes to the union and they are paying less taxes to the states. So for example, let's say if I have to give a simple analysis of this, if we create this kind of an idea, if I put, for example, the union government and state government, and I put a kind of a proportion to how much the union gets and how much the state gets. I, let's say, hypothesize that the state gets 70% and the union gets 30%. Okay, so for example, let's say, imagine if I am the state of Uttar Pradesh. Okay, if I am the state of Uttar Pradesh and 100 rupees have been paid in tax by my people in the territory of state of Uttar Pradesh, 100 rupees have been paid in tax by my people. Out of that, 70% goes to the union and 30% goes to the state, is what the general assumption is, that the inclination or the tax collected by the union is much higher than the tax collected by the state. Okay, and therefore what basically is the logic of this? The logic of this is, of course, that states can be very prosperous and less prosperous. Across India, you may have very different categories of states. You may have very different qualities of state. You may have very different kinds of states who are far removed from each other in terms of their growth, in terms of their productivity, in terms of their GDP, in terms of their per capita GDP, in terms of their population control, in terms of their general efficiency, okay, natural resources. And therefore, there is such a variation among all the states of the country. Then it is not feasible, according to the Constituent Assembly, to give the states the power over their own taxes too much. Okay, to give the power to the people of those states to pay taxes and retain those taxes only for their own state. So for example, if the state of Tamil Nadu is a very well industrialized state, let's assume, okay, then it is not feasible according to the Constituent Assembly to give the state of Tamil Nadu too much powers upon its own tax money, because then of course the state of Tamil Nadu will enter into a kind of a reinforced cycle. You have good industries, they get good taxes produce good industries produce good taxes, etc., etc., and the growth rate of Tamil Nadu would take off. But at the same point of time, you are creating a union of India, which means that states should support other states in growing up, right? In a kind of, it is a what you say, a kind of a obligation of the cooperative federalism that must exist, that the states should be able to talk about other states who are not as heavy in the growth of their GDPs, etc., in comparison to, for example, like a state of Tamil Nadu. And also, if for example you have a state of Tamil Nadu which becomes all powerful because of its money, etc., etc., then the state of Tamil Nadu may not necessarily be an integral part of India, which is otherwise poor. You see, so the Union of India is created at the center to take a kind of a control over the taxes of the state of Tamil Nadu, and if needed, to direct those taxes to the poorer states. And that is why, as I mentioned, according to the 7th schedule list 1, most of the tax heavy subjects for the territory of India, including the territory of Tamil Nadu, are given in the union list, and therefore the state governments do not end up having so many taxes as the union government by the virtue of the first list of the 7th schedule of the Constitution. Right? Does it make sense? So that's basically what we, in a way, want to take an understanding of with regard to this thing. And in this perspective, eventually what happens is that a kind of a position arises that is known in the language of constitutional thinking on fiscal policy and fiscal federalism as vertical asymmetry. Okay, what is vertical asymmetry? The unevenness between the union and the states in terms of the collected revenue. This is what one can understand as vertical asymmetry class. I hope that you're getting a sense of what I'm trying to say over here. What I'm saying is that because this has been designed in such a way that it is deliberate that the union must have more money than the states, a vertical asymmetry arises, and the vertical asymmetry implies that there is an unevenness 70s to 30 between the union and the states in terms of collected revenue. Okay, this is one part that I want to be clear about. Now, in juxtaposition to this, there's another aspect of tax collection. The other aspect of tax collection is, of course, that there are going to be states which are going to be more prosperous than the others. That naturally you will find that kind of a diversity. You will find less prosperous states, more prosperous states, better naturally gifted states, better, let's say, organized states, etc., etc., and less ones. So, okay. So, for example, let's say if this is the state of Tamil Nadu, if this is the state of Karnataka, if this is the state of Bihar, if this is the state of MP, if this is the state of Kerala, right? Now, all of these states tax their own subjects, right? But what you see, for example, is that the taxes collected by the state of Tamil Nadu, let's say, for example, stand at 70 rupees. Taxes collected by the state of Bihar stand at 80, Karnataka stand at 80 rupees. Taxes collected by the state of Bihar maybe, let's say, stand at 30 rupees because the general inability of people to rise their income levels. Okay, taxes collected by MP maybe stand at 37 rupees. Taxes collected by Kerala maybe stand at, let's say, 49 rupees. Okay, so if you take a look at this kind of a thing, that if you take an example of Karnataka versus Bihar, you see how much more taxes the Bihar Karnataka government has, in a way, in comparison to the Bihar government. And of course, these taxes are going to stay within the Karnataka government and the Bihar government, etc., etc., right? So this also has the potential of creating what is known as a horizontal asymmetry. Horizontal asymmetry implies that different states are what you can call different states are positioned differently, and that difference of position is very clearly manifested in the prosperity of the states, and the prosperity of the states directly determines the tax collecting abilities of those states. And again, you can have a virtuous cycle where you have better industries, more taxes, better industries, more taxes, and it kinds of start rotating up, which may create a kind of a vertical asymmetry, a horizontal asymmetry between the two things, right? So if I have to define, for example, the concept of horizontal asymmetry, it is the unevenness in revenue powers of the states compared with each other. This is what you can see is the definition of what is known as a horizontal asymmetry, right? And therefore, when I complete the first cycle of my tax collection, the first cycle of my tax collection is arrived at a position where the union has a lot of taxes as compared to the states, causing a vertical asymmetry, and the states on the other hand have a lot more taxes than other states, causing a horizontal asymmetry. You see, this is the, what you can say, first activity of tax collection that happens within the government of India, right? Now, if I draw a bit of a lineation for it and go to the second cycle of tax devolution. So first, let's say, for example, this has happened, that taxes have come to the state. तो आपके जो taxes थे वो लग के collect हो गए. That is basically, we understand, is what is happening in this particular part, that there is a First cycle of tax devolution and the second cycle of tax devolution is what we basically take a look at over here. Now, if you want to address this part, second cycle of tax devolution, the most important figure in the second cycle of tax devolution is the Finance Commission. Now, you know for a fact that Finance Commission is a constitutional body. Okay. And now what basically it says is this, that let's say, I'm just going to put it out very simply as what is given under Article 270. Now, please take a look at this, how these taxes which have been collected by their appropriate governments in their appropriate funds, they are to be mobilized. Okay, please take a look at this. We are looking at a fact that the government of India has collected taxes from different states, right? And this is all gone to the government of India. But now we want to take a look at the question that how will the government supply the money back to the different states, right? Government of India को बाकी states के पास पैसा भी तो भेजना पड़ेगा ना किसी प्रकार से. So how the government of India will supply the money back? This is basically supplying the money back is what is known as devolution. So for example, let's just imagine a situation like this, that state of UP gets a package from the government of India by the report of Finance Commission. Let's say the state of UP gets a 5,500 crore package into the consolidated fund of Uttar Pradesh from the government of India at the recommendations of the Finance Commission. Just think about a news item that you may have read, something like this. Okay, the government of India is going to give the state of UP a package of 5,005 crore rupees. Okay, let's say for example, the Planning Commission used to give money to the states to be able to carry out their schemes, etc., etc. So this is what basically I understand at this point of time as devolution, or the second cycle of devolution. Okay, so the state of Uttar Pradesh does not have enough money of its own to take care of this thing. Let's say the taxes which have been earned by the state of Uttar Pradesh are, let's say, 300 crore, and 300 crore is very less for the state of UP to be able to carry out its activities, right? To be able to carry out certain schemes that it is wanting to do. So the government of India can give a kind of a massive package to the state of Uttar Pradesh, by which state of Uttar Pradesh can be put in some kind of a, state of Uttar Pradesh can be put in some kind of a advanced mode, right? That's basically what we asked by the question of devolution, right? And that's what basically we are trying to understand over here. Now, if you take a look at Article 270 of the Constitution, the article that we are focusing upon, Article 270 states that money collected from subjects mentioned in the union list, money collected from the subjects mentioned in the union list must be further devolved into two categories. Please pay attention to this class, okay? This is very critical stuff. Okay, the first category would be total money divided between the union and the states. Okay, so this is what basically we can call a vertical devolution. Okay, vertical devolution. And then we take a look at point number B. This is what is known as the horizontal devolution, right? And the constitutional body that shall decide on the formula for such devolution is the Finance Commission. Please take a look at this part very clearly. I am just in a way decoding before you Article 270 of the Constitution class. Please, if you can, just take a little bit of an understanding of it openly. You have to be very sure about what you're reading. I will explain it again, okay? But please be sure that there is some amount of depth to what is being presented over here. Money collected from subjects mentioned in the union list must be further devolved into two categories. One, total money divided between the union and the states, and B, total money divided among the states. When total money is divided among the union and the states, it is known as vertical devolution. And when total money is divided among the states, it is known as horizontal devolution, right? The chief task of the constitutional body created under Article 280 and Article 281 of the Constitution, which is called the Finance Commission of India, is to effectuate vertical devolution and horizontal devolution. That is the chief task of this particular body. Right? Do I make my point clear, class? Let me elaborate this. If I say, let's say for example, if after I say the first cycle of tax collection, right? मतलब फर्स्ट साइकिल हमने देखा था इसमें क्या है कि यूनियन ने अपने टैक्स निकाल लिए, स्टेट्स ने अपने टैक्स निकाल लिए. Okay, let's say for example the total tax paid is 100. Okay, in the territory of India, the total taxes paid is 100 for one financial year. Total taxes paid are 100 for one financial year. Okay, now let's imagine that out of this 100, 70 go to the Union of India, and overall 40 goes to the states. Okay, now please take a look at this clearly. If in the first cycle of tax collection, which is 100 rupees are collected, 70 go to the Union of India and 30 go to the state. Okay, 30 rupees go to the state. Clear? So this is what I call vertical asymmetry, right? So let's say for example, in blue what is mentioned is vertical asymmetry. Okay, and let's say within the states you have, for example, different states. Let's say you have Karnataka, you have Tamil Nadu, you have Odisha, you have Uttar Pradesh, you have Himachal Pradesh, etc., etc. If you take a look at the collection of these states, let's say a high producing state would have a high amount of tax collection. Another high producing state may have a high amount of tax collection, but another state may have a very low tax collection. Another state again may have a very low tax collection. Another would have a average tax collection. Another would have extremely high tax collection. Another would have, let's say, again a high tax collection. Depending upon the kind of state that you are, the fiscal collections made by states are going to be asymmetric, and that's basically what I'm in a way marking as. In pink you can have horizontal asymmetry, right? This is what we're taking a look at, aren't we? Okay, now you take a look at this. What happens in this particular scenario? According to Article 270 of the Constitution, this amount 70 rupees is the subject of Article 270. Okay, now 70 rupees are going to see two kinds of functions applied over it. First function applied over is vertical devolution. The first function applied over 70 is vertical devolution. Okay, the first function applied over 70 is vertical devolution. What do we understand by vertical devolution? That 70 is going to be divided into the union and the states. Let's say, for example, 40 is kept by the union and 30 is given to the states. This is what is known as vertical devolution. You see what I'm doing over here? States have 30 altogether. 30 more are added to the kitty of the states. Okay, and this 30 has been taken from here. This becomes 70 minus 30 equals to 40. तो यूनियन गवर्नमेंट ने अपना पैसा ले लिया, which is 40. ठीक है, you see the point? The money which has been taken by the union government for itself is 40. 40 रुपए में अपना काम चलाएगी सरकार, और 30 रुपए सरकार अलग अलग राज्यों के कंसोलिडेटेड फंड ऑफ इंडिया में क्रेडिट करेगी. ठीक है, इसको कहेंगे वर्टिकल डेवोल्यूशन. डू गेट द पॉइंट? देखिए, भारत सरकार, यूनियन ऑफ इंडिया इज एन एब्स्ट्रैक्शन. टेरिटरी तो स्टेट ही है ना, मतलब डोंट थिंक ऑफ स्टेट एज अ पॉलिटिकल यूनिट, बट थिंक ऑफ अ स्टेट एज अ टेरिटरी. अब अगर सरकार को पैसा खर्च करना है तो सरकार कहाँ करेगी? मद्रास में करेगी, कोलकाता में करेगी, चेन्नई में करेगी, यही तो करेगी. इट इज नॉट गोइंग टू मेक इन्वेस्टमेंट्स इन सम abstract idea called India. It is going to invest in the territory of India, right? Now what it does is, if you have a 70-30 division between the union and the states, right, which is the natural tax collection that has been accrued by both the union and the states, this 70-30 distinction, what you can call division between the union and the states, leads to what you can call asymmetry, that union has more and states have less, right? Now sure, the union government also has to work on the territory of state. So कर्नाटका में जो स्टेट गवर्नमेंट की लिस्ट में सब्जेक्ट है उस पे यूनियन नहीं बना सकता है, लेकिन जो यूनियन गवर्नमेंट की लिस्ट में सब्जेक्ट है उस पे तो यूनियन ही बनाएगा ना लॉ. तो मान के चलिए कि अगर हेवी इंडस्ट्रीज को प्रमोट करना है कर्नाटका के अंदर, या डीआरडीओ को ऑफिस लगाना है कर्नाटका के अंदर, तो कर्नाटका की टेरिटरी पे उसे यूनियन गवर्नमेंट ही तो बनवाएगी, राइट? द गवर्नमेंट ऑफ इंडिया is going to be the one which is going to create an office of DRDO in the state of Karnataka, because defense is a union subject, right? So now the point is that government of India has 70 rupees from its own earnings. जो union subject से उसने पैसे निकाले हैं उसमें 70 रुपए उसके पास आया, right? And the state governments have 30 rupees from their own earnings. State governments experience a kind of a shortfall. But that's also correct, because some states will earn more money than the other states. So rather than giving those states the power over their monies, their subjects have been given to the Union of India to take taxes out of them. Are we clear? Right? Now what the union government does under Article 270, it takes its 70 rupees which it has earned from union subjects and divides them vertically. Okay, this division vertically means that union government will create a portion for its own expenditure. ठीक है, तो स्टेट ऑफ कर्नाटका में अगर यूनियन गवर्नमेंट को डीआरडीओ की फैक्ट्री लगवानी है तो द गवर्नमेंट ऑफ इंडिया विल टेक इट आउट ऑफ 40, लेकिन बाकी जो 30 रुपीज है ना, 30 रुपीज गवर्नमेंट ऑफ इंडिया सारे स्टेट गवर्नमेंट्स के कंसोलिडेटेड फंड ऑफ स्टेट्स में क्रेडिट कर देगा. You see the point? So it's a kind of a grant, it's a kind of a devolution which has been given by the government of India to states. So Bihar ko, for example, as we saw, 5500 crore fund transfer has been given to Bihar in the consolidated fund of the state of Bihar, which is a kind of a devolution made by the government of India by the activities of Article 270 of the Constitution. ठीक है, तो देखिए अब मतलब इसका क्या है कि टोटल जो स्टेट्स कंसोलिडेटेड फंड ऑफ स्टेट्स है ना, द टोटल मनी in the consolidated fund of states, as you can see it, the total money in the consolidated fund of states is 30. Now 30 is added with 30 which becomes 60, right? तो अब सारे स्टेट्स के टोटल मिला के कंसोलिडेटेड फंड में 60 होगा. ठीक, नाउ टेक अ लुक एट दिस. ये वाला जो 30 है, this will now further be horizontally divided by the government of India. So for example, let's say out of this 30, let's say I take the first lot. Out of this 30, I take 7. ठीक है, और 7 में दे देता हूं इसको, मान के चलिए इसको. You see the point? So 2 will get a top up of 7 and it will come to a point of 11. You see the point? 2 will get a top up of 7 in its consolidated fund of India. So let's say for example the state of Bihar will get 7 rupees from 30 which was coming from here, and the state of Bihar upon giving 7 rupees from 30 will get a top up of 7 which will lead to 11. Sorry, which will lead to 9. Okay, I was thinking 7 plus 5, sorry. So 7 plus 2 will lead to 9. So 9 is the amount of money now lying with the consolidated fund of the state of Bihar, which it can spend for its own subjects. Okay, so for example, if Bihar wants to make a new hospital, it has received a 7 rupee top up from the union government over and above the money it has earned from its own consolidated fund. This 7 rupee will be utilized by the Bihar government for spending upon its own subject. Okay, own subject meaning, let's say for example, if health is a state subject, then upon the subject of health, the union government has given the money to the state of Bihar, and the state of Bihar can develop its own hospitals upon its own subject. It doesn't have to do it for the union subject, it doesn't have to do for defense or anything else. For its own subject, out of its own consolidated fund of India, it has got some money which will allow it to perform better. You see, this is what basically we understand as the devolution which is done horizontally, vertically, and also devolution which is done horizontally. So the government of India will decide what amount of money has to be given to different entities. So for example, it says minus 10 rupees have been given, let's say, to the state of Uttar Pradesh. So 10 plus 2, उत्तर प्रदेश comes at 12. तो उत्तर प्रदेश के कंसोलिडेटेड फंड ऑफ इंडिया में, कंसोलिडेटेड फंड ऑफ स्टेट में उतना पैसा एक्स्ट्रा आ गया. इट नाउ स्टैंड्स एट 10 plus 2 which is 12 for स्टेट सब्जेक्ट्स. मतलब जो भी विषय राज्यों की सूची में दे रखे हैं 7th शेड्यूल में, उसके ऊपर उत्तर प्रदेश अपना खुद का इन्वेस्टमेंट कर सकता है. ये आपको जो 10 रुपए मिले हैं, ये आपको केंद्र सरकार से मिले हैं, और इसको हम कहते हैं हॉरिजॉन्टल डेवल्यूशन. Do you see the point? So what I'm trying to in a way suggest is very clearly, class, try to take a look, listen to this and get a sense of what I'm trying to say over here. When we talk about asymmetries which are existing between the union and the states and among the states, we are looking at vertical asymmetry and horizontal asymmetry. This is after the first cycle of tax collection is completed. Okay, this is after the first cycle of tax collection is completed. You will see these kind of asymmetries, vertical asymmetries and horizontal asymmetries. Okay, now what happens is, under Article 270, the Finance Commission of India suggests and recommends to the Union of India to take the money which is there with the Union of India and divide it into two categories. One, the money which has to be retained by the Union of India, and second, the money which has to be distributed among the states as a whole. Okay, states as a concept. So the Union of India in this particular chart, as you can see it, has given 30 rupees to the states as a concept. Okay, मतलब स्टेट एज अ होल, सारे स्टेट्स को मिला के आपने स्टेट्स के नाम के 30 रुपए निकाल के रख दिए. ठीक है, जैसे आप समझ रहे हैं ना इस बात को. क्लास, आर वी एबल टू अंडरस्टैंड इट प्रॉपर्ली? क्लास, आर वी हियर? आर वी कनेक्टिंग विद व्हाट आई एम सेइंग राइट हियर? Class, are we here? Do we get the point here? Please tell me. I'm trying to develop for you the conceptual basis of the Finance Commission, a constitutional body which has been brought into institution only this year. A Finance Commission is created once in 5 years, and 2023 is the year when the Finance Commission has been created. Right? So when I'm taking a look at, let's say for instance, this kind of a thing here, the union government has received taxes of 70 and the states put together have received a tax of 30, and now let's say for example I am taking 30 rupees from my own taxes and transferring them to the states. States have 30 more. This is what is called a vertical devolution. Which is made upon the recommendations of a constitutional body known as the Finance Commission. Class, are we getting a clear sense of what we are saying over here? 70 minus 30, 30 go from the Union of India account and they are credited into the state government account. Okay, so what happens over here? द यूनियन ऑफ इंडिया इज लेफ्ट विथ 40 रुपीज। तो अब भारत सरकार को अपना सारा खर्चा 40 रुपए में चलाना पड़ेगा। ये वाला वो पैसा है जो कंसोलिडेटेड फंड ऑफ इंडिया में रह जाता है। द मनी विच इज लेफ्ट रिमेनिंग इन द कंसोलिडेटेड फंड ऑफ इंडिया इज 40। ओके, द मनी विच इज नाउ सेंट into the consolidated fund of all the states put together as a whole is 30. This is what I basically understand as vertical devolution, which is made upon the recommendations of a constitutional body known as the Finance Commission. Am I clear about this, class? And then in addition to this, what you see is, for example, if I take a little bit of a blown up version of the states. Now, if I have seen that, for example, states are divided into these 3-4 categories. Let's say you have taken a few states over here, and let's say the total tax collected by these states in one financial year is 30, out of which one state has collected 5, the other has collected 15, the other has collected 5, the other had collected 5, other has collected 10, etc., etc. Right now, what we are seeing is that a top up of 30 is coming to them in the form of vertical devolution. Clear? A top up of 30 is coming to them with a vertical devolution. And the formula by which the figure of 30 is distributed among the states. Formula which 30 is distributed among the states is horizontal devolution. And this is also recommended by the Finance Commission. If I am able to very clearly establish for you the job of the Finance Commission. By the Finance Commission, right? So the Finance Commission can say, let's say for example, out of 30, 5 will go to UP, okay, 7 will go to Bihar, let's say 3 will go to Karnataka, or let's say 4 will go to Kerala. Do you see this point? This is the way in which the devolution will be recommended. And that's how, for example, the states, they end up adding 30 rupees overall, which is 60 rupees to their CFIs. But let's say, for example, if you have the state of Bihar over here, state of Bihar has been given 7, then the total money in the state of Bihar is going to be 12. This is going to be money with the Bihar CFI, Bihar Consolidated Fund, to be spent on the subjects of the स्टेट लिस्ट। ये पूरा का पूरा पैसा अपना बिहार का है। बिहार इस पैसे को किसी भी तरह से चाहे खर्च करे, उसमें उसको कोई जवाबदेही नहीं होगी। हालांकि फाइनेंस कमीशन की कुछ रिकमेंडेशंस होती हैं और कुछ उसकी मतलब इंसेंटिव्स होते हैं कि अगर आपने पिछले साल अच्छा पैसा खर्च किया है किसी एक पर्टिकुलर सेक्टर में, जैसे मान लीजिए बिहार ने गरीबी कम करी है किसी प्रकार से, तो फाइनेंस कमीशन अगले साल उसको और पैसा देने का रिकमेंडेशन करती है। तो इस तरह से पैसा किस तरह से सरकारें खर्च करेंगी उसको थोड़ा सा इंसेंटिवाइज करके रेगुलेट किया जा सकता है। अगर मान के चलिए कि क्लाइमेट चेंज पे काम कराना है किसी ऐसे प्रदेश में जहां पर कि क्लाइमेट चेंज का सबसे बड़ा इम्पैक्ट पड़ा है, तो फाइनेंस कमीशन उसको बोलेगी कि इतने पैसे आपको दिए गए हैं, अगर आप क्लाइमेट चेंज पे काम करेंगे तो हम अगले साल भी आपको और ज्यादा पैसे देने के लिए सेंट्रल गवर्नमेंट को बोलेंगे. We will tell the central government to give you more money next year. So this is how the recommendations of the finance commission can be made to work as to what sectors have to be invested in by these governments by creating a kind of incentive structure. You understand the point? This is what is the job of the finance commission, to put it very simply and lightly and in a very kind of a general studies manner. The job of the finance commission is to ensure that there is horizontal and vertical devolution to deal with horizontal and vertical asymmetry. Now, if I can put this grand plan that the constitution has made of using the money of the people for them. Okay, you have Union of India, you have the states of India, right? Now, since it is a federal polity, union has to be given its own subjects to tax upon, and the states have been given their own subjects to tax upon. Naturally, because states in some areas are going to be more prosperous, better suited, better developed than other states, then those states cannot have an entire control over their tax money, because then they would create a real, what you can call a lopsided development vision of India, and then poverty will be concentrated in a few states and wealth would be concentrated in another few states, and this is going to be bad for the unity and integrity for India for every sense. Therefore, these states cannot be given the, what you can say, the position to tax themselves completely or to use their own taxes entirely, and therefore these states, however, have a few taxation rights. Prominently, the sectors which are tax incentives, are tax intensive, are supplied to the union government, and union government takes the money from these states which are resourceful. Okay, but now the union government has having the money. Now what it has to do is it has to cut that money into half. Okay, and then allocate a portion from that money only for states. This is what is called as vertical devolution, and it has to find out states. For example, let's say I'm taking the money from state of Kerala, state of Karnataka, state of Andhra Pradesh, which are, let's say, tax intensive states, and I'm supplying that tax to the state of Bihar. This is what I'm doing by vertical devolution. So what money could have been in the consolidated fund of the state of Kerala, I've taken it from there and I've given it to the consolidated fund of the state of Bihar, and I'm telling Bihar कि आप अपनी जो गवर्नेंस है वो इस पैसे से चला सकते हो. You see the point? This is the nature of the union as a kind of a authority on the matters of taxations, and this is exactly the will of the constitution. Every state which became a part of the Indian polity, Indian constitution, agreed to these terms. All of these terms have been agreed to the states which had it, what you can call, signed the instrument of accession with the India. So all of this is a part of the constitution as written by the constitution. It has not been introduced into the constitution by an amendment. These actions are there in the original constitution starting up. And that is exactly the nature of the union, and that is the nature of cooperative federalism, which means that states which are wealthy have to be sure that states which are left backward cannot be ignored in their growth and in their productivities. And therefore, since the states which are forward, they depend upon the states which are backward. Let's say, for example, the whole idea is divided into this thing, that southern Indian states are population controlled states, they are better developed states, they are better educated states, literacy rates are high, manufacturing sector is better developed, you have more jobs in the services sector, more agrarian economy has been converted to either the manufacturing or services sector. They should be allowed to have their own tax money so that they can develop them further. Why is a person from Karnataka giving money to a person to Bihar for able to develop him? The answer is because all these states have developed on the back of the populations, right? If, for example, the government of Karnataka or the state of Karnataka manufactures a particular, let's say, commodity, a large amount of the consumption of the commodity doesn't happen in the state of Karnataka, it happens in the state of Bihar or Uttar Pradesh. You see, so since there is more population in the northern states, they are the bigger market, they are the bigger consumers, and since they are the consumption, what you can say, they are the consumption factor in the economic engine, Economic engine cannot run only upon the production factor. You have to have a consumption factor also circulating the economic engine properly. So this kind of a circulation is triggered by the consumption factor of the populous states of Uttar Pradesh, Bihar, etc., etc. And therefore there has to be some kind of a cooperation between the states in terms of achieving inclusive and a kind of a sustained growth for the entire territory of India, and not growth coming to one part of India and not coming to the other part of India at all. This is something which is felt as a violation of the unity and integrity of India by the constitution makers, and that is how this kind of a financial fiscal distribution system is created within the constitution itself. And the constitutional body which plays the most significant role in achieving this kind of a fiscal distribution is the Finance Commission of India. And again, I'm pointing out to you that the question on Finance Commission of India is going to be one of the most important questions this time, because there has been the creation of the 16th Finance Commission. As you will read under Article 280, that the Finance Commission is to be created every 5 years, and it is this time again that the Finance Commission is getting created, right? The what you can call the the 16th Finance Commission which will recommend the formula for sharing revenues between the center and the states for the 5 years period beginning from April 1, 2026. You see the point? Now I hope that you can read this part a little more properly and categorically as to what does the Finance Commission do. Just a little bit of a newspaper reading will allow you to get a sense of it clearly. Mr. Arvind Panagiria, who was previously the vice chairman of Niti Aayog and also has been a economic advisor to the President of India previously, is going to be the what you can call the head of the 15th Finance Commission, 16th Finance Commission, which is going to start its work right now and submit the details of its reports by the end of the year 2025. Okay, so this is going to be a possible question from the current updates this time, again a relevant question. The chairman of the 16th Finance Commission, Mr. Arvind Panigaria. Okay, he was a previous vice chairman of the Niti Aayog. He comes from the Jagdish Bhagwati School of Economic Thought and has been a very important economic advisor to the government of India in the years of 2014. Okay, and then you can say that you have these members of the Finance Commission. These are the 5 members of the Finance Commission, including the chairman, Mr. Ajay Narayan Jha, Mr. Annie George Matthew, Mr. Niranjan Rajadhaksha, and Mrs. Dr. Soumya Kanti Ghosh, Chief Economic Advisor of the State Bank of India. Okay, all of this is here, and the 16th Financial Commission has been requested to make its recommendations available by October 2025. Right, for the financial year commencing from April 1, 2026. That's why these part are in the news, and that is why we are trying to focus upon this directly in terms of understanding the background of the finance commission, etc., etc. So class, tell me, do you get a sense of what is the duty of the finance commission? When we take a look at it, it has to devise a formula for addressing the devolution of money from this union to the state. What do we understand by that formula? Class, are we clear about it? Okay, take a look at this. Article 270 of the Constitution. Please try to read this Article 270. This is exactly the article that provides for all these activities. Class, these are very technical aspects. I hope that you get a sense of them. Then you would be able to answer questions. Article 270 of the Constitution, please, if you can. Just take a look at the line that I have underlined, the sentences that I have underlined. All taxes and duties referred in the union list, okay, which means the money which is earned by the government of India under any law made by Parliament shall be levied and collected by the government of India and shall be distributed between the union and the states in the manner provided in clause 2. You can see over here. From here you get the sense of distribution of two kinds: vertical devolution and horizontal devolution. I hope you get a sense of this, class, please. Are we sure? All taxes and duties referred in the union list under any law made by Parliament shall be levied and collected by the government of India and shall be distributed between the union and the states in the manner provided in clause 2. So this distribution is what is given as vertical devolution and horizontal devolution. Article 270 is the crux of this argument, right? And if you take a look at clause 2, the manner prescribed in clause 2, in clause 2 you have the, what you can say, the positioning of a finance commission. So the manner is prescribed by the finance commission, which means to say that if you put this entire thing together, devolution of the money of the union list shall be prescribed by the finance commission. Okay, if you take a look at this article 270, so I've broken down the entire aspect of article 270 before you in terms of getting a sense of how the finance commission has been given its powers. Okay, so again you can see the signs of vertical and horizontal devolution in article 270 of the Constitution. Article 270 says such percentage as may be prescribed by the finance commission of the net proceeds of any such tax or duty in any financial year shall not form a part of the CFI. मतलब इसको CFI में जमा नहीं किया जाएगा, but shall be assigned to the states. Okay, just take a look at this. Shall be assigned to the states is talking about, shall be assigned to the states is talking about vertical devolution, कि पहले आप states का एक chunk निकाल के अलग कर दोगे. Vertical devolution shall be assigned to the state, vertical devolution, within which that tax or duty is leviable in that year and shall be distributed among those states. You see, you are going to take a look at this as horizontal devolution. Okay, and this devolution has to be made by the president according to the recommendations made by the finance commission. Okay, class, am I getting a sense of clarity on article 270 of the constitution? Class, give me a yes or no if I need to explain this again. We very clearly want to understand what is the finance commission, what are the ways in which finance commission works, and what do we exactly mean by the powers given to the finance commission under article 270. 270 is one of the most enigmatic articles of the constitution of India. I'm trying to decode it for you. Do let me know if you are able to grasp the point that I'm communicating here. Class, what do we understand by vertical devolution, horizontal devolution, and what are the terms that are written before you on this page? Are you able to understand here is what I'm going to ask. Class, are we there? Is it clear? समझ में आ गया फाइनेंस कमीशन? So if I have to ask you the question that let's say very simply, I go back to the newspaper article over here. Very simply, if I put this very part in front of you, can you read the answer to this? What is given? Can you decipher this point as to what it says? The Union Cabinet on Wednesday approved the terms of reference for the 16th Finance Commission, which will recommend the formula for sharing revenues between the center and the states. What are the ways in which revenues are being shared? Are you able to read this? समझ आ गया क्लास आपको? ठीक है ना? तो अब देखिए, let's just try to calculate it out properly and build a summary of it, and then I'll go to the next part. As I was mentioning that what you can say, tax collection and devolution between the union and the states, which is an entire chapter of the Constitution of India. Tax collection and devolution between the union and the states. Tax collection and devolution of taxes between the union and states can be divided into two categories, or let's say two cycles. Okay, cycle number 1 is पहले आप टैक्स कलेक्ट कर लीजिए सब जगह से. ठीक है, तो हमने टैक्स कलेक्ट करना समझा दिया कि यूनियन लेजिस्लेचर will impose taxes upon the union list. And state legislatures upon state list. ठीक है, तो ये तो आप समझ गए. So here, let's say in a very simple sense, I can write that after this tax collection is done, the distribution between the union and the states would be something like 70-30, because the most amount of money, most amount of sectors which are tax intensive, they are in the union list, right? So first the union government takes the money from the states which are prosperous, right? And then the union government, at the recommendations of the finance ministry, gives a part of the money to the states which are less prosperous. That is the what you can call vertical and horizontal devolution that it does. And then a part of it retains for itself. You see, so we saw 70 and 30, then we saw 40, 30 plus 30, and then the remaining 30 was divided among the states horizontally. So you have 40 with the state, 40 with the union, and each state has 10, 5, 10, 7, 10, 8, ऐसे करके, right? And the union has 40. Now this is the money that is going to be put in the consolidated fund of India only for the union purposes. So this is the money that will go for the union subjects, right? And the remaining money would be spent upon the state subjects by the states. Clear? So ये 70, 30 का जो पूरा determination है, this is what happens. And then what happens in the cycle number 2, as we are taking a look at this over here. Now this is cycle number 2 where the finance commission becomes important. This money from the union list. Class, are we clear? We are talking about money from the union list only, 70. Article 270 says money from the union list, all taxes and duties referred to in the union list. Okay, this is the money from the union list. This is what we're talking about. Okay, so taxes and duties collected from the union list, not the state list, only the union list. This 70 is subjected to vertical division. So it has, let's say, become 40 and 30. Okay, so now what happens is that you have 40 which remains with the union, and the states have 30 of their own plus 30 given by the union. This money 40 will go into the consolidated fund of India, and this money altogether will go in the consolidated fund of the states, right? And the cycle number 2 is given effect to most prominently by the constitutional body called the Finance Commission. Okay, by the constitutional body known as the Finance Commission. Am I getting a clear sense of it? तो पहले यहाँ पे 70-30 हो जाता है, फिर यहाँ पर 70 का आधा निकाल दिया जाता है और 30 यहाँ चला जाता है, 40 यहाँ रह जाता है. उसके बाद क्या करना पड़ेगा आपको? इस 30 को now you will have to horizontally distribute, right? So out of this 30 you will give 5 to someone, you will give 6 to someone, you will give 7 to someone, you will give 10 to someone. So this is what is going to be horizontal devolution. So अब देखो, आप इसको ना पूरा सिमेट्री में देखो क्या म्यूजिक बनाया है कॉन्स्टिट्यूशन ने, एकदम परफेक्टली फाइन. सिंपल तरीके से कहने का अर्थ ये है कि यूनियन जो ज्यादा प्रॉस्परस स्टेट्स हैं उनके टैक्सेस उठा के जो कम प्रॉस्परस स्टेट्स हैं उनको दे रही है, यही तो कर रही है, राइट? That's exactly what it is doing, and that's exactly the nature of Indian Constitution. A strong unitary force which may take the taxes from the what you can say more prosperous states and give it to the less prosperous states, so that there is a cooperative growth. There's a sustained and more, what you can say, united growth of the country, rather than a kind of a lopsided, uneven growth of certain states and a total destitution and poverty in the other states of the country. Right? Do we have an understanding, class? Okay. Horizontal devolution, vertical devolution. तो अब इसके अंत में what we'll get is, in the end of this what we'll get is article 270 के end में we'll see that union has for itself 40 and states for themselves have 60, right? And then the states, according to their own weightage and according to their own needs, are given parts of what are given over here. ठीक है, ये सारे स्टेट सब्जेक्ट पे बनेंगे, एंड ये सारे होंगे आपके consolidated fund of India. ठीक है, do we understand this? ठीक है, अब just to give a little bit of an additional part, article 270 we have understood, which is probably the most central article with regard to fiscal federalism and the financial devolutions between center and state. Let us very simply take a look very briefly under article 280 plus 281 of the constitution, which talk about the, what you can say, the constitutional body of finance commission. मतलब फाइनेंस कमीशन का कॉम्पोजिशन, फाइनेंस कमीशन का अपॉइंटमेंट, फाइनेंस कमीशन का टेन्योर, फाइनेंस कमीशन की ड्यूटीज और रिस्पॉन्सिबिलिटीज और पावर्स और लिमिटेशंस, ये सारी चीजें क्या है, वो सारी आर्टिकल 280 से लेकर 281 में हो जाएंगी. ओके, बिकॉज वी आर टेकिंग अ लुक एट these powers are exercised at the recommendation of the formula created by the finance commission. उसके बाद फिर हम current update एक बार इसका update करेंगे. Okay, so just a quick revision. Now again I'm identifying it as somewhat a very important category because finance commission is instituted once in 5 years, and this time you are seeing a possibility of the finance commission which is getting a renewal of term this time. Okay, so take a look at this article 280 of the constitution. We are going to just take a look at the nature and structure of the body known as the finance commission. Just take a little bit of a revision of how the finance commission is composed, constituted, instituted, powers and functions, and all those things put together. How do they work with reference to the finance commission? Okay, so very simply speaking, finance commission is a constitutional body. Constitutional body always has a shall written within it. So when you have, for example, a body which has a shall written into it meaning it is something which is necessarily to be formulated. It is not on the discretion of the government of India to make that body. For example, though if we had taken previously a look at article 340 of the constitution, article 340 of the constitution talks about the backward commission, the what you can call backward classes commission, right? Article 340. Now over article 340 you have written the term president may appoint a backward classes commission to investigate into the situations of the backward classes, right? That is what the term says, president may. On the other hand, what we see in this particular matter, which is the matter of the finance commission, it is said president shall, which means that the government of India has no option but to institute a finance commission every 5 years. If the president does not institute a finance commission every 5 years, then the Supreme Court can oblige the president to institute a finance commission, because that is going to be the constitutional function of the Supreme Court, to interpret the constitution, and it will tell the government that it is mandatory under the constitution that there shall be a finance commission, so you have to institute it. If you can't institute it, I will institute it. You see the point? This is what basically the nature of a constitutional body is. So every 5 years the membership of the finance commission can be changed. The president shall, within 2 years from the commencement of this constitution, and thereafter at the expiration of every 5th year or at such earlier time as the president considers necessary, by order constitute a finance commission, which shall consist of a chairman and 4 other members to be appointed by the president. So exactly on that regard, we have seen the appointment of the current finance commission. We have the 16th finance commission, which has come into appointment over here, right? 1, 2, 3, 4 members and 1 chairperson of the finance commission. 5-membered body which has 1 chairman. Mr. Arvind Panagiria is the chairman of the 16th finance commission, just to be sure about the name. Okay, Mr. Arvind Panagiria, he was the former vice chairman of the Niti Aayog. Clear? Okay, now take a look at this. Parliament may by law determine the qualifications which shall be requisite for appointment as members of the finance commission and the manner in which they shall be selected, right? So the power has been given to the parliament to make a law by which the appointment of the finance commission, etc., etc., can be made. So just take a name of this law which has been made by the parliament. Please just note the name of this law. Again, this would be a multiple choice question kind of a format this year because of the current update on the institution of the finance commission. So let's say the terms and conditions for appointments, salaries, allowances, tenure, the what you can call conditions of services of the members of finance commission are to be governed by this act, the Finance Commission Miscellaneous Provision Act 1951. This is the law which has been made by the parliament under the application of section 280. Parliament may by law determine the qualifications which shall be requisite for appointment as members of the finance commission and the manner in which they shall be selected, right? So the membership of the finance commission is determined by the law made by the parliament. The name of the law is Finance Commission Miscellaneous Provisions Act 1951. I want you to take a little bit of a note of this because this is going to be necessary as a multiple choice question in the prelims examination this time. All the boxes are getting checked by a question like this. It is a part of your static portion and it is also current update, and it happens once in 5 years, so might as well, you see, become a recipe question for you. Finance Commission Miscellaneous Provisions Act. Okay, all of these things, if you are able to focus upon right now, will help you extraordinarily in the prelims examination, is what I mean to say. All said and done. Are we taking a sense of this? Finance Commission Miscellaneous Provisions Act 1951 class. Okay? Chalo. Next, we take a look at the duty of the Finance Commission. Okay, now just take a look at this. This is exactly the same thing that we have seen under Article 270. This is the foremost duty of the Finance Commission. This is the foremost duty of the Finance Commission. The distribution between the union and the states of the net proceeds of taxes which are to be or may be divided between them under this chapter. So the part of this chapter which is referring to those areas is Article 270. Okay, Article 270 में already इसकी बात कर रखी है, and the allocation between the states of the respective shares of such proceeds. Okay, so it again talks about the distribution between union and the states. It talks about what is known as the vertical devolution, right? It talks about vertical devolution, distribution between the union and states, and the allocation between the states, which is known as horizontal devolution. So again, the idea of Article 270 has been rehashed in this part also. Okay, do you see the point? Okay, and the other duty which is given to the Finance Commission apart from this is the principles which should govern the grants in aid. ठीक है, ये अलग चीज होती है, grants in aid. Maybe we'll come to this a little later. But the Finance Commission is also supposed to take a look at the grants in aid which can be given by the union to the state. So over and above the money which is given by devolution, certain grants in aid can also be given by the government of India in the consolidated fund of the states on the recommendations of the Finance Commission. So just to remember a point, the grants in aid also can be provided by the government of India over and above the expenditures, the devolutions which are made under point number A. Okay, and all of this takes a look at this part over here. This has to do with state finance commissions, which have been specifically instituted for managing the financial sustainability of local bodies. So for panchayats and for municipalities, the state finance commissions have been created specifically to manage the financial sustainability of the panchayats and the municipalities. So the state finance commissions have to work in tandem with the Finance Commission of India. So that's a little bit of a separate part, okay, that you can take a look at once you understand the Finance Commission of the states, which I'm sure you've covered in your foundation classes, etc., etc. And it also says any other matter referred to in the commission by the president in the interests of sound finance. ठीक है, अगर राष्ट्रपति जी फाइनेंस कमीशन से किसी और मैटर के बारे में जानना चाहते हैं तो वो उनसे इसके बारे में पूछ सकते हैं. So again, a question here could be that which of the following bodies is the principal body to advise the president on matters of finance? The answer is Finance Commission. Just like the president can be approached by any person under Article 143, president can be approached to the Supreme Court in the matters of advisory jurisdiction on matters of constitutional relevance. If the president has to go to a body to ask on financial questions, the decision shall be, or the matter shall be referred to the Finance Commission. Okay. And now this is the final part of Finance Commission, Article 281 of the Constitution. Then we'll come to the current update, discuss a little bit about the report of the 15th Finance Commission, which has caused a little bit of a trouble everywhere. Take a look at this. First of all, we get a sense that what does the Finance Commission do? Finance Commission suggests to the president, you have, for example, the what you can say Consolidated Fund of India, right? Now 70 rupees have come into the Consolidated Fund of India, or 70 rupees have come to the government of India from the taxes which have been collected from the union list, right? Now these monies are to be given by the government of India. First of all, they have to be divided in two parts. One is the share of the government of India, other is the share of the states put together, right? And then the next is the division which has to be made among the states, horizontal devolution, right? Now, of course, it is 100% necessary to be able to run and look at the country as a whole, that taxes from prosperous states shall be given to less prosperous states. Of course, it's no problem, yes. But again, there's a huge question over here. Question is, what about the politics of it? What, say, for example, the argument made by the southern Indian states many times is that every political party in the center wants to appease the North Indian voters, because obviously North India has a more higher, very higher population than South Indian states. And because of their high population, they also have more votes in the Lok Sabha, right? And the Rajya Sabha. So the fact that you have more number of Lok Sabha constituencies in a state like Uttar Pradesh and Bihar, and if you are able to capture the Lok Sabha constituencies in Uttar Pradesh and Bihar, you are already in a position in which you would want to, in a way, please or appease Uttar Pradesh and Bihar by giving them more money, right? Without those states actually earning their own money, but in a way trying to get the money from the states which are prosperous, educated, literate, better developed, and all of that. So the question is, what about the politics of it, right? That's the point. And that's the thing. Just like, for example, we see National Commission of Backward Classes, National Commission of Scheduled Castes, etc., etc. They have been kept there to check and balance the politicization of caste in matters of appointing reservations. Similarly, the Finance Commission is the independent constitutional body whose principal responsibility is to give suggestions to the Government of India to distribute the money in accordance with sound ideas of finance, not because of a kind of a appeasement politics. So let's say, for example, if the Government of India is under the control of a political party which is giving money to the state of Bihar, because Bihar has a lot of MPs, Lok Sabha votes, and therefore this keeps a kind of a situation in which everyone wants to appease Bihar, right? That's the first thing. What is the role of Finance Commission in this entire situation? The role of Finance Commission is that the Finance Commission will make recommendations based upon science, based upon scientific expertise. So for example, it shall determine which are the states which deserve some more money. For example, it will take the assessment of the poverty ratios, it will take an assessment of the malnutrition indices, it will take a ratio of the per capita GDP and all the other economic indicators, and on the basis of this very purely scientific objective assessment will the Finance Commission recommend that according to scientific evidence, these are the states and these are the sectors within the states that money should be put in by the Government of India. So the Finance Commission has a kind of a little bit of a control over the hand of the Government of India, and the hand of the Government of India is controlling the purse of the people, right? It has the taxation powers. So the hand of the Government of India cannot completely be free of the Finance Commission. The Finance Commission would scientifically and objectively try to tame the intensification of politicization of the action of giving money which is taken from a few states to other states only because of the fact that the other states are getting you to become powerful at the union level. It will direct the hand of the government on the ground of science and evidence and empirical data. You see, that's the, what you can say, power punch of a body like Finance Commission. I hope you're making the point clear over here, class, right? And therefore, the question that we are asking in Article 281 of the Constitution is that you have the Finance Commission which is supposed to create recommendations, okay, which is supposed to create recommendations on how this 70 has to be divided, first of all vertically and then horizontally, right? So recommendations on vertical and horizontal devolution of 70. You know what 70 is? It is the taxes and duties levied on the union list. So it is going to be the one which will suggest to the Government of India where the money should go according to principles of finance and according to the objectives of alleviating poverty, developing administrative system, investing in infrastructure development, creating the general welfare of the people. That should be determined by the recommendations of the Finance Commission. So, as I'm again pointing out, the Finance Commission is like the scientific gadfly chained to the government of India, the President of India. The fact that it is a constitutional body makes it a scientific gadfly, which is changed to the government of India. And in that sense, the government of India will not be able to completely avoid the shadow of the Finance Commission. Okay, the constitutional body cannot be unconstituted by the government of India or the law made by the government of India. That would be unconstitutional, right? So it is in a way a gadfly which is attached to the government of India, which is forcing the government of India hand to do the right thing rather than just acting crazy out of politics. It is exactly the kind of role that a National Commission for Backward Classes, Scheduled Castes and Scheduled Tribes plays in matters of allocating seats in the categories of reserved categories. Yes. So this is what basically we understand under Article 281. What is the nature of the recommendations? Now the reports / recommendations of the Finance Commission are not binding upon the precedents. That's true. Are not binding upon the precedent. Okay. These reports are not binding upon the precedent. But these reports are to be laid before or to be presented before both the houses of parliament with the memorandum explaining okay, and this is basically what is also true about the National Commission for Backward Classes, National Commission for Scheduled Castes, etc., etc. The reports of the Finance Commission are not binding upon the President. Of course, the President over here is acting only in aid and advice of the Council of Ministers. So he's not necessarily acting as a free agent over here with his discretionary powers. But nonetheless, these reports can create a huge political storm because these reports are to be laid before the houses of the parliament with a memorandum explaining the steps taken or not to be taken. So if in the event that, let's say for example, the government of India makes devolution based upon purely political logic and avoids the recommendations of the Finance Commission. So let's say for example, if the Finance Commission says that the money has to go to the state of Rajasthan, okay, and let's say if the government of India gives the money to the state of Bihar, the recommendations of the Finance Commission are not binding upon the government of India, but these recommendations need to be tabled before the parliament with a memorandum explaining why did you not give it to the state of Rajasthan and instead gave it to the state of Bihar. Now all of these documents are to be put by the government of India in the parliament, which means in the public domain. Now it depends upon the political creativity of the opposition parties to be able to convince the state of Rajasthan that if you keep voting for this political party over here, they are going to take all your share and give it to another state in the name of pure politics. Science does not exist for them. And the larger message that it will send to the entire country is that even the states which are paying a lot of money, eventually their money is being taken by the political party in power to give it to people who are giving them more votes and more seats in the Lok Sabha, rather than on sound principles of finance. And there would be a kind of an overall disenchantment against the political party entering into this kind of a devolutionary irregularity. That's exactly the kind of politics that the report of the Finance Commission can create if it is presented in the parliament and is given to competent politicians from the opposing sides. You see, that's exactly the job of politics on the opposing sides. That it takes up these matters and it creates a reverse politics against the bad politics. That is supposed to be the political creativity at activity inspired by the Constitution of India. Do you get the point? Therefore, it is non-binding upon the president. The president is not bound by the report, certainly. And of course, after a point of time, you can't really change the president and the government of India on the basis of certain reports. But the fact that you will be able to make these reports public and these reports are going to be subjected to a public scrutiny, it is on the creativity and the dexterity of the opposition political parties who can create a narrative on the basis of this report in which the money was supposed to be going to Rajasthan, but it has been sent to Bihar only on the account of vote bank politics, that people in Bihar are going to be happier and they're going to vote for you back in power. You are going to be able to create a disenchantment and a dispassion for the government in power once the people of India get to know that the government of India is taking money from the rich states, giving it to their own favorite states, not giving it to the poor states, and in every way trying to earn only political mileage out of this. All of these states who are paying money, the rich states and the states who are not paying money but also are poor states, all of them will turn against this political party and will tell the political party that no more seats for you in the next Lok Sabha election. We know what you're up to. You're politicizing the tax collections. And that is a kind of a remark that is coming even from the, what you can say, the states which are currently agitating against the Finance Commission reports and recommendations, the southern Indian states. Okay, so we take a look at Article 281 of the Constitution class just quickly, and that is basically all the information that we need to understand the concept of the Finance Commission. Do we have it, class? Do we get the point here? The question whether the president, the recommendations of the Finance Commission are binding or not, the answer is the president shall cause every recommendation made by the Finance Commission under the provisions of this Constitution together with an explanatory memorandum as to the action taken thereon to be laid before each house of the Parliament. Right, so I think this part is self-explanatory now to you as to the nature of the recommendations of Finance Commission. They are binding? No. But should they be made public? Yes. You can have a multiple choice question. Now class, please listen to me very carefully. It is a matter of good questions for you which are going to come in the prelims examination. I am going to connect these two parts. Finance Commission is instituted every 5 years. 2023, a Finance Commission has been instituted for the year April 2026 onwards, the financial year. It has to submit a formula which shall apply from April 2026, which is going to decide the devolution of funds between the center and the states and among the states for the next 5 years from 2026 onwards. Okay, and therefore this finance commission is appointed once in 5 years. It is appointed now. So we are taking the static portion of finance commission, the overall idea of fiscal devolutions and the financial relations and the consolidated fund of India and the contingency fund of India, and making them come together so that this charged up, position can become one of the relevant points from which a question may be asked. So are we clear with all the data on finance commission, the job of the finance commission under article 270, the composition, institution, powers and duties, the finance commission's miscellaneous provisions act 1951, and the recommendations of the finance commission and the nature of these recommendations, whether they are binding or non-binding upon the president of India, and if non-binding, how is it that accountability of the president can be ascertained if it doesn't go with the recommendations of the finance commission of India, which is scientific in nature and instead has used politics to be able to ward off the money to states which are giving him more seats rather than what is feasible scientifically. Do we get the sense of this? Understand it clearly, class? Yes or no? Okay, now let's come to quickly finish this part up. We are going to take a look at the understanding of this matter, what is known as the report of the 16th Finance Commission. Okay, this is the final part I'm going to cover, and then we'll take a look at a little bit of a GST tomorrow. The first thing, report of the 16th Finance Commission. This is the current update part that I want to in a way take a look at now. Class, सारी चीज़ आपके प्रीलिम्स के एग्जामिनेशन में आएंगी. आप देखिए अभी आप इनको जो यहाँ पढ़ रहे हैं, इतना हम जो आपको बोल रहे हैं ना, ये सारा आपका प्रीलिम्स में दिख जाएगा आपको इस बार. Over the years you've developed an instinct to understand how the UPSC thinks. That's really the most important capital that you need to be able to prepare for an examination like this, and that is our only offering actually. We have to read the instincts of the commission and to be able to start thinking like the commission as to how it gives the questions. And exactly on that thought line, I am preparing the module which is covering all these parts. Okay, let's take a look at this. So your question here, is there any specific formula based on which finance commission recommendations vertical devolution? Yes, that's what we are going to take a look at. The formula which is given by the 15th finance commission. Each finance commission gives its own formula, and the formula keeps changing from finance commission to finance commission. But yes, there is a formula which has been given by the 15th finance commission, and exactly that formula is under crisis in terms of the agitation made by the state governments over here. That's what basically we're going to write. See, this is an editorial in the Hindu on February 21, 2024. We're that close to current updates. Okay. Looking at February 21, 2024. Right. All of this is going to be the relevant material from which the UPSC prelims paper is going to be made out. Okay. What is the role of Finance Commission? What is the basis for allocation of tax revenue to various states? Has the percentage of share of the divisible pool of taxes been reducing for southern states? What are the potential solutions? Okay, so your question here is, what is the basis for allocation of tax revenue to various states? Okay, and has the percentage share of the divisible pool of taxes been reducing for southern states? That's the question, right? कि क्या जो आपका 70 है और 70 में से जो 30 निकाला जाता है, तो यहाँ जो 40 रह गया है, क्या इसमें 30 में ज्यादा से ज्यादा नॉर्दर्न स्टेट्स के लिए जा रहा है और कम सदर्न स्टेट्स के लिए बच रहा है? इज दिस द क्वेश्चन? Is it true that northern states are getting less, more and more, and southern states are getting less and less? That's the point that we're trying to understand through this editorial. Okay, so just take a look at this. Now, all of this is in current update class. I hope that you're paying attention to this. Recently, various opposition ruled states, especially from South India, have claimed that they have not been receiving their fair share as per the present scheme of the financial devolution. They have raised issues about their less than proportionate share of receipt in tax revenue when compared to the contribution towards tax collection. ठीक है, तो इन लोगों ने बोला कि हमारे यहाँ से टैक्स जाता है इतना. So what are they saying? That out of the 70 rupees, you are taking so much tax from Karnataka, income tax from Karnataka, etc., etc. Yes, it is a union tax, but still it is going from the territory of Karnataka. Now they say that the tax which is given by the state of Karnataka to the government of India is very disproportionate in terms of how much it comes back to it. So for example, if like I said, the government of India is getting 20 rupees of tax from Karnataka on the union list subjects, but it is coming from Karnataka, then what the state of Karnataka is saying, that out of 20 rupees that we are giving to the government of India, when it comes to devolution, it comes to 5 or 6 rupees. Matlab, we are getting much lesser returns in devolution than what we are getting in terms of its money that we have put in the hands of the government of India. Okay? Take a look at this. Please just get a sense of what we were discussing in the classroom, and you'll get a sense of what we are dealing with over here. Article 270 of the Constitution provides for the scheme of distribution of net tax proceeds collected by the union government between the center and the states. The taxes that are shared between the center and the states include corporation tax, personal income tax, central GST, the center's share of the integrated GST. So all of these are union taxes, by the way, okay? This division is based on the recommendations of the Finance Commission that is constituted every 5 years as per the terms of Article 280. Apart from the share of taxes, states are also provided grants and aid as per the recommendations of the FC. The divisible pool, however, does not include cess and surcharge that are levied by the center. Okay, so class, first of all, tell me, are you able to easily read this paragraph? Is this paragraph comprehensible to you, is my question. Class, are you able to read this paragraph? Yes or no? Get a sense of this current updates. Class, come on. Are you able to read this, class? So congratulate yourself. This is one of the most complicated parts of the polity paper because it is heavily technical. You are now very well in understanding of Finance Commission. Wait till you find out how all of this helps you in the examination. Okay, now take a look at this. The FC, Finance Commission, is constituted every 5 years and is a body that is exclusively constituted by the Union Government. It consists of a chairman and 4 other members. The Finance Commission Miscellaneous Provisions Act 1951 has specified the qualifications for chairman and other members of the commission. The Union Government has notified the constitution of 16th Finance Commission under the chairmanship of Dr. Arvind Panagiria for making its recommendations on the period of 2026-31. Class, is this paragraph understood? ये दो पैराग्राफ अगर आप समझ जाओगे तो आपके प्रीलिम्स का कोई भी स्टैटिक पोर्शन का क्वेश्चन निकल आएगा और जो डायनेमिक पोर्शन में फाइनेंस कमीशन का एस्टैब्लिशमेंट हुआ है वो भी निकल आएगा. समझ रहे हैं ना बात को? ये वाला पूरा समझ में आ रहा है? वर्ड बाय वर्ड एवरीथिंग. दिस इज ओनली, क्या करता है यूपीएससी का एग्जामिनर, यही निकाल के बना देता है क्वेश्चन इससे प्रीलिम्स के. दैट्स एग्जैक्टली व्हाट यू सी एवरी ईयर. दैट इज एग्जैक्टली व्हाट यू विल सी दिस ईयर आल्सो. ठीक है, चलिए अब आगे बढ़िए. व्हाट इज द बेसिस फॉर एलोकेशन? अब देखिए, the share of states from the divisible pool vertical devolution stands at 41% as per the recommendations of the 15th Finance Commission. The distribution among the states horizontal is based on various criteria. Table 1 lists the criteria for horizontal evolution among the states from the 11th to 15th Finance Commission. So by the way, now take a look at this. 41% of the union revenues. Okay, so you see 41% is the formula which is created by the 15th Finance Commission. So 41%, what do I mean to say over here? Remember what I had said, 70? So the figure that I had kept at 70 is what is known as the divisible pool. So what we see over here is 41% of 70. This is the formula for vertical devolution. Class, are we getting it? Answer to your question, sir, and also a question for the prelims examination. The share of states from the divisible pool according to the 15th Finance Commission report for vertical devolution, okay, is 41% of the divisible pool will be given to states, right? So if you have 70, it means that 41% of 70, let's call it X, will be given to states. And how it would be horizontally divided between the states is going to be determined a little more elaboratively. तो 41% का फिगर पकड़ लिया आप लोगों ने क्लास. चलो अब इस पे आएंगे बाबा. The criteria as per 15th Finance Commission can be briefly explained as follows. Income distance is the distance of the state's income from the state with the highest per capita income, which is Haryana. States with lower per capita income would be given a higher share to maintain equity and among states. Population is the population as per the 2011 census. Till the 14th Finance Commission, weightage was given for the population as per the 1971 census, but that has been discontinued in the 15th Finance Commission. ठीक है? Now take a look at this. यहाँ पर जो क्राइटेरिया है, जो फॉर एग्जाम्पल इफ आई एम टेकिंग अ लुक एट दिस पॉइंट वेरी क्लियरली, यू आर लुकिंग एट 15th फाइनेंस कमीशन फॉर्मूला. आप 15th फाइनेंस कमीशन के फॉर्मूले को यहाँ पर देख रहे हैं क्लास. ठीक है, 15th फाइनेंस कमीशन के फॉर्मूले में फैक्टर क्या क्या रखे थे उनको देख रहे हैं डिसाइड करने के लिए वो कितने राज्य को कौन सा मिलेगा. ओके, वी आर टेकिंग अ लुक एट द फैक्टर्स व्हिच वर डिसाइडेड बाय द 15th फाइनेंस कमीशन इन टर्म्स ऑफ devolution ऑफ मनी. First factor which is determined over here is income distance. Okay. Second which is determined over here is population. Third which is determined over here is forest and ecology. And fourth which is determined over here is the demographic performance criteria. Right? इसको आप नोट कर लीजिए. Fifth is tax effort. Okay, so these are the 5 factors or 5 criterias which are used by the 15th Finance Commission to determine the formula for devolution between the center and the states and among the states. Income distance, population, forest and ecology, the demographic performance and tax effort. Take a look at this. These are the 5 factors, class. I hope that you've taken a look at it properly. This is super relevant for your prelims examination. 5 factors which the 15th Finance Commission has used to determine the formula for tax devolution. That is its job under Article 270 and Article 280 of the Constitution. Are you taking a look at this? population, forest and ecology, demographic performance, tax efforts, and income distance. 5 points. I need you to take a look at it very clearly and very intently to get a piercing understanding of this question. Please, class. Fifteenth Finance Commission formula, class. Are we clear about it? Okay, let's go down. What are the issues? The constitutional scheme has always favored a strong center in legislative, administrative and financial relations. This is what we have seen already. However, federalism is a basic feature and it is important that states don't feel shortchanged when it comes to distribution of resources. While there are always political differences between the union government and the opposition rule states that exacerbate the problem, there are genuine issues that need to be considered. Firstly, we'll just not go into this technical details, but take a look at this part. Just take a look at this chart. The amount in rupees each state government got for every rupee they contributed to central taxes in 2021-22. So what are we getting a sense of here? Do you see the assessment which is done over here? Let's say, for example, each of these states have contributed 1 rupee. Each of these states have contributed 1 rupee to central taxes. Okay, so for example, as I'm pointing out that the state of Karnataka में बहुत सारे लोग इंफॉर्मेशन टेक्नोलॉजी में टैक्स दे रहे हैं, राइट? तो वो सेंट्रल टैक्स है. सेंट्रल टैक्स मतलब जो कि आपके कंसोलिडेटेड फंड ऑफ इंडिया में जाएगा, जो कि मतलब यूनियन लिस्ट का टैक्स है, ठीक है, स्टेट लिस्ट का टैक्स नहीं है. तो हम बात कर रहे हैं कि कौन सी टेरिटरी से, मतलब फ्रॉम द स्टेट ऑफ कर्नाटका सो मेनी पीपल हैव पेड टू द union list taxes. Okay, so if each of these state has paid 1 rupee to the central taxes, okay, in return of that 1 rupee, how much in rupees have they got is the assessment which is presented by this chart. Can you take a look at this chart, class? Can you get a sense of what I'm trying to say over here? If 1 rupee is contributed by each of these states to central taxes, class, please get a sense of it. Are we getting a sense of it or not? Yes or no? If 1 rupee has been paid by each of these states into the central taxes, not in the state taxes, okay, these are not talking about the money which is going to the consolidated fund of India, but it is talking about the money which is going to the central government, which is forming the divisible pool, 70 rupees as we had mentioned it. If 1 rupee is being paid by each of these, what is the return in rupees assessed is presented upon this chart. Okay, so for example, Maharashtra pays 1 rupees, gets in return 0.08 rupees. Karnataka pays 1 rupee, gets in return 0.15 rupee. Haryana pays 1 rupee, gets in return 0.18 rupee. And if you go ascending order, you see, for example, Uttar Pradesh and Bihar on the other extreme ends. 1 rupee is paid by Uttar Pradesh, it gets 2.73 rupees in return. 1 rupee is paid by Bihar, it gets 7.06 rupee in return. And this is what basically is one of the problems which have been raised by the southern Indian states, which are all tagged along in the left column: Maharashtra, Karnataka, Gujarat, Tamil Nadu, Telangana, Andhra Pradesh, Kerala, right? in terms of the money that they are taking and the money that they are giving. Class, do we understand? So do you see what the problem in this entire episode is going to be like? It can be seen that industrially developed states received much less than a rupee for every rupee they contributed as against states like Uttar Pradesh and Bihar. This is partly to the fact that many corporations are headquarters in these state capitals where they would remit their direct taxes. However, this variation can also be attributed to the difference in GST, etc., etc. Chalo, this is a different thing altogether. The share of states in the divisible pool of taxes over the last six finance commissions. These states are contributing less and less. These states are contributing more and more as they're going. Right, so you can see Karnataka and Kerala and Tamil Nadu, there the money which is given to them is declining steadily, right? And if you take a look at state like Maharashtra, Rajasthan, Uttar Pradesh, money given to them is inclining steadily. Okay, so this is more of your mains material. Okay. Do we get a sense of this class? ठीक है? Are we there? %41% itself has to be shared between state is not mentioned apart from horizontal devolution. 41% itself has to be shared between state is not mentioned apart from horizontal devolution. No, see, that's the point now. See, you make a vertical devolution, 41% is supposed to be given to states, and then this 41% is supposed to be horizontally distributed between the states. That's simple, right? Right, so I do answer the question with regard to the finance commission formula, 15th finance commission. ठीक है, ये आपका बहुत ही important एक current update का topic, उसके पूरे static portion के साथ और उसके पूरे background के साथ consolidated fund of India के साथ सारी चीजों के साथ cover हो गया. अब अगर आप budget का part लो, if you take the finance bill 2017 kind of a thing, and if you take it with consolidated fund of India, contingency fund of India, फाइनेंस कमीशन एटसेट्रा, जब आप ये सारी चीजें अगर कंबाइन कर लोगे ना, तो जो भी फाइनेंशियल मैटर्स इन द कॉन्स्टिट्यूशन है वो आपके खत्म हो जाएंगे. वी हैव टेकन द फाइनेंस बिल व्हेन वी वर डिस्कसिंग द इलेक्टोरल बॉन्ड्स केस. टुडे वी हैव टेकन अ लुक एट द फाइनेंस कमीशन. तो ये दोनों फाइनेंस के अगर आप पॉइंट्स उठा लेंगे कि किस तरह से पैसा अंदर जाता है फाइनेंस बिल पास करा के इन द कंसोलिडेटेड फंड ऑफ इंडिया अकॉर्डिंग along with the recommendations of the finance commission, then you would be in a position to completely and very beautifully understand all the questions and answers which are relating to the financial aspects of the Constitution of India, which is probably the most difficult part of the Constitution of India. And every year there are two questions out of this policy, fiscal federalism, cooperative federalism, financial commissions. All of these questions are repeating again and again with the term finance attached to a subject of polity is a terrifying topic for people to read in polity because it is slightly technically challenging. Okay, we are taking a look at this today. We've taken an understanding of this, and we will see you tomorrow. Thank you so much for your time and patience. Please read the sections, the articles that we have discussed in the constitution, and I'll be back tomorrow. Thanks a lot, class. ठीक है, so कल we were taking a look at the what you can call the concept of fiscal federalism. Yes, we were taking a look at the concept of fiscal federalism, and within the concept of fiscal federalism we had taken yesterday the understanding of certain articles of the constitution. We had understood article 265, article 266, article 267, article 270, article 280 and article 281 of the constitution. These are the articles of the constitution that we had taken a look at yesterday with regard to understanding the concept of fiscal federalism, right? Now in article 265 we had studied the fact that taxation cannot be imposed without the authority of law. Okay, taxation cannot be imposed without the authority of law. This is what was given under article 265 of the constitution, right? Then we have seen under article 266 about what is known as the consolidated fund of India, and we have seen what are the entries which form the consolidated fund of India. We have seen the entries which form the consolidated fund of India. ये हमने पढ़ लिया है, अच्छे से देख लिया है, right? Entries which form a part of the consolidated fund of India. Okay, then we take a look at article 267. Article 267 talks about the contingency fund of India. Right? We've taken a look at article 267. This is what we talk about as the contingency fund of India. Okay, and then in addition to this we take a look at article 270. In 270 we have talked about certain concepts that we discussed yesterday. We were discussing the concept of vertical and horizontal devolutions. We're discussing the concept of vertical and horizontal devolution, right? And in vertical and horizontal devolution we had seen how the money collected by the government of India from the union list the money collected by the government of India from the union list is subjected to devolutions on the recommendations of a constitutional body called the Finance Commission. Okay, do we get a sense of this class? Are we surely getting a kind of a content base upon how we understand the nature of fiscal federalism? Class, are we aware about this? Article 265, Article 266, Article 267, Article 270, and then finally we take a look at what are the coverages of Article 280 and 281. We talk about here the composition, functions and powers of the Finance Commission. This is what we get in its understanding, the composition, functions and powers of the Finance Commission, Article 280 and Article 281. Now, in addition to this, yesterday we had taken a look at two current updates on this, which are going to be a part of your questions. The current updates are, as we discussed yesterday, current update are point number A, the institution of the 16th Finance Commission under the chairmanship of Mr. Arvind Panagiria, right, 16th Finance Commission, and also the issues around the devolution suggested by 15th Finance Commission. Yesterday I had given you a little bit of an understanding of this part. So this is what basically I was referring to yesterday as covering both these aspects, the current aspects and the static portions, which are dealing with these particular questions. Okay, so all of this is, I hope, is clear to you. The issues that we were taking a look at with regard to the Finance Commission and all of these things, I hope now are clear to you. Okay, all okay here, clear? All right, so once this part is clear to you, let me now just go to understand the next thing that we're dealing with, the fiscal federalism. I hope that you are able to understand all the issues which are arising in the current updates these times because of these activities. When we take a look at fiscal federalism, the other thing which is now to be covered by us is the 101st Constitution Amendment Act 2016. The 101st Constitution Amendment Act 2016, which talks about what is known as the GST and the establishment of what is known as the GST Council. This is the part that I'm going to take a little bit of a look and understanding at what we understand by GST and the GST Council, right? That's basically another constitutional body that we might just take a look at. Article 279A of the Constitution talks about GST Council, and Article 269A of the Constitution talks about Goods and Services Tax, and this is a part of the 101st Constitution Amendment Act 2016 that we have taken a look at these areas in the Constitution. They have been introduced by these amendments made to the Constitution, right? So we'll take a understanding of this, right? Now, as for example, we have seen previously. Now, class, please take a look at this very clearly. We are trying to understand the intricacies of the goods and services taxes and how the goods and services taxes are divided between the union and the state, and what are the constitutional activities and provisions which work in the background of the goods and services taxes. That's basically what we are trying to, in a way, take an understanding of at this point. Okay. Now, once we try to focus upon what is known as the GST, as we have seen, for example, yesterday, please take a look at this class clearly. When we talk about GST right over here, the taxes which are kept by the government of India in its own pocket, the taxes which are kept by the government of India in its own pocket, and the taxes which are kept by the government of states in their own pocket. These are divided into the taxes which are given by the union list and the taxes which are given by the state list. Okay, taxes which are given by the union list and the taxes which are given by the state list. Now, as you know for a fact that the large chunk of taxes, class please pay focus on this, that a large chunk of taxes go to the union list, go to the union, comma, as there are more tax intensive subjects with the union. Okay, a large chunk of taxes go to the union as there are more tax intensive subjects with the union. Union list has more tax intensive subjects is what basically we have understood yesterday. Now, another thing that, for example, what you can understand with regard to this particular perspective is that most of the taxes which are earned by the union are direct taxes, and most of the taxes which were earned by the state are indirect taxes, right? So, if for example, we take a look at the large chunk of taxes which are coming to the union, if you take a look at the large chunk of taxes which are coming to the union, most of these taxes are direct taxes, and the large chunk of taxes which are coming to the states, most of these taxes are indirect taxes. This is the kind of division which has been created between the union and the states in terms of understanding the tax division. Okay, so for example, let's say if I have to give a very simple understanding of the difference between direct taxes and indirect taxes. Direct taxes are directly payable by the okay, so if I have to take a very simple understanding of a direct tax, the direct tax are payable directly by the person who's involved in that particular activity to the government of India. So let's say for example, if I put up a little bit of a sense to this, if let's say if I am a person who's working in a company, if I am a person working in a company, okay, if this is a person who's working in a company, right, and if this company is giving him income, if the income is being given to this person, then this person out of this income will pay a tax to the government of India. This is what is known as a direct tax. Okay, so the person involved directly is paying the tax upon this entire thing. So you have, for example, let's call this person the tax deductible or tax subject. The person upon whom a tax liability is created is himself the one who's paying that tax, is what is we understand by a direct tax. Again, I'll repeat it. A person on whom a tax liability is created is himself paying a tax. This is what is known as a direct tax. Okay, a person upon whom a tax liability is being created is himself paying a tax. This is what is known as a direct tax. Clear? That's the first point we understand. Okay, and the second point that we understand is, for example, the indirect tax. Let's say, for example, if I take an understanding of the goods and services tax, the GST, let's say. Now, let's imagine, for example, that the GST is a tax which is payable by the customers of the product, right? It's a consumption tax. It is tax paid by the one who consume, right? It's a consumption tax. What basically we understand with this particular idea is that a person who is purchasing a book, let's say he goes to a bookstore, a person is going to a bookstore and he's purchasing a book, okay, and let's say, for example, he pays, let's say, 8% GST on the purchase of the book. Okay, this 8% GST is being paid by this person who is the final consumer or the customer of the product. Okay, now this 8% GST is paid to the bookstore, right? And the bookstore is supposed to collect these taxes, but it is the case that the bookstore has already paid this tax to the government of India, right? So the government of India has already extracted this tax from the bookstore. It is not waiting for the government, for the customer to give it the tax, and then the government of India gives a position to the bookstore, gives a charge to the bookstore to collect the tax from the customer and keep it with himself. You see, so what an indirect tax looks like, for example, is very simple. That when a bookstore is selling a book and you're paying a 8% GST on that book, you are paying the government, but indirectly, because the bookstore has already paid the 8% GST to that of the government. So, for example, if I manufacture an object and if I am going to provide that object to a wholesaler, I will have to start paying the government from the time of manufacture. 8% GST has already been paid by the manufacturer to the government if a tax has been paid by the government, by the manufacturer. Okay, so the manufacturer is already paying a 8% tax to the government upon anything which is manufacturing, and then he is going to bill that 8% to the wholesaler. The wholesaler will bill that 8% to the retailer will bill that 8% to the customer, and that is how these people start reclaiming the tax which they have already paid to the government of India. You see the point? That's what we understand by the concept of a GST class. Okay, or an indirect tax. So a direct tax is basically, or in fact, you know, a kind of a good economic assumption that can work around here is that a direct tax is a tax which is imposed upon incomes. Okay, a direct tax is a tax which is imposed upon incomes, and an indirect tax is a tax which is imposed upon consumption, right? So you have two actors in an economic sphere. In every economic activity, in every economic ecosystem, you have two actors in every economic ecosystem. The first actor is the one who is, let's say, for example, producer, manufacturer, service provider. What kind of a tax liability exists upon a producer or a manufacturer is known as a direct tax, okay? And what kind of a tax liability exists upon a consumer of a product is what is known as an indirect tax. So I have given you kind of an understanding over here to just in a framework sense understand the difference between a direct tax and an indirect tax, okay? when we are trying to understand the concept of a direct tax, we are saying that a direct tax is based upon income. So for example, let's imagine a situation, class, focus upon this. If you imagine a situation like this, that if I am a producer, if I am producing goods, okay, and I am earning income by selling those goods, the charge of tax which I have to pay upon my income is a direct tax. You see the point over here. I am paying the tax to the government of India on the income that I have earned. So it is a tax which is made upon production, tax which is made upon income, tax which is made upon manufacturing, right? I am creating a value for the economy. I am selling that value in the economy to a people, and those people are going to now give me the return of that in value of currency. From that return I have received from the people who have purchased my material, I have to pay a tax to the government of India. The government of India is taxing the producers. These are the direct taxes. On the other hand, for example, if I'm not a producer, if I'm not a person who's paying anything to the government of India, I'm not producing an economic value, but I'm consuming an economic value. I am a consumer. I am the supply, the demand end of the economy. The tax which I am supposed to pay is known as an indirect tax, and this kind of a demand and supply formula is how the taxes are managed. The demand is represented by the indirect taxes and the supply is represented by the direct taxes. This is how basically the entire framework of taxation is constructed in the society, between the indirect taxes paid by the consumers and the direct taxes paid by the manufacturers and the producers. This is what basically we understand at the fundamental level to make a sense of this very clearly and very easily, right? Okay, now take a look at the point of contact. When we say, for instance, let's say if I call something like this, that most of the production taxes, what you can call most of the production slash manufacturing taxes are taken by the government of India. Because most of the production heavy and manufacturing heavy sectors, because most of the production heavy and manufacturing heavy sectors are with the union list, I can come to the conclusion that the direct taxes are mostly absorbed by the union, right? This is what basically I can take a look at. So most of the direct taxes, most of the taxes on production, most of the taxes on manufacturing, most of the taxes of what you can call services creation, etc., etc. If I am on the supply side of the economy, I am paying taxes to the union government. That is how Schedule 7 has categorized List 1 and List 2 of the Constitution, right? And the corollary to that is most of the indirect taxes, which are taxes on consumption, most of the indirect taxes which are taxes on consumption are charged by the state governments. Most of the indirect taxes, which are taxes on consumption, are charged by the state governments, right? So indirect taxes go to the states. So when you're consuming, you are putting a tax upon indirect nature, and these are collected by the states, and most of the producer taxes are collected by the union. This is how you have to understand how the union and the state lists have been divided by the 7th schedule on this parameter. Production sector goes to the union and the consumption sector goes to the state, and the management of production and the taxes of production is supposed to be taken care of by the union, and the management of consumption and the the organization of consumption is to be taken care by the state, and that is how they kind of get their tax pools. And therefore the larger chunk of taxes which come out of this, they come to the Union of India, and then a smaller chunk of taxes out of this comes into the states. Basically that is the kind of division that I'm trying to make over here. Okay, now take a look at it. When we're talking about something like a goods and services tax, first of all you have to understand that this is a regime of what is known as a indirect taxation. GST, the goods and services tax, is a regime of indirect taxation, which is also basically what we understand is that taxation on consumption. This is not a direct taxation which is taxation on production, but this is a taxation which is institutionalized as a taxation on consumption. This is what we have to understand, class. Are we getting a sense of it? This is an indirect tax, meaning the goods and services tax as we have instituted it by the 101st Constitution Amendment Act 2016 is a tax which has been imposed upon consumption, not on production, right? And therefore you have to understand that most amount of share of taxes in the GST, belongs to the states, right? It is a state's principal, what you can say, it is a principal revenue source for the states in their consolidated funds. Okay, it is a principal source of revenue for the states from their consolidated funds. Okay, so you have goods and services taxes, which is a regime of indirect taxation, which is taxation on consumption, and it is the principal revenue source for the consolidated fund of the states. This is the point that I'm trying to make over here. Okay, now let's just try to understand this. How did indirect tax work pre-GST? And then we'll ask the question, what has changed with regard to GST? Okay, so we are going to still in a way come at a point in which we'll understand how the GST works. Okay, so who is the first person paying GST to government? Is it raw material supplier or the finished producer? The raw material supplier upon the raw material, the finished producer on the finished product. There is a value which gets added when the raw material is processed into the finished product. So for example, let's say if I buy 5 kgs of cotton to produce a sweater or produce a textile out of it, then I am paying GST upon the 5 kgs of cotton when I'm buying it from a supplier of cotton, right? And he has already paid the GST to the government of India. So this is done over here. So at this point of time, I'm a consumer. And then when I produce the textile out of it, while I'm selling the textile to the market or to the distributor, I will pay a GST to the government and I will recover it from the distributor who will pay it to me. So I will bill it to the distributor, distributor will bill it to the retailer, retailer will bill it to the customer. Finally, the person who's paying the GST is the customer. he is the final end product from which the GST is recovered, but there's a line of chain of actions which moves in terms of recovering that GST, right? So the taxpayer finally is the one who's paying the government, but he is not the one who's paying it directly, he's paying it indirectly. This is how the indirect taxation regime works out, class. Am I clear now? Okay, now the question that we're asking is, how did indirect tax work pre-GST, right? Or in fact, let me just kind of give you a little bit of an addition to this. How did interstate commerce indirect tax work pre-GST? मतलब इंटरस्टेट कॉमर्स के बीच में जो एक मतलब टैक्सेशन स्ट्रक्चर लगाया जाएगा, if you have a interstate commerce activity which is happening over here, how did that work pre-GST? That is basically the question that we're trying to ask. ठीक है, आप समझिएगा इस बात को, प्लीज क्लास ध्यान से दीजिएगा. GST का करंट अपडेट्स आए हुए हैं बाहर, इस पे क्वेश्चन आ सकते हैं, थोड़ा ध्यान दीजिएगा, कुछ हो सकता है सॉल्व कर पाए आप लोग इस चीज के साथ. ठीक है, मान के चलिए, लेट्स इमेजिन फॉर एग्जांपल दैट इट इज अ स्टेट ऑफ कर्नाटका. Okay, state of Karnataka here is, let's say, producing, let's say, coconut water. स्टेट ऑफ कर्नाटका कोकोनट वाटर प्रोड्यूस कर रहा है. ठीक है, तो मान के चलिए स्टेट ऑफ कर्नाटका ने कोकोनट वाटर्स प्रोड्यूस करे, या कोकोनट मतलब नारियल पानी के नारियल प्रोड्यूस करे बहुत सारे, और फिर लेट्स से मान के चलिए कि स्टेट ऑफ उत्तर प्रदेश State of Karnataka is producing a lot of coconut water, clear? And in addition to that, state of UP is importing all these coconut waters. Imported by the state of UP. Clear? Now let's say, for example, if one, let's say, box of coconut water comes for 100 rupees, and let's say it has 8% GST. The question that I'm asking to you is this. First question. Who is the person eventually paying the GST? Option number A, is it a person from the state of Uttar Pradesh? Option number B, is it a person from the state of Karnataka? These are two questions that I'm asking class. Please tell a sense of this, yes or no, right or wrong, correct or incorrect. You're getting my question over here? If the state of Karnataka is producing coconut water and state of Karnataka is exporting that coconut water to the state of Uttar Pradesh, let's say one bottle of coconut water is sold for 100 rupees in the state of Uttar Pradesh, let's say for example the city of Lucknow, and the state of Uttar Pradesh, let's say someone is purchasing 100 rupees worth of bottle, 8% GST is paid upon that bottle. Let's imagine, so the total price is 100 plus 8, which is 108 rupees. Okay, am I clear? Then the question that I'm trying to ask is, who is the person eventually paying the GST? मतलब जो व्यक्ति GST eventually pay कर रहा है वो क्या है? इसका आंसर बताइए क्लास एक बार प्लीज. Class, who's paying the GST? Which person among these A and B is paying the GST? Class, tell me the answer, please. ठीक है, चलिए ये वाला आंसर तो आपने दे दिया कि यहां पर अगर हम देखते हैं, if the production of a particular material is happening in Karnataka and it is being consumed in the state of Uttar Pradesh, eventually it is the citizen of Uttar Pradesh who is paying the GST. ठीक है, तो जो GST पे कर रहा है वो सिटीजन ऑफ उत्तर प्रदेश है, ये बात तो मैं आपकी मान गया, चलिए बिल्कुल सही बात है। अब इस प्रश्न का उत्तर दीजिए, पॉइंट नंबर बी, इसका बताइए। चलिए, लेट मी जस्ट चेंज द अरेंजमेंट ऑफ इट। आई राइट X इज यूपी एंड Y इज कर्नाटका। बताइए, व्हाट इज द करेक्ट आंसर टू दिस? यूपी और कर्नाटका? Class, what is the correct answer to this? UP or Karnataka? What do you think should be the correct answer? Use your own logic and try to see the question as it is. That if a state of Karnataka is getting to export its coconuts to Uttar Pradesh, surely 100 rupees are being taken by the state of Karnataka. So you have a kind of a trade between the state, interstate trade I am talking about. The state of Karnataka is purchasing, is selling coconuts to the state of Uttar Pradesh, and the state of Uttar Pradesh is selling the coconuts, purchasing the coconuts from the state of Karnataka. 100 rupees are coming to Karnataka. That is the income that Karnataka is making. That is a trade that is happening between state of UP and state of Karnataka, right? But also 8% GST is paid by the person who is earning, who's in a way transacting this kind of a situation and is paying that kind of an idea. The question is, who should get the tax money? Should the tax money be given to the state of Uttar Pradesh 8%? मतलब उत्तर प्रदेश की सरकार के हाथ में आना चाहिए या फिर कर्नाटका की सरकार में आना चाहिए? Right? Now this is the point over here. If you take a look at this, pre-GST, मतलब this is why GST was known as a very solid reform. Pre-GST, consumption based taxes pre-GST consumption based taxes in interstate trade were all charged in the state of consumption, but the state where consumption is happening, and were credited in the state of production. कंसोलिडेटेड फंड। प्लीज ध्यान दीजिएगा इस बात पे क्लास। प्री जीएसटी ये हुआ करता था, कंजम्पशन बेस्ड टैक्सेस इन इंटरस्टेट ट्रेड वर ऑल चार्ज इन द स्टेट ऑफ कंजम्पशन। दैट इज ट्रू, दैट द person sitting in Uttar Pradesh is the one who is going to pay the goods and services taxes, right? The state in which the, what you can say, the consumption is happening, that person of that state will pay the tax. True, understand, okay? But also the money which was, let's say for example, if you take a look at the transaction of the state of Uttar Pradesh and Karnataka in this sense, and then we'll see what reform that GST actually bring about. If Karnataka and Uttar Pradesh are like two, let's say, what you can say, point in demand and supply, Karnataka and Uttar Pradesh. if these are two, if this is the demand and supply equation, okay, Karnataka is the producer and Uttar Pradesh is the consumer. Okay, now for example, let's say if Karnataka is selling a commodity to Uttar Pradesh, right? This is leading to a transaction in which Uttar Pradesh is giving the money to Karnataka. So Karnataka is earning the income, Uttar Pradesh is getting the value in return. This is a kind of a, think of it like an import and export between two states, right? Karnataka is giving the value, Uttar Pradesh is giving the currency, the money. Okay. But the question also is that for this value, there is a kind of a taxation which has to also be paid, 8%. And pre-GST, what used to happen, that all this taxation went to the state of Karnataka. Taxation on consumption went to the producer state. Taxation on consumption went to the producer state. This is what basically we understand as to what happens pre-GST. Okay, right? This is the situation of indirect taxes or consumption based taxes is pre-GST. What did the GST change? Now take a look at this very simply. 101st Constitution Amendment Act 2016 was initiated as a reform. It's the greatest tax reform that India had ever seen, and the most substantial, what you can say, the more substantial activity which underwent change by the 101st Constitution Amendment Act with GST was that consumption based taxes in interstate trade were all charged in the destination state but also now were not credited in the destination state but credited with the government of India and was redistributed among the states according to the recommendations of the constitutional body known as the GST Council. Class, I hope you get a sense of what I'm trying to say over here. Please read what is written over here. Please quickly take a look at it. Tell me if you understand what is being said over here. Class, please see if you can get a sense of what I'm saying. Class, this is what is the reform that was brought about by the goods and services taxes. In a way, I am indicating before you the entire language of Article 269A. Article 269A is what we're taking a look at. Please take a look at this if you can get a sense of this clearly. Class. indirect taxes that are charged in interstate trade and commerce they became this was the greatest reform which was brought about by the GST. Okay, now take a look at this very simply. If a money is coming, there's no financial committee. What is the finance? No. Yes, that's the point. For direct taxes, you have the finance commission. For indirect taxes, you have the GST council. It's a very good point. For direct taxes, you have the finance commission because most of the taxes which are coming to the union list are direct taxes only. So the direct taxes are generally dealt by finance commission. For the indirect taxes, you don't have to go to the finance commission, it is to the GST council. So you can very clearly think about it like this, that the finance commission is the GST council for the indirect taxes. That's something that you can take a look at in terms of getting a sense of what we are explaining over here. Now think about it like this. What did GST change is a question. 2016 for 101st Constitution Amendment Act, when this Constitution Amendment Act was initiated, it was a midnight session of the parliament, and the prime minister at the time had hailed the GST as the biggest economic reform since independence, right? Even overcoming the liberalization, privatization and globalization reforms is what the prime minister claimed. Okay, now if you take a look at this, let's say for instance, what is it that the GST changes? If for example Karnataka is selling to Uttar Pradesh, Karnataka is a high producer state which has a lot of productivity with itself. Uttar Pradesh is a low production state but a high consumption state because it has a lot of population with itself. So you're getting two elements of a market, a producer and a consumer, a demand, a supply and a demand. Now if state of Karnataka is selling to the state of Uttar Pradesh, the income is coming back to the state of Karnataka, that's correct. But also previously the indirect tax was a reward for people to produce higher and higher. Right, so the indirect tax was retained by the states which were higher in terms of production. The states which had higher production, those were the ones who were able to retain the indirect taxes. Okay, Karnataka would take 8 rupees also and put it in its consolidated fund and then invest it within Karnataka. That's basically what the states were doing, the pre-GST. After the introduction of the GST, the government of India, the Union of India came in picture. And it made certain amendments to the constitution, and the Union of India said that all those taxes which are paid in interstate trade and commerce, okay, all the taxes which are paid in interstate trade and commerce, those taxes are supposed to be charged not by the states in which the consumption is happening, not by the states which are producing, but by the Union of India. So Union of India in a way intermediated between Karnataka and Uttar Pradesh and said that this 8% indirect tax upon sale is going to come to a fund created by me, the union government, and this fund is going to be regulated and monitored by a committee created by the union government and the states, which is known as a GST Council. Article 279 of the Constitution creates the constitutional body of GST Council by the 101st Constitution Amendment Act. And the creation of the GST Council allows, again let me repeat it, for the union government and the states chief ministers sitting at a council in which whether 8% is going to Uttar Pradesh or 8% is going to Karnataka will not be decided or in fact the money will not be divided between Karnataka or Uttar Pradesh. It would be taken by the government of India under the GST Council, and the GST Council would then recommend how this tax pool of money which has been collected on GST which is made for inter-services trade and commerce going to work out. You see the point? The change would lead to lower production by states, perhaps, but also, don't you think that the change would lead to a higher production by the other states? And if I am paying the income tax, if I am paying the consumption tax of a particular object, right? Okay, I am paying the price for the Nariyal Pani, 100 rupees, I am giving it to Karnataka. But I am also paying a tax on the consumption, right? Now, at least the tax on the consumption should stay in my state. Okay, don't give it to me, but give it to my state so that more infrastructure, etc., can be created in my state, that I also can jump into the production spectrum. After all, it is my money. I have earned the state in money in this state. This money, which I am paying as 8% tax to the state of Karnataka, why should it not stay in my state? Is the question that the northern states starting asking the southern states. And therefore, the question therefore is slightly deeper in terms of understanding the fact that the union government said that ये जो states के बीच में परेशानी चल रही है GST को लेके, मतलब indirect taxes को लेके कि consumption destination पे होना चाहिए या फिर production source पे होना चाहिए GST का crediting. So this was the decision taken by the union government, and the union government decided that the GST is going to be submitted into a common pool, and that pool is going to be governed by a GST council which will have members from all states and the union government, and they will decide what is going to be the way in which this money is going to be distributed. So in a GST, the finance commission, for example, like a body, a finance commission body, was created for the indirect taxes, and these indirect taxes are going to be coming to the government of India, and then these indirect taxes are going to have the ability to be distributed among different states as per the formulations of the GST council. And these indirect taxes we are talking about on materials which are moving from one state to another, and the question is, which of the following two states is going to charge tax upon the consumption which has been made upon a particular thing. Okay, do you understand the point, class here? Class, am I making some sense here? Yes or no? ठीक है, I'm going to take you through Article 269 of the Constitution of India. Let's take a look at this clearly. Article 269A. Okay, please take a look at this. Just very simply. Okay, the mere definition of what is the Goods and Services Tax. Instituted by the Constitution 101st Constitution Amendment Act 2016. Okay, Article 269A, the Goods and Services Tax. Levy and collection of goods and services tax in course of interstate trade or commerce. We are talking about interstate trade or commerce, right? Now take a look at this. Goods and services taxes on supplies in the course of interstate trade or commerce shall be levied and collected by the government of India. Okay, you see the point? Shall be levied and collected by the government of India. And such tax shall be apportioned between the union and the states in the manner as may be provided by Parliament by law, on the recommendations of the Goods and Services Tax Council, GST Council. Please take a look at this part very clearly, class, to get a sense of what we are trying to say over here. Okay, this is the article in the Constitution which introduces the GST as an amendment. Levy and collection of goods and services tax in course of interstate trade or commerce. Goods and services tax on supplies in the course of interstate trade or commerce shall be levied and collected by the Government of India, and such tax shall be apportioned between the Union and the states in the manner as may be provided by Parliament by law on the recommendations of the GST Council. So, what it basically means for you is to understand the fact that the interstate trade and commerce indirect taxations are now taken in control by the, what you can say, the Goods and Services Tax Council, and it is going to be the council which is going to decide upon the apportionment of the taxes between the union and the states. That's basically what the GST in a way implies. That is what basically we take a look at under Article 269A of the Constitution. And of course, as you can see slightly in this particular activity and aspect, that there are parts of the Goods and Services Tax Council, goods and services taxes, which are going to be understood in a sense which are lean towards it. Okay, now just take a look at Article 246A of the Constitution. Just take a look at this. Special provision with respect to goods and services tax. Parliament and state legislatures have power to make laws with respect to goods and services tax imposed by the union or by such state. Okay, just try to read Article 246A alongside of what we have seen over here. Okay, just read this once. I'm going to come back to again and explain it, but just read this over here and read this part. Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods or of services or of both takes place in the course of interstate trade or commerce. Explanation. The provisions of this article shall in respect of goods and services tax referred to in clause 5 of Article 279A take effect from the date of recommended by the Goods and Services Tax Council. Okay. Now let me just summarize it for you very simply. Okay. Now please take a look at this. We are talking about the concept of indirect taxes. Class, please pay attention to what we are elaborating over here. Taking a look at the concept of indirect taxes. Yes. Now within the structure of indirect taxes, we are looking at three activities. First, indirect taxes or consumption based taxes which are coming from the union list. Okay, indirect taxes or consumption based taxes which are coming from the union list. Number one. Number two, indirect taxes which are coming from, let's say, interstate trade and commerce. Okay, where the consumption is happening one place and production is happening in another place. Okay, and third one, indirect taxes that are coming from state list. Okay, I'm just very simply reducing very simply the entire regime of the GST for you. Okay, do we understand this part? Okay, now take a look at this. We are reading article 246A plus article 269A plus article 279A, which collectively are a part of the 101st Constitution Amendment Act 2016 class. I hope that we're clear about it. Okay, now we are saying what is this, that the indirect taxes which are part of the union list shall be imposed only by a law made by Parliament on the recommendation of the GST Council. The GST Council is given under Article 269A. Clear? Do we have a sense of this? Indirect taxes which are done in interstate trade and commerce is what we talk about under Article 269A that we just read over here. Okay. I'm elaborating before you the constitutional and polity based understanding of what is known as the GST regime. Okay, class, please, am I able to make this point clear to you? We are just in a way very simply keeping before you the entire regime of the goods and services taxes as it works within the Republic of India after the 101st Constitution Amendment Act 2016. Class, please take a look at this. This was exactly a question in the main examination in 2023. And because of the developments which have happened recently, you are also expecting a question like this in the prelims examination, because you have a judgment of the Supreme Court and certain issues which have been raised by the states in concern of the GST. So please tell me if you are getting a sense of what we are trying to say over here, class, please. Right now, let's take a very quick understanding of it. If a tax is imposed upon goods and services on a subject which is given in the union list, then the Parliament of India can impose that tax on the recommendations of the GST Council. The GST Council is instituted in Article 279A of the Constitution. One, done. Okay. Second, if a law is made, if a tax is to be imposed on a subject which is given on the state list, the tax to be imposed is supposed to be a, what you can say, on the goods and services. So if on the goods and services a tax is imposed upon the subject which is mentioned in the state list, if on the goods and services tax is imposed upon a subject which is mentioned in the state list, then such tax shall be imposed by the state legislature on the recommendation of the GST Council. Right? Second, and if a tax is imposed upon a subject in which there is interstate trade and commerce, for example, there is one producing state and another consuming state, then such tax shall be imposed by a law made by the Parliament with the recommendations of the GST Council. This is what is known as the IGST. So you have the concept of the CGST, the IGST and the SGST, which have cropped out from Article 246A, 269A and 279A, which are basically the statutory provisions given in the Constitution with regard to what is known as the GST 101st Constitution Amendment Act. Class, am I making my point clear? Do you have a clear design of how the GST is implemented? We know for a fact that laws are needed before you impose a tax. So if it is a tax upon goods and services, it cannot be imposed without a law, right? Now, if it is a goods and services listed in the union list, then the law shall be made by the Parliament, but the Parliament shall also act according, or not, the Parliament may also act according to the recommendations of the GST Council. If there is a subject which is mentioned in the state list as a goods and services, and if a law has to be made to impose a tax upon those goods and services, then it is a state legislature which can make that law, but that state legislature must also at least consider the reports of the, or the recommendations of the GST Council. And if there is a tax which is made in terms of interstate trade and commerce, when one is a producing state and another is a consuming state, and if the tax is to be decided between the producer and the consumer state, then that money, that tax shall be decided by the Parliament by making a law with the recommendations of the GST Council. This is what is known as the IGST. Class, am I laying out the framework of the GST and the GST Act and the GST Council, etc., etc., clearly before you? Tell me if there's something that you have missed out and I'll explain it again, class. Please ask me. Class, do we get a sense of this here? Yes or no, class? Say something at least, you're there. Hmm. ठीक है. I'll explain it with an example as you're asking. Let's take a look at this. Please understand this via an example, class. It's important to be very clearly aware of the conceptual underpinnings of this. Please take a look at this again. I'm trying to explain it with an example over here. Okay. Let's say, for example, there is an insurance policy. Insurance is a union subject under the Schedule 7. This is an insurance policy. Insurance is a union subject under the Schedule 7. Okay. Let's say this is a lottery ticket. Gambling is a state subject. Under Schedule 7. Class, am I clear about this? Now let's say, for example, if I buy an insurance policy of, let's say, 100 rupees, if I purchase an insurance policy of 100 rupees, okay, I will have to pay, let's say, for example, 10% indirect tax upon this. Indirect tax in this regime is understood as the goods and services tax. Okay, I will have to pay a 8% indirect tax GST. The question is, who decides this rate? And the question is about levy of tax and the collection of tax. Okay, this is basically the question, right, class? Who decides this rate and who collects this money? This is basically, I'm asking the question. So first of all, let's say if I'm buying an insurance policy. Now please, class, focus, get a sense of this once and for all. Okay, there are going to be questions around this area. Last year only in the main examination you have a question like this. Have you seen the question? Prelims और मेंस के लेवल पे इंटरव्यू में बहुत इंपॉर्टेंट चल रहा है जीएसटी आजकल. If you take a look at the UPSC main 2023 paper, question directly from what we are teaching over here. All of these things I was teaching exactly the same time last year, and now also they're relevant because you have many much current updates upon this. ये देखिए, ये क्वेश्चन आया है, ठीक है, जीएसटी करंट अपडेट्स में चल रहा है। देखिए 2023 का प्रश्न पत्र है ये। GST is working is involved in the current updates. Please take a look at this clearly now, class. ये सारी चीजें आपके आ रही है, करंट अफेयर में है ये सारी चीजें। Explain the significance of 101st Constitutional Amendment Act. To what extent does it reflect the accommodative spirit of federalism? It's 250 word question, 15 marks. राइट, ये आपके क्वेश्चन मेंस में आए हैं, ये आपके क्वेश्चन प्रीलिम्स में आ सकते हैं इनके आसपास के, क्योंकि जीएसटी थोड़ा थोड़ा इस समय कॉम्प्लिकेटेड चल रहा है। स्टेट्स और केंद्र के बीच में जीएसटी को लेकर थोड़ा थोड़ा मतभेद हो रहा है। पहले तो बहुत हुआ था, अब थोड़ा कम हो गया, लेकिन फिर भी थोड़ा होता रहता है। ठीक है, अगर मैंने एक इंश्योरेंस पॉलिसी खरीदी और मैंने उस पर 8% टैक्स दिया तो दो क्वेश्चन हम पूछेंगे। Who decides the tax rate, which is levy of taxes, right? And the second question is who collects a tax? Okay, do you see the point here? Now the answer to that question is Union of India, of course, because Article 246 says, 246A says that if it is a union subject, a law shall be made by the Union of India for the levy and collection of the tax. However, the Union of India shall work ठीक है, ये समझ में आ रहा है? Am I able to explain this clearly? Insurance policy is a union subject. Therefore, if I purchase insurance policy, it is the Union of India which decides the amount of tax, and it is the Union of India which collects the tax. But this decision on the amount of tax and this decision of collecting the tax is made by the Union of India on the recommendations of the GST Council. But the recommendations of the GST Council are not binding upon the Union of India. Let me be clear about that also. These recommendations are not binding upon the Union of India. ये अभी सुप्रीम कोर्ट ने क्लैरिफाई किया है इस मैटर को, इसीलिए हम थोड़ा इस पे ध्यान दे रहे हैं। These recommendations are not binding upon the Union of India. ओके, ये वाला एग्जाम्पल समझ में आ गया। और अब मेरा क्वेश्चन ये है कि दूसरा वाला जो हमने एग्जाम्पल देखा था कि अगर मान लीजिए, इमेजिन करिए कि लॉटरी टिकट अगर वैलिड है, इफ लॉटरी टिकट्स आर वैलिड, मतलब अगर एक किसी प्रदेश में गैम्बलिंग को वैलिड कर रखा है, जैसे मान के चलिए कि लेट्स से फॉरगेट अबाउट लॉटरी टिकट, लेट्स से आई गो टू गोवा and in Goa I go to a casino. Okay, if I go to Goa and to Goa I go to a casino, and in the casino, let's say for example, in the casino I am paying a card game of 100 rupees, and let's say the policy says that on any card game purchased worth 100 rupees, you have to pay a 10% GST. मतलब सरकार इससे पैसा कमाएगी, 10% GST आपको लेना पड़ेगा। ठीक, you get the point? So in this situation, the question is, who decides and who collects? That's the question. And the answer is state of Goa, by passing a law. On the recommendation of the GST Council. Does it make sense? Clear? Now this is what basically we understand as an SGST, and this is what we basically understand as a CGST. ठीक है, तो ये तो आपको दोनों कैटेगरी समझ में आ गई, और इसके साथ साथ क्या होगा और जीएसटी काउंसिल का इसमें क्या रोल है. The recommendations of the GST Council are not binding upon the state of Goa, is what the Supreme Court has held. The recommendations of the GST Council are not binding upon the state of Goa, is what the Supreme Court has held. Okay, are we clear about this, class? ठीक है. Now let's take a look at this in a final sense. If an insurance policy is issued by, let's say, Max Life Insurance, which is based in Karnataka, okay, but let's say if this Max Life insurance policy is bought by someone in Lucknow for 100 rupees, and let's say there is a 7% GST upon this, the question again is, who will decide, and the question is, who will collect, किसके पास रहेगा. Now, what is the answer to this? Parliament by making a law on the recommendation of GST Council. On the recommendation of the GST Council. Okay, and this law, which is basically going to be made by the Parliament in giving effect to what is known as the IGST. Right? Do we have an understanding of this, class? This is what inclusively we take a look at with regard to Article 246A, Article 269A in terms of creating these taxes. Okay, so the question over here is that you have the IGST, you have the CGST, and you have the SGST. And this is basically what we are, in a way, taking a look at in terms of the GST tax regime, right? Now, if we are focusing, let's say for example, only upon this part, let's say I'm focusing upon GST, which is, let's say, GST, which is in intrastate trade and commerce. GST which is paid in intrastate trade and commerce. Okay. It is collected by the union, but then it is divided between and then among the states. The same kind of a, what you can say, vertical devolution and horizontal devolution of indirect taxes on the recommendation of the GST Council. You get the point, class? Over here we are preparing a kind of an entire understanding of how the GST is working and how these activities are working. Now I'm going to take you specifically to this part, again article 269A of the Constitution, and then we'll just move to the GST Council and get a current update upon it. Goods and services tax on supplies in the course of interstate trade or commerce shall be levied and collected by the Government of India, and such tax shall be apportioned between the Union and the states in the manner as may be provided by the Parliament by law on the recommendations of the Goods and Services Tax Council, GST Council. Okay, just take a look at this. This idea shall be apportioned between the Union and the states. This is what basically we are trying to understand over here. Article 269 on goods and services collected in the category of interstate trade and commerce. By interstate trade and commerce, we means that when the producer state is A and the consumer state is B. Please इसको ध्यान से पढ़िए एक बार. Just try to get a sense of this clearly, class, please. Okay. Now, so you're right about that. I probably should not have taken the example of insurance. Yes, you're right about it. As I pointed out correctly, that there is a what you can call IGST is what we understand interstate trade and commerce only on state subjects. So you're right about it. On interstate trade and commerce of subjects which are under the union list, they would form under the CGST. Interstate trade and commerce only on state subject is IGST. Yeah, so I'm sorry, I just went along with the example over there. But insurance will not have the example of IGST, it will have the example of CGST. But if I take the example of lottery tickets, sorry, if I had taken the example of lottery tickets over there, lottery tickets would have been under the IGST, right? Now, do we have an understanding of what the integrated GST is, the integrated goods and services tax, which basically allows the states who are importing and exporting with each other to decide in whose account the money is going to be, and the money is not going to go either in the account of the state which is importing or in the account of the state which is getting it, but the money will be decided by the GST council as to who will get it. That's where basically the entire idea of GST as a tax reform has been structured. Okay, you get the point? Now, when I take a look at, for example, this idea that it is the GST council which is supposed to sit at the center of this entire thing. GST council shall sit at the center of this entire thing, and GST council is a body which is composed of the finance minister, union minister of finance, and the state finance minister, meaning the finance minister, MOS, minister in charge of the state. These two are going to be the people who are sitting in the GST council. And apart from this, the GST council will have a table for finance ministers of the states finance minister of all the states in the country, right? All of these finance ministers are going to be sitting at the GST council. So GST council is a kind of an integrated body which is created by the finance minister of the union and the states, and these are the ones who are going to take a decision upon these matters, right? So the rates of the GST council decided by the GST council will inform the CGST, will inform the SGST, and will inform the IGST, right? And in this specific case, when we are taking a look at IGST specifically, IGST mein GST council will also determine how this money has to be apportioned between the union and the states. जैसे मैंने आपको कल बताया था, this is a kind of a similar function which the finance commission has for direct taxes. A very similar function the GST council has in the case of indirect taxes, right? This is how we are in a way completing the entire idea of Article 246A and Article 249A to institute a tax regime on what are known as the indirect taxes, right? And if you, for example, take a look at a question like this, if you have a question like this, to what extent does it reflect the accommodative spirit of federalism? The accommodated spirit of federalism is reflected in IGST, the integrated GST, in which previously, as we had understood, that the IGST, the GST which is done in interstate trade and commerce, was collected by the producing state and was actually demanded by the consuming state. Now, the IGST which is collected by the Government of India, and the Government of India, on the recommendations of the GST Council, can transfer the IGST to the state government where the consumption of the product is happening, trying to make this a consumption driven tax, meaning the tax has to be a kind of a destination based indirect tax in which the territory or the area where the consumption of a particular entity is happening is the one in whose account this kind of indirect tax can be accrued, which means that, for example, the producing states which were earning money previously, class, please take a look at this very clearly. The producing states which were earning money previously, these producing states are giving up upon their indirect taxes which were coming to them, and by entering into the tax regime, they're allowing the GST Council under the Union of India to give that money to states which are consuming, or to the states which are needing some kind of an incentive to create their own production system so that they can be self-sufficient in some ways and be able to deal with their own problems properly. This is the real element of change which has been brought about by the GST under the principles of accommodative spirit of federalism, right? So the producing states have shown some kind of an accommodation with regard to giving this section a spirit of federalism. That is what basically we have to understand in this part, class. Okay, now I want you to take a look at the Supreme Court judgment upon the matter, right? This is what we are basically most importantly concerned with. This is the current update we are most looking after. Take a look at this. This is a judgment given by the Supreme Court in the year 2022. Union of India versus Mohit Minerals. This is the judgment of the Supreme Court we are going to take a look at and refer it to it clearly as to what the questions are asked over here. The judgment is given by the current Chief Justice of India, but at the time only the Justice, which is Mr. Dhananjay Y. V. Chandrachud. Just 1 second, let me pull out the relevant section of the judgment. Take a look at this as a little bit of a summary of it. Before we proceed to analyze the wires of the impugned notification, it is pertinent to contextualize the constitutional architecture of the GST. The Constitution's 101st Amendment Act 2016 was enacted on 8 September 2016, introducing Article 246A, 279A and 246A. Article 246A stipulates that both the Parliament and the state legislatures have the power to legislate on the GST. Right? This we have taken a look at. 279A constitutes the GST Council, which shall make recommendations to the Union and the states on a wide range of subjects. So we have just taken some understanding of what the GST Council is and the composition of the GST Council. Okay. Now, the question that was basically raised by the union government over here is, the union government has contended that the recommendations of the GST Council are binding on the legislature and the executive. It was submitted that since the recommendations are binding, the rule making power of the government under the provisions of the IGST Act and the CGST Act exercisable on the recommendations of the GST Council are also very wide. The arguments of the union government are as follows. Right, this is what basically the constitutional question that became relevant over here is. One of the questions that you were asking is, are the recommendations of the GST Council binding? Now that is the answer that I gave at the time, just in a simple summary format. But if you take a look at it, that question, whether the recommendations of the GST Council are binding in terms of giving the state, let's say for example, if the state wants to impose a GST and the GST Council says that this is not the GST that you can impose, are the recommendations of the GST Council going to be binding upon that state with regard to its own activities, right? And we'll take a look at this. A combined reading of Article 246 and 279A elucidates that the GST Council is the ultimate decision-making body in framing the GST law, since it is a constitutional body that acts as a converging platform for both the union and the states. The functions and the role of the GST Council are unique and incomparable to other constitutional bodies. Therefore, interpretations of other provisions of the Constitution do not have precedential value while interpreting the role of the GST Council. This is the argument which has been made by the union government, stating that the recommendations made by the GST Council are binding. And this is basically the question that was put in front of the Supreme Court, whether a state government under Article 246A, now take a look at this basically. Under Article 246, it is written that a state legislature may impose a goods and services tax upon a subject which is mentioned in the state list. A state legislature may make a goods and services tax upon a subject which is made under the state list and impose a tax upon it and collect the tax upon it if it is not an interstate trade and commerce with the recommendations of the GST Council. That is what is given under Article 246A. The question is, if a state assembly goes ahead and makes a law which is not in concurrence or not in harmony with the recommendations of the GST Council, which is dominated by the union slightly, then is it constitutional or unconstitutional, is the question that was asked before the Supreme Court in this particular matter. Right? Do you get a sense of what I'm trying to say over here? The recommendations, whether binding or not binding, before the idea over here. Now, this is a 3-judge bench of the Supreme Court, Justice Chandrachud, Justice Suryakant and Justice Vikramnath. These 3 judges of the Supreme Court decided on this matter. The Supreme Court on Thursday, in a judgment championing the importance of cooperative federalism for the well-being of democracy, held that union and state legislatures have equal, simultaneous and unique powers to make laws on goods and services tax, and the recommendations of the GST Council are not binding upon them. This is the judgment that had come from the Supreme Court of India in what is known as Mohit Minerals versus Union of India. Class, am I making the point clearly here? The judgment which has come from the Supreme Court of India is on this particular aspect, are not binding on them. The apex court's decision came while confirming the Gujarat High Court ruling that the centre cannot levy integrated goods and services tax on ocean freight from Indian importers. The recommendations of the GST Council are the product of a collaborative dialogue involving the union and the states. They are recommendatory in nature. The recommendations only have a persuasive value. To regard them as binding would disrupt fiscal federalism when both the union and the states are conferred equal power to legislate on the GST, a bench held by Justice Chandrachud held. The court emphasized that Article 246A, which gives the state powers to make laws with respect to GST of the Constitution, treat the union and the state as equal units. It confers a simultaneous power on union and states for enacting laws on GST. Article 279A, in constituting the GST Council, envisions that neither the centre nor the states are actually dependent on each other, Justice Chandrachud interpreted. He said that the centre and the states were autonomous, independent and even competing units while making GST laws. Cooperative federalism is treated like a marble cake federalism due to the integrated approach of the federal units, he compared. The judgment said that though the center may have larger share of power in certain instances to prevent chaos and provide securities, the state still wield power. India is a multi-party system. It is possible that the party in power in the center or may not be in the power in the other state. Even if the states have been given lesser power in certain situations, they can still resist the mandates of the union by using different forms of political contestations permitted by the constitution. It is not imperative that one of the federal units, center or the states, must always possess a higher share of power over the other units, the court stated. Now, do you get a sense of this? I am going to cite before you very simply the judgment of the Supreme Court in Mohit Minerals versus Union of India 2022. The crux of that judgment is that wherever we have, for example, the concept of a GST Council recommendation, that GST Council recommendation is not binding upon the states. This is what basically we are taking a look at. GST Council recommendations are not binding upon the states. Okay, I'm just citing the current update upon the GST. So now what does it mean for us? Let's say, for example, if you go to the chart that we have prepared over here. Just take a look at this, and everywhere you see, you can get a sense of how this chart is supposed to work out, right? If you have, for example, a indirect tax in the union list, the law can only be made by the parliament, but the parliament is not bound by the GST Council. If you have a indirect tax which is given in the state list, which is not an interstate trade or commerce, that law can be made by the state legislature, and in this particular case, the state legislature is not bound. In this particular case, the state legislature is not bound by the activities of the recommendations of the GST Council. So this is where the not binding impact can come. And if the question basically asks you, can a state legislature on its own create a GST? Can a state legislature on its own create a GST which is against the recommendations of the GST Council? The answer is correct according to the Mohit Minerals versus Union of India judgment of the Supreme Court, right? That's exactly what we are trying to take an understanding of. Okay, right? ठीक है. Now just one last thing, if I can complete this up properly. When we ask the question about IGST, when we ask the question with regard to IGST, then the question is that whenever there is an interstate trade and commerce, whenever there is a question of interstate trade and commerce, though the subject is given in the state list, class, please be very clear to it. Whenever we're talking about interstate trade and commerce, though the subject is given in the state list, a IGST, which is an interstate trade and commerce, goods and services tax, can only be imposed by a law made by the parliament. Okay, so if you have, for example, the question that can a state create an IGST against the recommendations of the GST Council, the answer is incorrect, because the state does not have the power to create an IGST. The state has no power over an IGST. The power over an IGST is given specifically to the center, to the union, according to Article 246A of the Constitution. As you can see it, that a IGST can only be created and regulated by the union. Parliament has the exclusive power to make laws with respect to goods and services tax, with a supply of goods or of services, or both takes place in the course of interstate trade or commerce, which is covering Article 269A of the Constitution. So in the cases of Article 269A of the Constitution, where you have a integrated GST, even if it is a state subject, the law can be made by the parliament exclusively, not by the state, because the power on that has been given to the parliament. Now, if for example you take a look at it in a more politically sensible term, there are, for example, states like Tamil Nadu, states like Kerala, states like Karnataka, which have a huge production ratio. Okay, they produce a lot of money, and this basically in a way implies to suggest that under the GST Act or under the amendments made by the GST, there are three kinds of taxes which can apply upon the people of Karnataka. One is the IGST, one is the CGST, and the other is the SGST. Okay. Now, for example, if the people of Karnataka are paying a CGST and an SGST, right, then what you are looking at is that the CGST can be made by the parliament with or without the recommendations of the GST Council. SGST can be made by the state with or without the recommendations of the GST Council. And IGST can only be made by the parliament with or without the recommendations of the GST Council. This is going to be today the position after the judgment of the Supreme Court has been given in Mohit Mineral versus Union of India. Class, am I getting a point clear about it over here? This is a Hindu editorial that came in the newspaper that we'll take a look at in terms of getting a sense of this. Pronouncing its verdict on a protracted dispute over the levy of goods and services tax on ocean freight charges paid by importers, the Supreme Court on Thursday said that such tax was untenable. Its 153-page judgment also has dwelt at the length on the nature of recommendations of the GST Council, the constitutional body set up to oversee the operations of the indirect tax regime. Invoking the spirit of cooperative federalism, the court has held that the union and the state legislatures have equal, simultaneous and unique powers to make GST laws, and the recommendations of the council, where they have 1/3 and 2/3 voting share respectively, are not binding on them. While amending the constitution to pave the way for tax system that subsumed multiple central laws and state levies, Parliament had intended for the council's recommendations to only have a persuasive value. As per the court, please, you have to be very sure about making this point understood properly. This has sparked fear that individual states can start vetoing the council's recommendations that they do not agree with and refuse to implement them, thus threatening one nation, one tax edifice of a reform that took years to bring about. Opposition rule states have hailed the verdict as upholding their rights vis-a-vis what few termed as arbitrary imposition of centre's decision in the council. The finance ministry has sought to quell anxiety by indicating that the court has only elaborated on the council's existing arrangement and the status quo would continue. States can already reject the council's decisions, but none has chosen to do so far, it said. While North Block undertakes a detailed review of the verdict, it is pertinent that it had argued that if the council's recommendations were not binding, it would lead to an impasse and the entire GST structure would crumble. This does not hold water, the court averred. That is, it has struck down a tax notified 2 days prior to the launch of the GST regime, just as it is on the verge of completing 5 years, is perhaps a fortuitous nudge for introspection on its journey and the way ahead. At worst, it can trigger more contestation in the council meetings and at best infuse a fresh sense of responsibility among members. The centre could strive to be more conciliatory towards states' concern and fiscal dilemmas, especially as their assured compensation clock winds down next months, rather than seek to bulldoze over thorny predicaments with the tacit support of the NDA rule states and the council. The council should also meet more often to nurture the critical fiscal federalism dialogue on the right direction, and minimize trust deficits. There are many pending reforms that require the center to work more cohesively with the state to take India's economy forward and lift those left behind, including but not limited to an overhaul of land and labor markets as well as the agrarian sector. You get the point over here, right? I hope now this point is entirely clear to you with regard to what is we understanding in the nature of GST Council. Now, take a look at this quickly. GST compensation cess. Okay, so this is one part that we have covered with regard to the recommendations of the GST Council not being binding in the judgment given by the Supreme Court. Now, let's take a look at this. GST compensation cess specifically refers to IGST. Now, please pay attention to this class. We are trying to decide an entire matter upon GST, which is in the current updates for the last 4 years. GST compensation cess. Okay, let's get a very simple thing cleared out of the way to be able to finish this entire chapter upon fiscal federalism. GST compensation cess. Okay. When we are talking about the concept of a GST compensation cess, the term that we are most importantly in understanding is shortfalls. Okay, so now please just try to focus upon what I'm trying to create as an argument over here. Okay, just take a look at this. Because of the implementation of the IGST class, because of the implementation of the IGST, the Supreme Court, sorry, the Parliament now, because of the implementation of the IGST, the Parliament can now take taxes which are being taken from the state of Karnataka to the state of Uttar Pradesh. So, state of Karnataka is a producer state. Okay, class, please focus upon this. Okay, we are nearing the completion of this entire thing. State of Karnataka is a producer state and the state of Uttar Pradesh is a consumer state. Class, please focus upon this clearly. State of Karnataka is a producer state, state of Uttar Pradesh is a consumer state, right? Let's say, for example, if a kind of a trade happens between the two of them on a subject mentioned in the state list, then you know for a fact that an IGST would be given out over here, right? And now the scheme of course this entire thing is that if let's say 100 rupee sale is made in Uttar Pradesh and 8% GST is paid to this person, this GST is going to be given to the Union of India. The Union of India will have the GST of 8 rupees, and then the Union of India may decide on the recommendations of the GST Council. The Union of India may decide on the recommendation of the GST Council to give this money to the state of Uttar Pradesh. The Union of India may decide according to the GST Council to give this money to the state of Uttar Pradesh, right? Do you understand? So in a way this has made an effectuation by which the GST has become a destination based tax, meaning it has to be collected by the state in which the consumption is happening, right? The indirect taxes are to be collected by the states inside which the consumption is happening. That is what basically we are taking a look at with this entire thing. Now let's say when the states agreed to this entire thing, let's say if you have the number of states like Karnataka, like Andhra, like Tamil Nadu, right? Let's say, for example, Telangana. If you take a look at these states, these are high producing states, okay? These are high producing states. And previously, these high producing states, Telangana, Tamil Nadu, Karnataka, Andhra, previously these high producing states had a lot of tax money coming in from the inter-trade commerce on taxes. You see what I mean to say? That if they are producing in Karnataka, if Nariyal Pani is being produced in Karnataka, sold in Uttar Pradesh, the tax which was coming before GST on Nariyal Pani, sales tax, was being given to the state of Karnataka. So Karnataka was getting the money upon it because it was a state subject. And state subject was interpreted in such a manner that if it is a state subject, it has to be collected by the state of Karnataka only. Do you get the point? So the idea was that the GST or the service tax or the service sales tax would be collected by the state which is producing the commodity rather than the state which is consuming the commodity. It would be submitted in the hands of the state which is producing the commodity. That was the basic idea that was behind the entire activity of understanding this part particularly, right? Now, with the GST, what happens is that the tax which is collected by the state of Karnataka is now to be given to the government of India. And government of India, generally what it is going to do is going to now credit this tax in the account of the consolidated fund of the state of Uttar Pradesh to make the reform in GST, which is to make GST a kind of a destination based tax. That's basically what the state governments wants to achieve, the union government wants to achieve out of this, right? A destination based tax has to be made out of this entire thing called the GST, right? Am I clear now? Now, why did the state of Karnataka, state of Tamil Nadu, state of Telangana, state of Andhra, state of Gujarat, state of Maharashtra, which were high producing states, why did they agree to the GST? You see, the GST was brought as an amendment to the constitution and it also required a ratification by the 50% of the states. So why is it that the state of Maharashtra, state of Karnataka, state of Tamil Nadu, state of Andhra, state of Gujarat, all these high producing states agree to the policy of the center to take away their tax money and give it to the state of Uttar Pradesh, etc., etc.? Why did they ever agree to sign upon something like the GST and bring about the 101st Constitution Amendment Act when clearly their money is being taken away from them? Why would these states agree? That is the question. Now, the answer to this question is in two parts. One part is cooperative federalism or the accommodative spirit of federalism. That these states were convinced by the union government that it is necessary for the growth of you to ensure that states like Uttar Pradesh, Bihar, Madhya Pradesh, Rajasthan, they also grow simultaneously. We cannot have, again, as I mentioned last time, a lopsided idea of growth where some states keep growing and the other states are not getting there anywhere, right? And it is the responsibility of the growing states, of the developed states, to take care of the states which are needing to develop, and therefore the tax money that you will compromise and would be given to them would be used by these states into making sure that their productivity and their activities are taken into a control, right? They can set up their infrastructure, their industries, their commerce, their trade activities and everything. So that 8 rupee shall be given to them for their own purposes. That is something that you will have to cooperate with. Cooperation के साथ चलना पड़ेगा, accommodation के साथ चलना पड़ेगा, accommodative spirit of federalism. That was a question in 2023 main examination. That was the first reason. So these states agreed. They said, okay, fine. We are going to wait for states like Uttar Pradesh and Bihar to catch up, and we will help by the hand of this entire activity for them to get a kind of a catch up out of this. They want, in a way, we agree with the fact that these activities must be done in a way which are proper, and we should wait for these states also to catch up. And if we have to take a haircut financially and give the money that used to come to us, we will do this, and we will join the tax regime and create the structure of the goods and services tax, right? This was the answer, which was basically the conceptual underpinning of the concept of cooperative federalism, which became the keyword of the GST reforms, also known as the accommodative spirit of federalism, as was mentioned in the 2023 main examination. This was one answer. But the other answer, if you take a look at it, the other answer which was associated around this was the GST compensation cess. The other reason why these states agreed was because of a promise made by the government of India, that the government of India will ensure that a compensation, class please take a look at this very clearly now, we are ending this part, a compensation must be paid to the states facing a shortfall due to the IGST. So the idea is over here, for example, let's say if you have the state of Karnataka or if you have the state of Andhra Pradesh, which are, let's say for example, their tax collection in an ordinary year is 100 rupees. Okay. Now let's say for example, because of the IGST, they are losing, let's say 15% of their tax collection is being lost. Class, please take a look at this here. If a state like Karnataka is earning 100 rupees in tax collection in an ordinary year, pre-GST. Before GST, the state of Karnataka is earning 100 rupees. If before GST, the state of Karnataka is earning 100 rupees, you get the point I'm trying to make over here? The question is, how much is it earning in terms of taxation coming down because of the imposition of the GST? That's the question. Right? And let's say the answer is 15%. 15% GST was earned by the state of Karnataka by interstate trade and commerce, right? 15% is interstate trade and commerce, which means it becomes a part of the IGST. Now, what the union government promised the state of Karnataka was that this, which is identified as your shortfall, this which is identified as your shortfall, the 15% rule which is identified as your shortfall, we will compensate for it. मतलब आपको जो 15% का नुकसान हो रहा है ना, क्योंकि आप पहले वो टैक्सेस अपने पास रखते थे, अब आपको वो टैक्सेस सरकार को देने पड़ रहे हैं, केंद्र सरकार को, और केंद्र सरकार उन टैक्सेस को उत्तर प्रदेश को दे रही है. तो आप ठीक कर रहे हैं, मतलब जो आप कह रहे हैं वो सही बात है कि कोऑपरेटिव फेडरलिज्म होना चाहिए और उन राज्यों को उनका पैसा रखने की अनुमति होनी चाहिए, क्योंकि उनके राज्यों में कंजम्पशन हो रहा है, तो उनके राज्यों के कंजम्पशन को, पैसों को वहीं छोड़ दे तो बेहतर है, जिससे कि वो अपने खुद पैसे को किसी प्रकार से डील कर सके. तो कर्नाटक इत्यादि इन सब प्रदेशों ने कहा ठीक है, हम बात मान जाएंगे आपकी कोऑपरेटिव फेडरलिज्म की स्पिरिट में कि हमको बाकी राज्यों के लिए रुकना है, शांति से उनको साथ में आने देने का समय देना पड़ेगा. ठीक, बात सही है. लेकिन उसके बाद सरकार ने यह भी प्रॉमिस किया, केंद्र सरकार ने, कि आपकी जो शॉर्टफॉल है ना, मतलब आप 100 रुपए कमाते थे, यूज्ड टू अर्न 15 रुपीज, एंड बिकॉज ऑफ द GST you are not earning 15 rupees which were earned by you in interstate trade and commerce, हम लोग उसकी भरपाई करेंगे, हम आपको 15 रुपए अपने आप देंगे निकाल के. Right? So the union government promised to give compensation to the state of Karnataka for the shortfalls that it is receiving because of the implementation of the GST regime. Do you understand the point I'm trying to make, class, over here? Right? And for giving this kind of a compensation, class, to be able to give this kind of a compensation, a new compensation cess was made by the government of India, which is known as the GST compensation cess. भारत सरकार ने एक नया प्रकार का compensation cess बनाया, GST compensation cess. GST compensation cess is applicable on luxury and sin goods. तो मतलब सही बात है कि आप भरपाई करेंगे, लेकिन भरपाई का पैसा कहां से आएगा? We are going to compensate the state of Karnataka, the state of Tamil Nadu, the state of Andhra Pradesh, the state of Gujarat, the state of Maharashtra for the shortfall that they are receiving because of the implementation of the GST. IGST के आने से जो पैसा पहले आपके पास आता था वो उत्तर प्रदेश के पास जा रहा है, जो कि कंज्यूम कर रहा है. तो ये आप कोऑपरेटिव फेडरलिज्म के लिए तो कर रहे हैं, लेकिन इसके अलावा भी हम आपको पैसे की भरपाई करेंगे 5 साल के लिए, 5 years. 5 years your shortfalls, मतलब जो आपका पैसा पहले आता था उतना पैसा हम करेंगे। तो मान के चलिए तमिलनाडु के पास पहले 100 रुपए आते थे, अब 15 कम हो जाएंगे, 85 हो जाएंगे, ठीक है। अब 15 में से मतलब 85 में से जो 15 कम है, द वंस विच आर मिसिंग आउट ऑफ 85, दे विल बी एडेड बाय द जीएसटी कॉम्पनसेशन सेस। तो ये वाला जो पैसा है इसका कॉम्पनसेशन आपको दिया जाएगा। लेकिन प्रश्न ये है कि ये पैसा आएगा कहां से कॉम्पनसेशन देने के लिए, और इसका उत्तर यह है कि एक नया सेस लगाया जाएगा। अ न्यू सेस इज गोइंग टू बी इंप्लीमेंटेड ऑन द पीपल ऑफ इंडिया हु आर कंज्यूमिंग लग्जरी एंड सिन गुड्स, ठीक है। तो मतलब जैसे मान के चलिए कि अगर किसी व्यक्ति ने एक शैंपेन की बोतल ली इंपोर्टेड, ठीक है, बहुत महंगी वाली, तो उस शैंपेन की बोतल पे जो कि इंपोर्टेड है उस पे 10% जीएसटी कॉम्पनसेशन सेस देना पड़ेगा। आपको पता है सेस is a kind of a earmarked tax, right? A cess is what is understood as a earmarked tax. Earmarked tax होता है मतलब cess does not form a part of the consolidated fund of India. जो भी consolidated fund of India में पैसा रखा जाता है उसका कोई दिशा निर्देश नहीं होता है, ठीक है। मतलब जब हम आपसे टैक्स लेते हैं, when I take money from you as taxation money, I don't guarantee to you that this money is going to be spent over here or over here or over here or back to you. I don't give you any such guarantee. That is why it is called the Consolidated Fund of India, as we discussed it yesterday. But when we talk about a cess, जब हम cess के बारे में बात करते हैं, if we talk about cess as a cess as a kind of a instrument of taxation, then what we see is that cess is an earmark tax, which means cess is collected for a particular purpose and is to be given for that purpose only. You have the example of a Swachh Bharat cess or an education cess. Now, if you are paying an education cess or a Swachh Bharat cess, you know for a fact that this money is only going to be spent upon education. So, when I am paying education cess, I know that this money is going to be put in a separate account out of the Consolidated Fund of India, which is going to be the education cess account. And while I am paying 15 rupees on education cess, I know for a fact that these 15 rupees on education cess are going to be spent only upon the subject of education and nothing else. You see, that's basically what we identify and understand with the concept of a cess. Am I clear, class? Okay, so cess is an earmark tax. It is not becoming a part of the Consolidated Fund of India, and like the other taxes which become a part of the Consolidated Fund of India, in which the guarantee is not given that this money would be spent on this amount or that amount or this category or that category. That has to be decided later on by the parliament where the money will be spent, but the taxpayer is not given any clarity or guarantee कि आपका पैसा ऐसे ही खर्च किया जाएगा। लेकिन सेस में आपका पैसा एक प्रकार से ही खर्च किया जाता है। By the use of cess, your money is spent in one particular manner only, and that is already determined. For example, if you pay a Swachh Bharat cess or an education cess, as I repeat it again, the money which you are paying for education cess or Swachh Bharat cess is going to be given only for the purposes of education or Swachh Bharat. It is not going to be given for something else, and therefore this money does not become a part of the Consolidated Fund of India. It is kept outside or in the public account of India. Do I make my point clear, class? Now, the government of India passed a law creating the GST compensation cess, and the government of India said that the shortfall that has been received by these states for the implementation of the GST, and especially because of the IGST, the Interstate Trade and Commerce, which has led to the taxes of interstate nature move from the producing state to the destination state, it is creating somewhat of a shortfall in terms of the revenue collections, right? So, for example, 15% shortfall has happened in terms of the revenue collection with regard to the goods and services taxes after they have been imposed. So now this 15% shall be compensated back to the state which is facing a shortfall for the next 5 years from 2016. And that is the promise of what is known as the GST compensation cess. So along with the GST Amendment Act and the imposition of GST as a composition rule, the GST compensation cess was imposed upon luxury and sin goods out of which money would be taken. So for example, if you're buying a bottle of champagne, and if that bottle of champagne costs, let's say, 10,000 rupees, you may have to give a 10% GST compensation cess upon that bottle of champagne. And this pool of money, which is going to be collected by the government of India, the Union of India, will be used to compensate the states which are experiencing a kind of a shortfall in the GST collections. You see, this was the method and the formula which was invented by the state and the government to create a kind of a compensation regime out of the GST for the people or the states who are experiencing a shortfall, and thus you had the creation of the GST compensation cess class. I hope that you are understanding this point clearly. Take a look at this notification given in 2017. For 5 years after the enforcement of the GST regime, for 5 years, GST compensation cess would be collected, and from that fund, all those states who are experiencing a shortfall in GST, in indirect tax collections, their shortfalls will be compensated by the GST compensation cess. Please take a look at this notification of the GST Council class. Please take an understanding of this here. You see the point here? So the parliament had passed a special law known as the Goods and Services Tax Compensation to States Act 2017. Compensation for what? Shortfall. Shortfall faced due to the IGST, Interstate Trade and Commerce. The central government, on the recommendations of the GST Council, hereby notifies the rate of cess as specified in column 4 of the schedule appended to this notification shall be levied on the intrastate supplies of interstate supplies of such goods, the description of which is specified in the corresponding entry. Now these are what are known as the luxury and skin good. तो अगर आपने मतलब मान के चलिए कभी अपने जीवन में ये खरीदा है पिछले कुछ समय में, तो आपने उस पे इतना GST compensation cess दिया है. Just take a look at this. Pan masala, aerated waters, lemonade, unmanufactured tobacco without lime tube bearing a brand name, unmanufactured tobacco bearing a brand name, cigar and cherots, cigarillos, cigarettes containing tobacco other than filter cigarettes, right? Sin goods, all of these are, okay? Hookah or Godaku tobacco bearing a brand name, hookah, chillum, hookah, gadaku, etc., etc. Smoking mixtures for pipes and cigarettes, homogenized or reconstituted tobacco bearing a brand name, chewing tobacco, filter khani, snuff, jarda, right? All these items are basically covered under the GST compensation cess. Okay, what are known as the luxury and sin goods. Take a look at this. Motor vehicles for the transport of 10 or more persons, including the driver. Okay, so these are the products which were produced under the GST compensation cess, and the government created what is known as a GST compensation cess, where money had to be taken from the people of India and had to be given to the states as compensation. ठीक है, ये वाली बात समझ गए ना आप लोग? अब देखिए इसमें अगर थोड़ी सी न्यूज़ पढ़ते हैं, we just take a look at some amount of news on this activity. शुरुआत में ये सिर्फ 5 साल के लिए दे रखा था, but in 2022 this has been extended for a period of 5 more years. मतलब 5 साल के लिए केंद्र सरकार जीएसटी कॉम्पनसेशन सेस राज्य की सरकारों को और देगा. ठीक है, इसको पढ़िए एक बार. दिस इज अ न्यूज़. GST compensation cess levy extended till March 2026. The levy of cess was to end on June 30, but the GST Council chaired by Union Finance Minister Nirmala Sitharaman, comprising, क्योंकि देखिए 17, 18, 19, 20, 21, 22, you had a very clear understanding that by the end of 2022 this would end. So in 2022 a kind of a lease was given to extend the GST almost by 4 to 5 years. The government has extended the time for levy for GST cess by nearly 4 years till March 31. As per the GST services rules notified by the Finance Ministry, the levy of cess was to end on June 30th, but the GST Council chaired by the Union Finance Minister and comprising of state finance ministers decided to extend it till March 2026 to repay the loans taken in the last 2 fiscal years to make up for the shortfall in the revenue collection. After the 45 GST Council meeting in Lucknow in September last year, Mrs. Sitharaman had said that the regime of paying compensation to states for revenue shortfall resulting from subsuming their taxes such as VAT in the form of national tax GST will end in June 2022, right? However, the compensation cess levied on luxury and demerit goods will continue to be collected till March 2026 to repay the borrowings that were done in 2020-21 and 21-22 to compensate states for GST revenue loss. ठीक है, इसका थोड़ा सा हम एक अलग सिस्टम क्रिएट करेंगे. ये 2020-21 में हुआ था, just to be able to finish that part. But overall, this is basically what we understand if a question comes on the GST compensation cess, which is dealing with the concept of shortfall. ठीक है, right? Class, are we done? अब देखिए, let's bring it to the last point of this discussion. Consolidated Fund of India. Okay. GST compensation cess and the Consolidated Fund of India. ठीक है, अब इसको ध्यान से सुनिएगा थोड़ा इस लॉजिक को. Try to understand this logic very clearly. The government of India had promised the states that it is going to, let's say state like Karnataka, Tamil Nadu, which are high manufacturing states and who had to lose their tax collections because of the creation of the IGST. They agreed with the cooperative federalism, but they also said that please give them some buoyancy so that we can maintain our head above the water. And for that, the government of India said, no problem, we'll tax the people of India in a special manner and give that money directly to you. That is exactly what these people started getting as a promise from the government of India, right? Now, when the COVID crisis came, and already there was a kind of a slowdown in the economy before that, during the COVID crisis, the government of India saw that the consumption of the goods which are mentioned for GST compensation cess, okay, so for example the cigarette, tobacco, khani, gutka, all these products on which you have a kind of a compensation cess, all the consumption of these goods went down. खत्म हो गया एकदम से consumption, right? और क्योंकि consumption खत्म हो गया तो सरकार के पास GST compensation cess आना भी बंद हो गया, right? This in a way bunked because of the COVID-19 and the consumption having stalled. the government was also not in a position in which it was getting any more cess. Clear? This is the first thing that happens. The second thing that happens in correspondence with this is that all of a sudden, health being a state subject, the expenditure of the states on health started piling up heavily. States had to create a lot of, let's say, uh, you know, arrangements for meeting with COVID-19, arrangement of bed, arrangement of vaccines, arrangement of protocols, etc., etc. All of this burden came upon the states, and states consolidated fund was already under a stress. Okay. Now, when the states consolidated fund came more under stress because of the health expenditure that had to be made by the states, then the states turned to the government of India and started telling the government of India that you have not paid us our GST compensation cess for the last 2 years. Please give us the money so that we can help ourselves out. The government of India said, because of the COVID-19 crisis, GST compensation is not coming to us, and therefore we don't have the money to pay it to you. Okay, and there was some amount of delay also. The government of India had not paid some GST compensation cess back to the states. They were planning to, but suddenly the government of India sees the COVID-19 happening, and the tax is not getting collected only. So what is the, where is the question of paying it? Government of India tells the states that we don't have the tax collections because of COVID-19. The consumption has dunked down. You see the point? And in this particular scenario, the states, especially the high producing states, started crying foul against the government of India, saying that the government of India had promised us to pay our cess so that we would be able to keep ourselves buoyant, and only on that promise were we able to take a position in which we were agreeing to the GST, because we wanted our money to be able to take care of our performances, and slowly we understand that some amount of growth will be given to all country and everything would be better for us also in the long run. But at least in the meantime, while we will experience these shortfalls, please give us the compensation. And they agreed to it, and that is how we agreed to enter to the GST council. Right now, the state started getting a little angry at the government of India, and the states told the government of India that you have to pay our GST compensation cess. If you have not been able to collect the GST compensation cess, it is your responsibility to pay it out of your own pocket. The Union of India declined that we are not going to pay you GST compensation cess from our own pocket, because we have not collected it, therefore we are not able to pay for it. You have to manage your own resources. The best that we can do is we can give you some amount of loan. Matlab, you can take a loan from the Union of India, and the loan is of course payable back in interest. That loan you can take from the Union of India for the meantime, but we will not be in a position to give you a GST compensation cess when the account itself is empty, as no compensation is being paid by people because of the COVID-19 crisis. Now it is over here that the states and the unions start, in a way, departing, especially the South Indian states and the state like Bengal. They start very heavily departing from having a faith and trust on the concept of the GST, because they feel that the government of India has sabotaged them at a time when they needed this money the most. The money which was entitled and given to them according to the act was not passed on to them, and this government of India was saying that we don't have the money because we can't collect the tax. But the states say that it was your responsibility to anyhow give us that money, whether you collect a tax or whether you take a loan upon it. But now you're asking me to take a loan upon it. That is a violation of our trust, and trust was the basic edifice of the GST. And on the basis of this, a kind of a divide, a kind of a confrontation and divergence started happening between the union and the states. This was what marked the entire year 2021-22, when the states started claiming that the government of India has taken the GST council and the GST as an object to only encroach upon the tax structures of the state, but it is not helping the states at the time when the states are needing that money the most. Right? This became the issue between the government of India and the states. If you, for example, take a look at this, these kind of news items used to appear so heavily in those times. Take a look at a news like this. States to center clear GST compensation dues, including that of February March. Okay, take a look at this. With the overall consumption of various goods and services at low, this is during the COVID-19. States are staring at huge loss in the goods and services taxes collection. Accordingly, they have urged the center to release the balance of GST compensation at the earliest. Right, this is basically the time when this kind of a thing starts happening, and this is where certain chief ministers, for example, Mamta Banerjee and MK Stalin in Tamil Nadu, etc., etc., they started in a way saying that the states are not being treated fairly by the union government. 7 non-BJP ruled states seek GST loss compensation. 7 state ministers to meet to demand payment of dues, waiver of tax on pandemic-related goods, medicines, etc., etc. Opposition ruled states will press to the center to waive the taxes levied on COVID-19 relief material, including vaccines, and seek a speedy payout of their compensation dues as the Goods and Services Tax Council, chaired by the Union Finance Minister Nirmala Sitharaman, reconvenes after a 7-month break on Friday. Okay, so you take a look at this part. The money when the GST compensation cess also started falling short, and thus the problems between the government and the state starting rising higher and higher. Okay, and now we come to the real punch of it. Okay, now I'm going to deliver to you the last part of this. Okay, CAG report. Okay, take a look at this part. I'm going to highlight this report properly. This was a CAG report which was prepared in the year 2000, which was prepared for the year 2018 and 19. The CAG report prepared for the year 2018 and 19. And this CAG report was kept by the president before the parliament in 2021. Okay. And this is the report that I'm trying to, in a way, look at. Issues relating to accounting of cess and levies. Okay, let me explain this to you. Let's say this is the Consolidated Fund of India. This is the Consolidated Fund of India, right? Consolidated Fund of India में से let's say आपके पास पैसे पड़े हैं 80 रुपए, ठीक है? You have 80 rupees inside the Consolidated Fund of India. Now let's say, for example, your expenditure is 100 rupees and the money which is kept inside the Consolidated Fund of India is 80 rupees. Okay, so usually speaking, in the language of fiscal policy, if your expenditure is 100 and your money is 80, you will have 20 as a fiscal deficit, right? We are all aware of this. Clear? Okay. Now, let's say very simply, the higher the fiscal deficit, comma, the lower the economic performance and management. But this is a very simple sign that any country with a high fiscal deficit is seen with suspicion. Right? This is basically the kind of inference that you draw, that the higher the fiscal deficit, the lower the economic performance and management. Meaning, अगर आपका fiscal deficit बहुत ज़्यादा है, तो it eventually leads to a kind of a decline in investments. आपकी इकोनॉमी में लोग इन्वेस्ट नहीं करना चाहते ज़्यादातर, क्योंकि आपका फिस्कल डेफिसिट बहुत ज़्यादा है. फिर आपकी सरकार के ऊपर और आपके देश के ऊपर प्रश्न चिन्ह उठाया जाता है कि आप इकोनॉमिक मैनेजमेंट कर पा रहे हो कि नहीं कर पा रहे हो. जाहिर सी बात है ना कि अगर फिस्कल डेफिसिट ज़्यादा है उसका क्या मतलब है कि आपके खर्चे बहुत अधिक है, आपकी आमदनी है, ठीक है, यू हैव अ लॉट ऑफ एक्सपेंडिचर्स बट यू डोंट हैव द मीन्स टू मेक दोज एक्सपेंडिचर्स. And to be able to deal with fiscal deficit, you have to take all kinds of instruments, fiscal financings, deficit financings, you create a crowding out effect on the market, and all of these things happen, as you know from your economic classes. Now, one of the ways in which this situation becomes problematic is that the higher your fiscal deficit, the lesser people start rating your economy and the government's ability to manage the economy. We are all aware about this basic entire stuff, right? Now, when we take a look at this entire scenario, we are looking at a rising fiscal deficit and as a relation to this and a decline in investment. Agar, let's say for example, if you take a look at a trick which is used sometimes by the government to artificially display that their fiscal deficit is somewhat low, right? So that investments आते रहे और सरकार के ऊपर इकोनॉमिक मिसमैनेजमेंट का प्रश्न ना उठे. कल को आप सरकारी अफसर बन जाएंगे तो आप ये रिकमेंडेशन दे सकते हैं नेताओं को, उनको थोड़ी पता होगा, आपको पता होगा, आप बताएंगे उनको ये सब यहाँ पढ़ के. अगर आपका फिस्कल डेफिसिट बढ़ रहा है, उससे इन्वेस्टमेंट कम हो रहा है और उससे आपके सरकार के मैनेजमेंट की एबिलिटी पे प्रश्न चिन्ह उठ रहा है ना, तो आप क्या कर सकते हैं? जो यहाँ पर हुआ, सरकार ने क्या किया, 2018-19 में जो जीएसटी कॉम्पनसेशन सेस आया था, जो कि डेडिकेटेड टैक्स था, आपको स्टेट्स को देना था एक पर्टिकुलर चीज के लिए, उसको आपने कंसोलिडेटेड फंड ऑफ इंडिया में चढ़ा दिया. द जीएसटी कॉम्पनसेशन सेस, लेट्स से फॉर एग्जांपल द जीएसटी कॉम्पनसेशन सेस इज लेट्स से 10 rupees. What you did was you credited the GST compensation cess, मतलब 10 में से आपने 7 रुपए यहां डाल दिए और स्टेट्स के हाथ में सिर्फ आपने 3 रुपए दिए. सुनेगा ध्यान से बात को. 10 रुपए में से 7 रुपए आपने यहां डाल दिए और स्टेट्स के हाथ में आपने सिर्फ 3 रुपए दिए. तो what is your, let's say for example, if I take a look at from this angle, what is the money which is kept inside the consolidated fund of India now? What is the amount of money which is kept inside the consolidated fund of India now? 87 rupees. Are we correct? Yes, we are correct. Okay. And if you take a look at this, my fiscal deficit, which was standing at 100 minus 80, which was 20, has now come down to 13, which means I have been able to manage myself fiscally. I have managed my economy well. मतलब मैंने अपने फिस्कल डेफिसिट को कम कर लिया. यही तो रिपोर्ट कार्ड दिखाना होता है ना सरकारों को कि हमारी फिस्कल डेफिसिट कम है. इसका मतलब है कि हमारे रिसीट्स और एक्सपेंडिचर में कोई एसिमेट्री नहीं है ना. लेकिन उसमें क्या किया सरकार ने? दिस इज द ट्रिक दैट दे पुल्ड. दे टुक द जीएसटी कॉम्पनसेशन सेस, जहां पर उन्होंने बोला था हमको कि हम आपको देंगे पैसा, ठीक है, 2018-19 में सरकार ने जीएसटी कॉम्पनसेशन सेस से, जिसको कहते हैं कि शॉर्ट क्रेडिटिंग करना, 10 रुपए आया, 10 रुपए में से 3 रुपया ही स्टेट्स को दिया और 7 रुपया 10 में से चिपके से निकाल के कंसोलिडेटेड फंड ऑफ इंडिया में डाल दिया। उससे क्या हुआ कि कंसोलिडेटेड फंड ऑफ इंडिया में आपके पास 80 रुपए अगर आपकी पहले की रिसीट्स पड़ी हुई हैं और अगर आपने 7 रुपए की रिसीट्स ऐड कर दी तो अब आपका टोटल 87 हो गया। इफ यू हैव 80 रुपीज ऑफ रिसीट्स kept inside the consolidated fund of India and if you add 7 rupees to it, now your total becomes 87 rupees. You see the point? Now when you have the total of 87 rupees as receipts and your expenditure is 100, as opposed to the previous times, your fiscal deficit is going from 20 to 13, which is going to be a decline in the fiscal deficit, and this is basically going to indicate that you have been able to manage your economy well, and also investments would start coming in an economy which is managing its fiscal deficits well. सरकार ने पीछे से ये कर दिया, शॉर्ट क्रेडिटिंग। ठीक, अब 2018-19 में सरकार ने किया था, 2020 में कोविड आ गया तो जीएसटी कॉम्पनसेशन सेस में पैसा आना वैसे ही बंद हो गया और अब स्टेट्स सरकार के पास खड़े हुए थे सामने कि जो इतना सारा पुराना हमारा पैसा था उसको आप हमको क्यों नहीं दे रहे, वाई आर यू नॉट गिविंग द मनी टू अस। तो सरकार बोल रही थी कि नहीं, इतना इकट्ठा ही नहीं हुआ था, पैसा हमारे पास था नहीं, ये था वो था। सरकार ने लेकर स्टेट्स को एक तरह से हाँ या ना करके मना कर दिया कि अभी हमारे पास पैसा नहीं, अभी हम नहीं दे सकते। स्टेट्स कहते थे कि वी आर सिटिंग ऑन अ मेडिकल इमरजेंसी इन आवर स्टेट्स, वी नीड द मनी टू बी एबल टू टेक केयर ऑफ आवर सिचुएशंस, वी डोंट हैव दैट काइंड ऑफ रिसोर्सेज टू बी एबल टू डू दिस एनीवे। So the government of India said, if you want the money, you can take the money as a loan, but we don't have the money in the GST compensation cess, क्योंकि compensation cess इकट्ठा हो ही नहीं पा रहा है। ठीक है, ये सारी चीजें चलती रही। फिर 2018-19 में जो CAG ने रिपोर्ट बनाई थी, ठीक है, इसको थोड़ा देखिएगा आप, इसमें क्या लिखा हुआ है। It was in 2021 when the report got released. 2018-19 की CAG की रिपोर्ट सरकार ने रिलीज नहीं करी थी, सरकार ने वो रिपोर्ट रिलीज करी 2021 में। The government released that report only in 2021. And when it, what you can say, released that report, issues relating to accounting of cesses and levies. The union government collected this amount of money from 35 cesses and levies in 2018. Under the scheme of such cesses and levies are required to be first transferred to the designated reserve fund and utilized for the specific purposes intended by the parliament. It was observed that the scheme for social welfare surcharge on customs, against which 871 crore was collected during the year, did not envisage a dedicated fund. तो अब सरकार यहां पर क्या कर रहा था कि सरकार ने एक सेस बनाया। अब आप थोड़ा बात को ध्यान से सुनिएगा ना, इस बात को। सरकार ने अगर सेस बनाया तो सेस का अलग अकाउंट होना चाहिए, क्योंकि सेस को एक पर्टिकुलर पर्पस के लिए ही खर्च करना है, दैट वी आर अग्रीड अबाउट, राइट? If you're creating a GST compensation cess, you have to be able to make sure that the money is going to a different account than the Consolidated Fund of India, because in Consolidated Fund of India you keep all that money that is not designated कि कहां जाएगा, वो आप बाद में बैठ के डिजाइन करते हो कि कहां जाएगा। बट जब आप सेस लगाते हो तो पहले ही आप लोगों को बता देते हो कि पैसा कहां जाएगा, उन लोगों को भी जिनसे आप पैसा इकट्ठा कर रहे हो और उन लोगों को भी जिसको आप पैसा दे रहे हो। इन सब लोगों की रजामंदी से आप एक ऐसा टैक्स क्रिएट करते हो जो कि पहले ही निश्चित होता है कि कहां पर जाएगा। तो एजुकेशन सेस, मैं अगर एजुकेशन सेस दे रहा हूं नागरिक की तरह, तो मुझे पता है कि मेरा ये पैसा देना बनता है, क्योंकि मैं चाहता हूं कि भारत देश में एजुकेशन का उत्थान हो। if I am paying education cess as a citizen, it is necessary that this cess be given by me, because I want the concept of education to get a bit of a promotion in India, right? That's what basically I say as a clarity. Now compensation cess is being collected from the people, saying कि states को शांति करने के लिए हमको पैसा देना है, लेकिन यहां पर सरकार ने क्या किया, compensation cess has been taken by the government and credited in part to the Consolidated Fund of India. देखिएगा CAG की रिपोर्ट में बाहर निकल आई थी सारी चीजें, और जब ये CAG की रिपोर्ट आई तो स्टेट्स बिल्कुल पूरी तरह से पागल हो गए। उनको ये लग रहा था कि एक तो सरकार कॉम्पनसेशन सेस के नाम पे हमको कुछ पैसा दे नहीं रही है और कह रही है कि अभी कॉम्पनसेशन मतलब कंजम्पशन नहीं हो रहा, तो हम कहां से दें। सरकार इज नॉट स्टेपिंग इन द सिचुएशन एंड हेल्पिंग अस आउट, जो हमारा पैसा पहले का चला गया। दूसरा, 2018-19 में जितना भी कॉम्पनसेशन सेस इकट्ठा हुआ है उसका 70% तो सरकार ने हमको दिया ही नहीं है। देखिए ना, during the year GST compensation cess of 40,806 crore was short credited to the related reserve fund. You see what I mean? कि मतलब अगर compensation cess इकट्ठा हुआ है तो उसमें से 40,806 रुपए का compensation cess CFI में डाल दिया गया, वो सरकार ने स्टेट्स की तरफ बढ़ाया ही नहीं. इसको कहते हैं शॉर्ट क्रेडिटिंग. डू यू सी द पॉइंट? And the government has done it not only for one cess but for a number of cess, and that is exactly the reason why the government uses a lot of cess in a general sense of the word, because it allows the government to be able to take a look at this. Short transfer of GST compensation cess to GST compensation fund and reversal of expenditure on defense pension etc. ये सारा जो GST compensation cess का जो short transfer था या short credit था, वो CAG की रिपोर्ट ने निकाल के दिया था. ठीक है. So if I want to for example say that in 2001 the CAG report take a look at this. Center used GST compensation cells elsewhere, violated law. The CAG findings run contrary to Finance Minister Nirmala Sitharaman's submission in Parliament that states could not be compensated for revenue shortfall from the Consolidated Fund of India. There was no such provision in the law. The CAG has found that the Union government in the very first 2 years of the GST implementation wrongly retained 47,270 crore of GST compensation cess that was meant to be used specifically to compensate states for the loss of revenue. In its audit report, the government accounts, the CAG, flagged that the amount was to be credited to the non-lapsable GST compensation cess collection fund for the payment of to states for loss of revenue due to implementation of GST since 2017, but the government did not do so and thus violated the GST law. The GST compensation cess provides for levy of cess for the purposes of providing compensation for the states for loss of revenue arising due to implementation of GST for a period specified in the Act. As per the Act and the accounting procedure, the entire cess collected during the year is required to be credited on a non-lapsable fund, which shall form a part of the public account, etc., etc. You see the point? This is what is known as the concept of short crediting. So please be aware of this concept for the perspective of the prelims examination. What do we understand by the concept of short crediting? Because this term has been in use for a long time now in the current updates. What do we understand by the concept of short crediting? ठीक है. तो ये वाला जो एक फिस्कल फेडरलिज्म में या कोऑपरेटिव फेडरलिज्म में थोड़ा सा जो एक बहुत अच्छा खासा ग्लिच आ गया था स्टेट्स और गवर्नमेंट के बीच में, दैट वाज द इम्पोजिशन ऑफ द जीएसटी कॉम्पनसेशन सेस. डू वी अंडरस्टैंड इट क्लास? Okay, class. Chalo, let me take a few questions and then. Okay, so this is the final session. We won't have a second session after the break today. We are ending the part on polity for this time. You have economy starting from tomorrow. There are certain parts of the polity which are remaining, including the discussion of the question papers. So we are going to wound them up tomorrow, wound them up again once we are finished with the initial parts of economy and the other parts of current updates. Okay, so I have tried to cover almost 70% of the important current updates which have happened in the last 15 months in correspondence to their static portions. Okay, I am pretty confident myself that all the things that we have developed inside the classroom here this time will one way or the other find some kind of a relevance in the prelims examination. As I was discussing with you the other day, the simple formula or the instinct that the UPSC has demonstrated mostly with regard to the prelims examination is to find that golden formula about a topic which is coming in the current updates again and again, and also that topic has a rich historical or contextual background. Okay, sometimes a topic may be coming in the current updates very much, but it may not have too much of depth inside it as a concept itself. Sometimes a concept may have a lot of depth inside it, but it is not coming relevance in the current updates. The UPSC ignores these two extremes. What the UPSC actually wants to see is a topic which is coming in current updates and has a kind of a historical root to itself. It has a conceptual basis to itself. And those are the questions which are generally the ones which are most frequently asked by the UPSC in the prelims examination. And everything that I have chosen as a module to be delivered in the classroom here has dealt with that kind of an activity, where you have questions coming possibly this year from the electoral bonds, from the Maharashtra Legislative Assembly and the anti-defection activities, from the Finance Commission and the reports of the Finance Commission, from the landmark judgments of the Supreme Court and the amendments to the Constitution, and everything else that we have done over the days in terms of understanding these activities in a more protracted and a kind of a final way, right? I wish that you take a good attention to what we have discussed in the classroom, and I hope that you have taken good amount of running notes while we were discussing these events in the classroom, because I am pretty confident that if you've developed the concepts around these areas and if you've taken the factual inputs that we've taken in these classes, we have had some amount of understanding to be able to prepare ourselves for the prelims examination. You will see this literature running again and again and again in the run-up of the prelims examination in all your current affair magazines and your books and everything. Tried my best to explain to you these very complex subjects which takes classroom sessions of hours and hours in a very short kind of a crunched out timing. And I have a list of the topics that you have given me as a recommendation, and out of that list, of course, I'm going to make the final call on this. And we will resume. The polity part is over for now. We will not have a session after this. We are ending the session. We won't have a session post break today. We are ending the session today with this part of the GST Council and the fiscal federalism part, which I hope that you've understood now clearly. But we are going to resume the polity part again towards the end of your classes. You are going to start economy from tomorrow. And I have taken a list of some topics that you have given so graciously in the chat box. And also I invite you again, as many topics that you feel are going to be relevant according to you for the prelims paper, just give a list of them. I will consolidate all of these topics and create a final session for you towards the end of the classes, adjoining the current updates upon this part. Okay, I will be back to take the current updates on the international relations part. And when those parts are starting, I'll take a few points here and there, adding a lecture or two in the middle of the international relations current updates on the remaining 30% polity papers and questions which are going to do, right? So this is my interpretation, my personal vision of how the prelims paper may look this time. And I feel that if we have a fair understanding of these topics and these ideas, you would be better positioned to deal with the questions which are given inside those items which are asked in the prelims examination, right? So this is the end of our session over here. My task here is not done. I will resume. I wanted to crunch more and more, but sadly we are having a little bit of a schedule which has to go in a streamlined manner. But the points about the remainder parts of polity which I feel need to be done, I am going to resume them once the current updates on international relations, etc., start. So I'll come back in for the international relations current updates part, and within those lectures only I'll resume with a little bit of the polity part. Okay, I hope that you've received the annotations and you've taken good amount of notes, etc., in the classroom. In a section like this, it is not possible to give dictation and notes, etc., but I was hoping that while we are discussing all of these things very intensively inside the classroom, at the same time you were sitting and taking notes of these facts and concepts, so that you have some written material along with yourself to be able to substantiate for these ideas and these queries and these concepts, right? And in conclusion, I am going to forward a list of topics which I feel which I may not be able to cover in the classroom, but I feel that if you have time on your own and if you have reading material on your own, which I think can be relevant for the prelims examination, I will take up these materials and put them in a draft and forward them to you for your own reading sake. Maybe you will find all of these things relevant for the prelims examination, which I may not have had the time or flexibility to cover in the examination. However, if given more, proper broad based time, we would have covered them together, right? So I've tried my best to be able to modulate a crash course not in a traditional way in which it is just a kind of a revision of your concepts, but I'm very radically and aggressive dealing with the current updates over here, so that you have a very uh, clear possibility of using all of these material inside the examination. See, that's our focus. आपका एग्जाम निकलना चाहिए, और एग्जाम निकलता है उन चीज़ों को पढ़ के जो एग्जाम में आती है, right? And that's basically been the motivation. कुछ मैं आपको notes दूंगा, कुछ मैं आपको documents share करूंगा. इसके अलावा अभी पॉलिटी ख़त्म नहीं हुई है. मेरे पास बहुत सारे टॉपिक्स हैं जो मुझे करने हैं. अनफॉर्चुनेटली बहुत सारी चीज़ें हैं तो मैं प्रायोरिटी बेसिस पे करना चाह रहा हूँ, लेकिन सेम सेक्स मैरिज वाला इशू है, आर्टिकल 370 वाला इशू है, ये सारी चीज़ें हैं तो मैं ये ख़त्म नहीं कर रहा हूँ अभी. इंटरनेशनल रिलेशंस करने के लिए जब हम लोग वापस मिलेंगे, व्हेन वी आर गोइंग टू रिज्यूम द क्लासेस ऑन इंटरनेशनल रिलेशंस, देन वी आर गोइंग टू टेक अ recalibrated look at a few topics: homosexuality and same-sex marriages, rights of fetuses, Article 370, which is the Supreme Court judgment, Supreme Court's judgment on demonetization, Supreme Court's judgment which is reserved right now but may come out anytime sooner on the minority status of the illegal Muslim university. और इसके अलावा भी कुछ चीज़ें हैं जो मुझे लगता है इंपॉर्टेंट है. आप लोगों ने भी काफ़ी चीज़ें सजेस्ट करी हैं, women's reservation bill and all of these things I will try to in a way consolidate in the last few lectures that we round them up again when we are discussing the subject of international relations. ठीक है क्लास? तो मेरे पास जितने डॉक्यूमेंट्स इसके निकल के आ जाएंगे, आई एम गोइंग टू फॉरवर्ड इट टू यू. आई एम गोइंग टू फॉरवर्ड द लिस्ट ऑफ टॉपिक्स that are I feel are relevant, right? In addition to that, if you want to get in touch with me for any doubts or queries which I am not able to take in the classroom for the paucity of time, you can reach out to me on this number. Please leave a message and please mention specifically that you are from the crash course, okay, so that I get a sense that you have been a part of this group which has been taking these lectures. So please mention that you are from the crash course or the destinary thing. Any doubts, any questions, any requests or demands, I may be able to take it out now more personally with you. Okay, so thank you for your time and patience. Thank you for your motivation. Thank you for your engaging these subjects, and I hope that all of this that we study in the classroom is a direct or indirect question in the prelims examination. क्योंकि point है कि जो हम यहाँ पर पढ़ रहे हैं वो एग्जाम में आना चाहिए, directly or indirectly, factually or conceptually. This has to be relevant in the exam, and the idea is to read the instinct of the UPSC, and to some extent I've tried to mimic the instinct of the UPSC while it is preparing the papers, right? I hope that we find all of this relevant while you're preparing for this exam this time. Thank you so much for your time and patience. I'll be in touch and I'll be back to deal with the other parts very soon. All the best with your remaining classes. Focus on the economy classes and the remaining ones of them. I'll see you tomorrow. Not tomorrow, actually. I'll see you at the end of the sessions now. Thank you for your time and patience, class.